following our discussion at the last hearing session. I then want to, we can have a session on the section 106, and you can update me on that. And then we will hear closing submissions. Just housekeeping reminders, please, since we're back online. Can you please make sure that your mobile phones are switched off or to silent? And please, if you need to make a point, please then use the hand raise function. Can I just take the names of those people who are present in this session, please? And I'll start with the council.
So good morning, Emmeline Lambert, Council. Also with me today, Antonia James, who will be leading for the council on the condition session. And we should also be joined shortly by Russell Fitzpatrick to assist you, sir, with any questions about the section 106, who is solicitor at the council.
Thank you. Thank you. And for the appellant, please.
Hello, sir. My name is Gregory Jones, Queen's Counsel, instructed by Provision. Catherine Miles is with us, I hope, and can take a lead as well on conditions.
Thank you. And for Rule 6, please.
Good morning, sir. Naomi Bird, counsel instructed by the Rule 6 party, Friends of Sandown Park. And here this morning are Ted Hood, lead representative of FOSP, and also Stephanie McMahon.
Thank you very much. Before we start, are there any matters that the advocates wish to bring to my attention?
Sir, I have one. Miss Miles is asking to be let in to the, if the council could let her in, we'd be most grateful.
Thank you.
Thank you.
Okay, there's nobody waiting. Okay, there is somebody waiting. She's about to be let in. I can see she's. We think she's now in. Maybe Miss Miles could confirm if she's in, if she's here.
Yes, I'm here.
Thank you. Good morning, Miss Miles.
Morning. Apologies for some issues being let into the meeting.
Not a problem at all. Thank you. Are there any other matters that the advocates wish to raise?
So there's one matter from me. At 10:30 last night, some appeal decisions were sent through to the council on behalf of Mr. Jones. I got them this morning. It seems he's going to refer to them in his closing submissions. I haven't had an opportunity to read them. My closing submissions are based on the evidence and the appeal decisions and the authorities that have been before this inquiry from the beginning. And there seems to me to be no good excuse for them arriving so late. They are all dated from before evidence was submitted to this inquiry. And so on that basis, I'm objecting to their admission. I haven't even read them.
Thank you. I'm not aware that this is news to me.
So can I think there are 3 appeal decisions. 2 I'm quite relaxed about. Well, I'm relaxed about all of them in a way. 2 are, you'll recall that Miss Lambert put in cross-examination, I don't know if she's going to pursue the point, that she had never come across the phrase appropriate weight being given to policy or material considerations. So that I mean, she was giving evidence, I suppose, but if that is to be pursued, it's wrong. And there's a couple of appeal decisions where inspectors have that I've just found that have used it. I don't think it's a bit of a. I don't think it's a big issue, but I don't know what Miss Lambert's going to say. So if she's, I mean, she didn't put any evidence in. She gave evidence. If she's going to pursue the point, then I'm entitled to put it in, because she didn't put any evidence in, any of her witnesses, as to the use of the phrase appropriate weight. But I don't think this is going to be a major issue in the determination of this appeal.
Thank you. Miss Lambert?
Covered in Miss James's rebuttal proof of evidence, putting in appeal decisions to deal with a matter that is in relation to a test is not the way to deal with whether the test is correct or not. It's either correct as a matter of law or it's not correct as a matter of law. I asked Miss Miles where there was any evidence of appropriate weight, and nothing came back. We've had 2 weeks almost since we last sat. Why did these come in at 10:30 last night? It's the second time that documents have been put in too late by the appellant. The ID5 came in late as well, and we had to have an adjournment. I do not want an adjournment today on this. It doesn't seem to me that it is a big point, but I cannot understand why these documents have come in so late.
I understand that, Miss Lambert, and I've not even been aware that these had come in until just now. We have had 2 weeks, and this closing session was only put today really because of availability. It wasn't for any particularly outstanding matters. We have used the time to deal with conditions in section 106, but
so
I'm not thinking that we need to accept more evidence.
So I'll deal with it in submission. If this is Ms. Lambert's best point, I don't think it really goes in it. And in my closing, which I've written, we can delete it. It's in a footnote, so you can just, when you get it, it's a footnote. It's just, if anything's made of it, it was put by my learned friend in cross-examination. You'll know that she, my learned friend, had not come across this in any of her planning appeals. Now, strictly speaking, that's not right. I didn't object to it, but I'm fairly relaxed about it. So they're more important issues, and you haven't got it. But I'll just, when I come to in closing, if I haven't deleted, I'll deal with it just by submission.
Thank you, Mr. Jones. Thank you. Are there any other matters that the advocates wish to bring to my attention?
Not from us, thank you, sir.
Thank you. Can we then turn to conditions? And I have seen I've seen an email yesterday from Miss Miles to say that there'd been progress and the conditions had been agreed between the parties. Can someone just update me on where we are now compared to where we were when we adjourned in Town Hall, and in particular the change that has occurred between the draft list and the now suggested list? I see that I think there's 4 more conditions, and they may be as a result of my comments, but I think there's at least 1 that is additional that might relate to the track. And I know that we had a discussion, didn't we, about this issue about companion, and I think there's a form of wording in there now which the parties seem to be in agreement with. But can someone please take me through the conditions? Don't need to go through them, ones that we've already thrashed out, as it were, before, but I need to know what the changes are and what they now say. I don't mind who takes me through, but it's a roundtable discussion.
Okay. Well, if I start, sir, and then perhaps if Antonia and Naomi could chip in as we get to the appropriate bits. But so the document that you've got is agreed between the 3 parties. The main difference in the structure is that we've reordered it to address your comment about the sort of order of the conditions. So the general conditions start first, and then there's the pre-commencement and so on. I did think this morning that actually the last condition is probably out of order, condition 46, the track, because it sits at the very end. It's the last one we agreed, and probably we should have put that into the structure. But so apologies that hasn't happened, sir. But so then the other changes, we deleted the words unless otherwise agreed from the conditions which you asked for, so that's been done throughout. And then on condition 6, so the change is the removal of the word companion and the insertion of the phrase cohabiting partner or such other person as the Borough Council may in its sole discretion otherwise agree in writing. And that's consistent with the section 106, which hopefully will be sealed and issued to you during this inquiry before we close. And then the other conditions are additional tree conditions. And I will just get those numbers for you, but condition 24 in particular is one. And this deals with the ancient woodland and the requirement in part F of that condition for the buffer of at least 15 metres. And that condition, the wording of that has been taken from the Sandalford appeal in West Berkshire, which was determined in May and is within the core documents. There's an additional BAT condition, so BAT survey condition, that's 25. So that requires a BAT survey for trees T4 and T5 to be undertaken before any development is commenced on site. And if there's any necessary mitigation as a result, for that to be submitted and agreed with the council. And then there is condition 46, which relates to the track. So previously we had two conditions. Essentially, they've been amalgamated into one. The wording's changed. But what this condition does is that in the event that the public right-of-way map modification order is made, then details of how the track can be accommodated by the estate road and the construction of the access from Sandown Park need to be provided, along with details of any surfacing changes to the right of way to the track itself, and that would be surfacing materials and finish levels, and that must be submitted and approved by the council prior to the commencement of development. If the map modification order has not been made before the development commences, in any event, the details that are required in points 1 and 2 of the condition must be submitted. And the condition also requires that the appellant and their agents or their successors in title must not take any measures to obstruct, limit or prevent access along the whole of the track, which we've agreed to. I think that covers it. If Naomi or Antonia have any other points?
No, thank you. Just to confirm, it has been agreed with the local planning authority, and Catherine has covered all the changes. Thank you.
Thank you, Ms. James. Thank you. Ms. Bird?
Nothing to add from our side. Thank you, sir.
Thank you. Well, I'm grateful to the parties for their work on collaborating on dealing with those conditions, because I was a bit concerned when we left Town Hall 2 weeks ago that whether that would happen, but thank you very much. Can I just check then on condition 6, which is there was the outstanding issue of companion, and you've used a form of wording which seems now to be to everyone's agreement. That condition now is that inconsistent with the wording in section 106?
That's consistent.
It is consistent.
Yes.
Is-
I
Is
don't know.
section 106 that I've not seen yet, or is
Am I don't know if I'm
You're-
sure.
Yes, you are.
Okay, sorry. Apologies. Yes, the deed has completed. We're just busy scanning it in now, and you will have it in the next 10, 15 minutes, if that.
right? So but the condition 6 is has the provision within the section 106 that deals with this matter, has that wording changed from the version of the section 106 which was before me 2 weeks ago?
Yes, it has.
So I've not yet seen. So what I've not yet seen is a version of section 106 with this wording in. That's correct.
That's
isn't
correct,
it?
sir. That's correct, sir. Yeah.
Right.
So
So
as I say to you, it does maintain keep the same wording as the condition.
okay.
There are other obviously restrictions around that, but it is not inconsistent with the condition.
Okay. Right. Are there any other change? We will come on to talk about section 106. Are there any other changes to section 106 other than this condition, other than this provision from that which
No,
I've seen before?
No, the paragraph 2.1 of the deed that you have seen is the only change that has been totally substituted, and there are 2 associated definitions that are in the interpretation provisions to Schedule 4, that being a definition of cohabiting and a definition of partner.
Okay. Right, we'll come on to section 106 in a moment. So the condition on trees, so it's condition 24.
How do I mute?
I think it's condition 24 you mentioned, Miss Miles. Is that
Yes,
it was
it was.
part F, wasn't it?
Part F specifically, the whole condition is new, but part F specifically dealt with the ancient woodland buffer of at least 15 metres.
Okay. So just tell me why is there a need for a new condition compared to where we were before?
It's probably best for Antonia to answer that question, because these conditions were put to us after the roundtable session on trees.
Okay. If you could just explain, Miss James, then that would be helpful.
Thank you, sir. So we considered that a condition was necessary. We've looked at the Sandalford appeal, which was submitted by the appellant. As we set out at the roundtable discussions, it would not be possible to implement the scheme that's shown on the illustrative plans with this condition. This condition has now been agreed with the appellant, and it requires a detailed assessment, which is something that our tree officer had been seeking, from the outset, to ensure that the appropriate buffers, which would be at least 15 metres, can be provided on site, and that those buffers are in place before development commences, and that no construction work can take place within those buffer zones, and that also afterwards those buffer zones are protected in perpetuity with something such as a post and rail fence, or another type of low-key type fence with stock wire, for example, just to protect the sort of the buffer zone in perpetuity. Thank you.
Thank you. So I know we had a detailed discussion on this matter in the trees roundtable session, but and we talked about a condition. So is this that condition?
That's correct. Yes, sir.
So does this? So where is the council now? Does this obviate the council's concern about ancient woodland?
That's correct, sir. but our concerns still remain in respect to trees T4 and T5. So there is still a tree ground for refusal, but we consider that this condition would address concerns regarding ancient woodland. Thank you.
Thank you. And is that a matter that will be picked up in closing, Ms. Lambert?
Yes, sir, it will be confirmed in closing.
Thank you. So in relation to T4 and T5, there's a new condition relating to bats, and just explain why there's a need for a condition in relation to those two trees.
So this condition has come about as in response to the ecological surveys that have been carried out by the appellant and submitted with the planning application. And they did raise an issue that those trees had potential for bats. And if, for example, there are if the development is to go ahead, I think they recommended, I haven't got the details right in front of me at the moment, I'm just going from memory, that they recommended that additional survey work was carried out because they have got, for example, cracks, etc. in those, which can make them potential bat habitat. So it's really to ensure that those are, the issue of bats is fully covered as part of, if a consent comes forward and they're covered by condition.
Thank you. Thank you. The condition 46 in relation to the track seems to be fairly clear to me. Is there anything that any of the parties wish to raise? Ms. Miles has introduced it, but is there anything that any of the parties wish to say in relation to that condition?
So I can just confirm that it was a condition that was actually put to us from the Rule 6 party, which had some very minor tweaks and has been agreed with the appellant. Thank you.
Okay.
So we have nothing to add unless you have any particular questions about it.
No, thank you, Ms. Bird. I don't have any questions. It seems very self-explanatory in terms of condition to me. Reads fine. So from what I can see at the moment, so that's okay. It is a condition that relates to the site, but it's not within. Is it within the control of the appellant to undertake those works, or does it require additional consent to undertake those works?
So it's outside of land that we own. The track is not owned, but the appellant has the right to a right of access and a right to repair and surface the track. So yes, we have the ability to carry out the works as the condition requires without any further consent.
So as far as the local authority is concerned, it's enforceable?
Yes, sir.
Okay. Thank you. Just one moment. Just on condition 6, the words cohabiting partner, are they words that are commonly used in these sorts of conditions?
In our experience, no, sir, but we're agreeable to the term.
Okay.
So if I may just come in there, one of the agreements that was put forward as part of the appellant's case does refer to a cohabiting partner. So it has been used in another agreement.
Okay.
We've just sought to define that.
Okay, thank you.
And sorry if I just may add, the term that we're using is more of a dictionary definition of cohabiting partner.
Okay, and that's defined in the section 106.
Yes, it is, sir. Do you want me to give it to you at all?
Yes, please. Yes.
Yeah, we've defined it as means to live together as a couple without being married, or where their relationship is such that they each have assumed an obligation to financially support and provide for one another, and cohabit shall be construed accordingly.
Okay, thank you.
That is also there's also a law society definition of cohabitation, which they use for cohabiting agreements, which we've also adapted that, but taken out a period of time that is referred to within that.
Okay, thank you. Thank you very much. Just one final question, and I've not compared, like I've not been through all the conditions compared to the previous version, but there was a duplication, wasn't there, in the early version that presumably is now picked up. The two
Yes,
numbers the same.
that's been removed. Yes, and we've
Thank you.
and the numbering should be consistent.
Okay, thank you. Okay, thank you very much. I don't have any further questions on conditions. Thank you. I want to turn to section 106, but I can't do that until I see the version of the section 106 that is the final agreed version. Has that been sent to PINS?
Can you just tell me we're sending it? I'm just sending it now. I've just received. Oh, sorry. Sorry, sir. I haven't done a virtual inquiry before, so please
It's okay.
excuse
It's fine, Mr.
my
Fitzpatrick.
I've just received the document now. I'm busy sending it to the planning officer, to Antonia, and she'll send it across the PINS
Okay.
and to the appellants.
Okay. Well, we'll take a 10-minute adjournment.
Okay. Thank you, sir.
And we'll resume at 10:10. Thank you.
Thank you.
We're going to resume, except I've not yet got it. Has it been sent, Mr. Fitzpatrick?
It was sent about 5 minutes ago to Leanne Palmer and Catherine Miles.
Okay.
Thank you.
I've got Leanne and other people have got access to that. Right. I've just been told it will be sent to me. Just for a moment. Okay, I've got it now. Thank you. Okay, I've just got it, and so who's going to take me through it? Is it Mr. Fitzpatrick?
Yes, sir. Where would you like me to?
Let me just have a look.
Oh, camera.
Just
sorry.
take me to. Just take me to the changes that you were talking about earlier when we're dealing with conditions of that. Thank you.
Yes, sir. The principal schedule is Schedule 4, which says C2 units.
So Schedule 4.
Yeah, that's page 27, bottom right-hand side of the page.
All right.
Yeah, and so are you just wanting me to take you through the changes that have been made from the one that was previously sent?
For now, yes, please.
Okay,
Yeah.
right. As I said, on page 27, we've inserted a definition of the word cohabiting. On
Okay.
page 29, we have inserted the word partner as any spouse or civil law or cohabiting partner of the primary residence in occupation of the C2 unit. And then paragraph 2 on page 31.
Okay.
Has been substituted in its entirety, and that was done in conjunction with condition 6.
So condition 2 that deals with occupation.
Yes, that's right. Because the principal issue that was in dispute between the parties was who could occupy the development.
Okay, thank you. Okay, thank you. Are there any other points that you wish to bring to my attention on the section 106, Mr. Fitzpatrick?
No, sir. I think, as I said, the only issue that was outstanding or between the two parties was whether or not a companion should be a party to the or should be included within the deed. I think the appellant, if I'm not mistaken, was alleging that the word cohabiting, and they were interpreting the word cohabiting as meaning companion as well. I think the word companion is far broader in its meaning, than a cohabiting partner. But what we have done is we have built in some flexibility into the agreement and into the condition, which would allow the council to approve in its discretion a person who is not a cohabiting partner, a civil law partner, or a spouse. So there is some flexibility built into the deed for that.
Okay, thank you.
That's how I think we overcame that.
Okay, thank you. Does the appellant wish to make any comment in addition to what Mr. Fitzpatrick has told me?
No, sir, the deed is agreed and has been signed and sealed. We're happy with it.
Thank you. Okay, thank you. I don't have any further questions on the 106 now. Thank you. Okay, thank you very much. So, can we now turn to closings? Ms. Lambert?
Thank you, sir. Miss James is just sending my closing to Leanne Palmer, and I've just sent it to my opponent and to Miss Bird.
Okay. If I'm not sure Leanne is picking up.
Who can I send it to?
You can send
or
to,
Miss James. Who can Miss James send it to?
If you send it to Leanne, but also send copy to Helen Skinner, who I know Helen has just sent me this
Okay.
via Leanne's inbox. So if you helen.skinner at planninginspectorate.gov.uk, Helen is picking up the inbox, so she should pick that up straight away. And once I have it, then we can commence. Shall we just take a couple of minutes to wait till that gets to me, Miss Lambert?
That yes,
it
it has gone to Miss. It has
gone
gone to Helen Skinner as well.
Okay, right. Let me wait then. Just 1 moment. I've not got it yet. Are the other parties' closings on the way as well?
Yes, sir.
Have they been sent or yet to be sent?
Just been sent to Leanne Palmer and Helen Skinner.
So mine hasn't been sent. I'm going to try, if I can, also just to, if I need to respond to any of the closings, because I go last.
Yeah.
But I have a draft, obviously.
Okay.
Thank you.
I'm just going to adjourn for a couple of minutes whilst I get that. If you like to stay on, but you don't need to have your cameras on, I'll come back in once I've got it. But we'll just pause slightly whilst I wait for that. Thank you. Thank you very much. I've now got council's closings and Rule 6 closings have just come through as well. So thank you. Ms. Lambert, when you're ready, thank you.
Thank you, sir. Before turning to the main issues, some preliminary points in relation to the development plan, material considerations and the lawful approach for the decision maker are addressed. And I start with the statutory development plan and the weight to policies. The NPPF is only guidance. The presumption in favour of the development plan still exists. It is accepted that there is no 5-year housing land supply, and therefore the most important policies for determining the appeal are out of date. However, there is still the question of weight and an exercise to be undertaken under Para 219. That is because there is no such thing as an out-of-date development plan, and the starting point by virtue of Section 38(6) of the Planning and Compulsory Purchase Act is the development plan. The proper interpretation of planning policy is ultimately a matter of law for the court. Policy statements should be interpreted objectively in accordance with the language used, read in its proper context. It is submitted that the test under Para 219 is not whether every single word between the policies is the same. If it was, then there would be no point having local policies relevant to local areas. There is no test in law that exists, as put forward by Ms. Miles, requiring an assessment of whether the policy is appropriate or relevant to the planning application. There would be no need for an analysis of any weight to an irrelevant policy. There is also no test in law based on the age of the policy. There had plainly been no application of the correct test prior to cross-examination. The appellant's approach of giving appropriate weight to policies is flawed. Weight to policies should be understood when undertaking the planning balance. And so at my Appendix 2, I have analysed Ms. Miles's assessment of weight to policies, and I don't read that out. Overall, the careful analysis of weight to policies undertaken by Ms. James at Para 609 to 643 of her proof is commended to the inquiry. In short, the strategy of the development plan is consistent with the NPPF. Moreover, despite the out-of-date requirement, given that the council currently has a 4.66-year supply based on its current development plan, and there is no evidence that it is granting significant planning permissions contrary to the development plan, the strategy is not restricting housing to any significant effect. The basket of policies is not out of date if this element of paragraph 11 needs to be considered, as found by Inspector Rose. Any development plan conflict should be accorded weight. The emerging submission local plan. The council has committed significant resources into its local plan, and it has made substantial progress with several important stages completed. It is currently at examination and has proceeded to stage 2. In a constrained borough, it should be commended for the significant effort that has been required to find the level of land it has that will provide the supply it needs in full. Recent appeal decisions have shown support for the council's approach on allocations. The Highgate Hill appeal was in relation to a site proposed to be allocated within the submission local plan and recommended for approval by officers and allowed at appeal. Gate Farm was not a proposed allocation and the appeal was dismissed. Hawkhurst Golf Club was not a proposed allocation and the appeal was dismissed. Ms. Miles failed to assess the SLP policies in accordance with the test in Para 48. There was no analysis regarding the extent of unresolved objections to relevant policies, and she did not assess the degree of consistency of the relevant policies to the NPPF. Para 48B and C are relevant to individual policies and not the plan as a whole, as Ms. Miles agreed. There is nothing in her proof of evidence demonstrating an assessment of weight to each relevant policy. Again, Ms. James's full and careful analysis in her proof of evidence is to be preferred. Whilst the emerging plan policies do not carry full weight, they demonstrate the direction of travel, and given that they have been consulted upon and received full council support and are at an advanced stage in the examination process, it is submitted there should be confidence in them. As to material considerations, Ms. Miles agreed that statutory duties under the Listed Buildings Act 1990, the Countryside and Rights of Way Act apply. All statutory duties should be accorded considerable importance and weight in the balance. Other material considerations, the following are also highly relevant: the NPPF, the Tunbridge Wells Borough Council Landscape Sensitivity Assessments, the Tunbridge Wells Borough Landscape Character Assessment, the AONB Management Plan, and relevant previous appeal decisions capable of being a material consideration. Turning to the Council's 5-year housing land supply, the Council accepts that it cannot demonstrate a 5-year supply of housing land, and it is agreed between the main parties to stand at 4.66 years currently. However, the effect of such a shortfall is not agreed. From a number of authorities, and as agreed by Ms Miles, if one of the objectives of the NPPF is to boost the supply of housing, then it is relevant that the decision maker should consider the scale of any shortfall, here only 0.33 years, and the steps being taken to address it. The inquiry has heard about the progress of the local plan, and the initiatives of the Council to proactively boost housing delivery are set out in Mr Ireland's proof. He concludes that these are extensive actions and notes not least the progress which is being made to putting in place a new local plan, which will of course ensure a 5-year housing land supply on adoption. This is all positive action and can be taken into account in assessing weight to policies in light of the lack of a 5-year housing land supply. The Council is doing everything it can at its end to improve housing supply in this constrained borough and should be commended. As to specialist housing need, Mr Ireland is an extremely experienced expert, and his involvement inter alia in assisting over 50 local authorities with adopted local plans leads to a highly impressive CV. Furthermore, Mr Ireland is completely independent of the Council's decision to refuse planning permission for this scheme. There are 3 areas of dispute in assessing need between Mr Ireland and Mrs Venables: population projection, prevalence rate to be applied to the population projection, and the supply position. On population projections, there is no equivalent standard method for assessing extra care need as there is for assessing housing need. There is also no single recognised methodology for identifying need for extra care, as there are a number of online toolkits which are recommended. Most models, as is evident from the Carterwood Planning Needs Assessment, apply rates to the population aged over 75, as does the model used by both Mrs Venables and Mr Ireland. As the inspector in the home-based Walton-on-Thames decision letter said, whatever model is used, its output will be determined by the assumptions on which it relies, and each analytical toolkit is only as good as the built-in assumptions. There is no standard one-size-fits-all guidance for the assumptions either. The PPG is not specific as to what projections should be used for demographic assumptions, despite the use of 2014-based projections in the standard method. However, it is worth noting that whilst the PPG references that the proportion of older people over 85 in the population is increasing and projects a doubling by mid-2041, this is why demographic projections are part of the assumptions for this modelling. Repeating that there is growth in this age group is not a separate point or a reason to adjust modelling outputs. Both Mr Ireland and Mrs Venables used the 2018 projections as these are the most recent. There is no difference between them as Mrs Venables accepted on this point. It is with regard to the prevalence rate that the difference between the Council and Mrs Venables is evident. Again, there is no guidance on this and there is no one size fits all. The publication More Choice, Greater Voice states that determining levels of provision is entirely a matter for local determination. There is a range of reasonable prevalence rates that could be used. You, sir, need not be distracted by the appellant's references to the local plan on this point. Mr Ireland explained that the SLP had focused on a narrow definition of extra care housing, but that using a wider definition to include enhanced sheltered and extra care housing together across tenure, a 45% prevalence rate was appropriate, and the evidence he gave to this inquiry was consistent with the evidence he gave during an examination of the local plan. In the home-based decision, an appeal in which Mrs Venables gave evidence, a prevalence rate of 45 per thousand on a cross-tenure basis was accepted by the inspector. In the Edenbridge Golf Club decision letter, similarly, a rate of 45 per thousand was used. We also have a further assessment prepared by a third party, healthcare property consultants, submitted with this application, which used the same rate. In other decision letters to which the appellant has drawn attention, it is worth noting that there was no specialist witness or need in Haverhill Road, and the evidence of Mrs Venables was unchallenged in Beechmore. There is also a dispute between Mr Ireland and Mrs Venables in relation to the age group 65 to 74. If these figures would make such a difference to the appropriate prevalence rate, as advocated by Mrs Venables, then her model should test this and include this. Or if Mrs Venables is going to provide evidence that 20% of residents are in that cohort, then an equivalent prevalence rate for that cohort should be properly determined. It is wholly unsatisfactory to inflate demographic assumptions when there is no modelling available to do so, and to expect inspectors to guess increases over and above modelling scenarios. In the home-based decision letter, the inspector was unable to place a figure for this cohort, noted that there was an upward trend, but still used a prevalence rate of 45 per thousand. Mrs. Venables told the inquiry that extra care housing had been around for 15 to 20 years. Her written evidence describes it as an immature market. She told the inquiry it is becoming more familiar, but many older people don't know that it exists. On catchment areas, there is no standard catchment area. Whilst Carterwood have done analysis on this, there is still a range even on that analysis, and there was no good reason for Mrs. Venables' catchment area to include Tunbridge, which has its own facilities, services, train station, and is in a completely different local planning authority area. Indeed, Mrs. Venables was not sure that Tunbridge had been included and had to double check. She had not recently undertaken a drive from Tunbridge Wells to Tunbridge to properly inform herself as to the practicalities of that being a realistic catchment area. In the Walton-on-Thames decision letter, it was said that a local planning authority area was more appropriate. Locally, the current provision is 16 per thousand. The plan period has 16 years remaining to 2038. An increase in the prevalence rate to 45 per thousand will be an increase of 2.8 times in addition to demographic growth. Demographic growth assumptions already take into account the points from the PPG about how growth in the age group is going to increase. So an increase to 45 per thousand over and above the demographic growth is a significant uplift on the current provision. On the basis that this is an immature market, only just starting to become familiar, an increase to 65 per thousand, as Mrs. Venables proposes, is an increase of 4 times in addition to accommodating demographic growth, and is simply out of step with reality. Her response that in Kent it is familiar because there has been affordable extra care is also out of step with reality because the markets do not cross over. Elderly people selling up properties do not investigate what is happening in the affordable housing, care housing sector. Mr. Ireland's approach is reasonable given demographic growth, given the better than average health profile in Tunbridge Wells, and given that his assumptions are within the reasonable range. His analysis of need is commended. Turning to supply, and firstly, the strategic sites. As Mr. Ireland stated, the area for assessing need and supply should be the same. There was some confusion at the inquiry as to who was giving supply evidence. The proof of evidence of Mrs. Venables covered supply in detail, but she was not content to be questioned on this evidence, which undermines her analysis of overall need, for example, with regard to appropriate prevalence rate, given that she appeared not really to understand supply. She did agree that from PPG, it is up to the local planning authority to decide whether to allocate sites and that there is no policy requirement to do so. She had not understood the submission local plan policies on extra care housing allocations at all, which are specific, and rendered her table 6 wrong. Both strategic site policies, as set out at paragraph 36 of these closings, show that 1 extra care housing scheme shall be provided in each strategic site. There was also an update on the deliverability of extra care housing on these sites provided by Mr. Ireland, following meetings that council officers had had with developers only the day before the second week that this inquiry commenced. Mr. Ireland explained that in response to the appellant's points about the soundness of the plan, and as a result of the lack of specific numbers in the strategic policies, discussions between promoters and the council had been taking place, and there had been meetings so far with Persimmon for land east of Paddock Wood and with Hadlow Estates with regard to Tudley. He confirmed that he was told by policy officers that Persimmon had agreed in principle to look at extra care housing within its development scheme. He said it was important to note that the land east of Paddock Wood is outside the green belt, and they are actively looking for an extra care provider. They are delaying submission of the planning application, which is now expected in September, and this is specifically so that they can include extra care provision within the local centre as part of the second phase of that development, which would be expected in 2027-28 in accordance with the trajectory. That is just one parcel. Mr. Ireland explained that there are further parcels and that there could be further similar schemes. He has assumed in his evidence that 150 units of extra care housing would be delivered overall on this allocation and phased partly 26 to 32 and partly 32 to 38. That is entirely reasonable. He also reported to you, sir, the outcome of the meetings with the Hadlow Estate. They are intending to act as master developer. There is an expectation of a planning application on adoption of the local plan in 2023. It is expected that extra care housing can be brought forward as part of a neighbourhood centre with delivery in the period to 2032. His estimations for the strategic sites are conservative overall and phased appropriately. In cross-examination, Ms Miles confirmed that she had made contact with developers following the evidence of Mr Ireland. She was asked if they had replied. She said that Persimmon had. She was asked if she was told anything different to that which Mr Ireland reported. She said she had not. That information was not volunteered to the inquiry by Ms Miles. But sir, you can safely conclude that those meetings have taken place, that developers are open to strategic policies being more focused if the examination inspector requires, and that extra care housing will come forward within the planned period on those strategic sites. Other allocated sites. The very late evidence put in during the second week of the inquiry written by Ms Miles sought to undermine the council's approach to major development in the AONB. Ms Miles was preoccupied with an earlier decision relating to the Woodsgate Corner site, in which the council refused permission as it had concluded it was major development in the AONB at the time. Things change, methods change. The council has a new approach, and as Mr Ireland recorded to this inquiry, Mr Scully, the council's landscape and biodiversity officer, gave evidence to the EIP that the approach had been recalibrated. This is all documented. The Regulation 19 response of Natural England is clear that there is no objection to the Woodsgate Corner site, known as PE6. Ms Miles has interpreted the correspondence to mean that Natural England only reviewed major development allocations presented to it by the council as it defined major development. That is plainly not correct, because it's clear from page 6 that PE 1, 2 and 3 were not considered major development by the council. Natural England states, whilst these 3 sites individually are not identified as major development by Tunbridge Wells Borough Council, they are considered to cumulatively represent major development. Natural England therefore objects to their inclusion as allocations. Clearly, Natural England was aware of all allocations, not just those identified as major development by the council. They were not concerned with PE6, either individually or cumulatively. It is not credible to state that somehow Natural England missed PE6, and if they did, the appellant could have drawn it to their attention, which they have not despite extensive participation in the EIP. Furthermore, the council's methodology is clear and transparent through the distribution of development topic paper. At para 6.145, the council sets out the matrix for determining whether developments are major. This was based on the criteria of MPPF footnote 55, taking account of nature of development, scale, setting, and potential for significant adverse impact on AONB proposals. Para 6.146 sets out that the methodology is at Appendix 2 and has been slightly revised, taking note of comments received at Reg 18. At paragraph 6.147, the topic paper provides that the results of respective assessment against each of the above MPPF considerations are drawn together by experienced planning officers in making a judgment on whether a development is major or not. While this is a matter of planning judgment, it is based on experience in the local context, using the above assessment framework to ensure a consistent approach. It has been informed by comments from Natural England and the AONB unit through an ongoing dialogue, as well as relevant recent appeal decisions. At para 6.148, the council sets out that there was broad agreement with Natural England on the list of sites considered to be major and not major. It also sets out that following AONB unit comments at Reg 18, all sites were reconsidered for major, non-major. Natural England was well aware of the methodology. It had been informed by them. It was aware of the sites that were listed as not major so that it could have challenged them as the AONB unit did, and PE6 was not listed. Finally, the Matter 7 statement produced by the Council for the EIP states at para 279 that ALP6 is not major development in the AONB, which is agreed with Natural England. That should put the matter beyond doubt. Ms Miles says that she has not seen that agreement. Neither the appellant nor you needs to see the agreement unless it is being alleged that the council is deceiving the EIP inspector. The inspector, you, sir, in this appeal, as a result of all the documentation available, can safely conclude that Natural England is not of the view that PE6 represents major development. Woodsgate Corner, Ms Miles accepts, will come forward as either extra care or a care home and not a C3 use. Mr Ireland's evidence is that it would be more likely in his experience as a planner to come forward as an extra care facility. Mrs Venables gave no expert surveyor's evidence, e.g. in the form of numbers and viability, as to why that was incorrect. Mrs. Venable's evidence was that it was more likely to come forward as affordable rather than private, but this is an area in which there are high levels of home ownership in the older persons cohort, for which there is mirroring, we have been told by Mrs. Venables. There was simply no evidence to support that point. Miss Miles accepted there were no known abnormalities to accept viability and did not produce any evidence of the same. The main point that appeared to be put was that because this was near a Tesco superstore and was roadside, it was not attractive. It may not be attractive to Audley Homes, who we are told operate in the luxury end of the market and sell some of their properties for just shy of £1 million. But there are plenty of people who cannot afford a retirement property of £1 million. And there are plenty of operators, as Miss Miles agreed, who do not operate in the luxury end of the market. The dairy on St John's Road is an example. Miss Miles has essentially sought to compare this site to the appeal site. She argued it is no more sustainable than the appeal site. As you would have noticed, sir, that is inaccurate. It is next to Tesco and it is better related to bus stops. Whilst the appellant appeared through cross-examination to advance that this was unattractive, being close to Tesco for many people is an advantage and not a disadvantage. Furthermore, if a luxury operator is not interested in this site, but a mid-range operator is, this site will provide choice to older people who do not have orderly budgets. Finally, it is not unusual that an operator has not yet been identified. The SLP is at examination. This site is sustainable. It is proposed to be allocated. There is no objection from Natural England to development of it. It can provide extra care housing and is deliverable. The cinema site. Mrs. Venable stated that she would simply not include a site like this as a planning application has not yet been submitted. Unlike general housing need experts, she had not contacted the developer herself. She had not sought information despite the fact that the council includes this site. Neither had Miss Miles. This appeared curious given that she had contacted promoters of strategic sites. This is all standard for appellants when seeking to undermine the council's supply. The appellant has not done so. Miss Miles said this was because the information about the strategic sites was verbal. The appellant has deliberately chosen to cast doubt rather than actively find out from developers whether there are problems or what future steps are. Miss James, as the case officer, gave detailed evidence about the planning performance agreement, the public consultation, the deadlines in the PPA, the meetings with Historic England, meetings with members, meetings involving the chief executive of the council, and the investment made in the planning application process so far. The pre-application meetings have been made on behalf of Retirement Villages, who Miss Miles agrees is an experienced operator. The EIA screening opinion has been submitted. Miss James expects a planning application by the end of this month, as this is the absolute latest it can be submitted, and has no reason to think that it will not be made. Mr. Ireland explained that the expectation is that it will be delivered in 2025-26, and this is consistent with discussions he had with a range of officers, including the head of planning at the council. He was not concerned with the Victorian Railway line. Retirement Villages have been doing a significant amount of due diligence on this site, including dialogue with Network Rail. It has amended the design so there is only one story over the railway line, and there is a basic asset protection agreement in place, which establishes solutions in terms of railway issues and Network Rail acceptance of the solutions proposed. That agreement is not the council's agreement, and it is not in a position, understandably, to put it before the inquiry. But you, sir, can be satisfied that a planning application is coming and that there would be no point making such an application if there were no engineering solutions. As Miss James said, there was a building on this site in the 1930s when engineering solutions were not as advanced. Demolition has taken place without damage. There is simply no reason to cast doubt on the deliverability of a scheme above a railway in 2022. The numbers of units in the planning application have increased relative to the previous consent, but as Miss James said, the heights have not. There is a more efficient layout. A cinema is not provided, which is not a requirement of the extant policy, and there is a lower proportion of retail use, which is accepted following the retail evidence provided in the Nexus retail study. Mr. Ireland and Miss James are both confident about the deliverability of this site. Windfalls and other commitments. Mrs. Venables undertook no analysis of windfall trends. Mr. Ireland's rebuttal details 3 recent windfall schemes delivering 125 units over 5 years just for extra care. Ignoring windfall trends is, in my submission, an unreasonable approach. Further extra care schemes are also coming forward. The Arriva bus depot is a deliverable site, and St Michael's Burstwood is also deliverable. On this site, Mr Ireland told the inquiry he had spoken to the planning agent. He was told the application is in preparation and it is a reasonable expectation that it will be delivered. Other ways of meeting need. It is submitted that extra care housing is not the only way to meet need. Care can be provided in people's homes, and many people do not want to leave their homes. Homes can be adapted. This is particularly relevant in an area like Tunbridge Wells, where there is high home ownership. Mrs Venables also seemed to have no idea what emerging policy H6 was providing. She was not aware that there was a supportive and flexible policy framework, which also included criterion 2 for M42 accessible and adaptable dwellings, so that there is choice for older people. She was not aware that criterion 1 was positive regarding adaptations and alterations to allow people to stay in their own homes. And criterion 3 provides for at least 10% housing for older people on new build developments of over 20 homes, and criterion 5 specifically supports windfall development. To conclude on need, Tunbridge Wells is addressing the need for different types of housing for older people. It has done so via windfall development, as is evident, and is doing so through its local plan, which is planning positively, proactively, and flexibly to ensure that need is met, whilst also ensuring choice for all. The allegation by Ms Miles that the council has wholly failed in its duty to properly assess the needs for older persons housing in its borough, such that it is a failure under the Care Act 2014, is wrong as a matter of law, as Section 1.4 of the Care Act 2014 engages Kent County Council and not Tunbridge Wells Borough Council. Mrs Venables was keen to tell the inquiry that she had experience up and down the country, including Scotland. She agreed that there are many authorities that have no policies adopted or emerging dealing with extra care provision. Tunbridge Wells is not one of those authorities and is different to local authorities in decision letters relied upon by the appellant. Mr Ireland's independent view regarding this council is that there are a number of schemes for planning consent. There are applications for extra care housing coming forward on town centre sites. There is specific provision within allocations in the submission local plan. As he also said in relation to Greenbelt from Para 141, all other alternatives must be examined fully, and there are a range of sites coming forward and opportunities to deliver extra care on land that is non-Greenbelt. Looking at Mr Ireland's table 4.25, there is a pipeline supply from commitments and proposed allocations in the borough of over 650 extra care units. In table 5.4, he shows a pipeline supply of 400 in the Tunbridge Wells area. Mrs Venables' table T3 shows a need to 2025 for private extra care in the Tunbridge Wells local authority area of 337. The need in Tunbridge Wells is not critical at all. Turning to the Greenbelt. As part of the submission local plan, the council commissioned a series of 3 Greenbelt studies by independent consultants LUC in order to evaluate and support the assessment and proposed removal of land from the Greenbelt. The site was assessed at stage 1 and stage 2, but it was not considered further for allocation, so was not subject to a refined assessment of harm within the stage 3 study. The appellant does not agree with the selection process for the stage 3 assessment, but it is not a matter to be resolved through this inquiry. The findings of LUC in the Greenbelt assessments are relevant and well reasoned. However, when looking at the site in isolation within the stage 2 study, it was part of a wider parcel TW5, and given the context of the site remaining in the Greenbelt and the permitted development at Owl's Nest Wood in close proximity to the site, the findings of the LUC study are not considered to be conclusive for the purposes of this appeal. What is more relevant is the refined and detailed analysis carried out by Mrs Kirk on behalf of the council. In relation to the conclusions of the stage 2 assessment, the overall harm rating for parcel TW5 was considered high. Other adjacent parcels were found to have an overall harm rating of moderate and low. It explains perfectly why parcel TW5 was taken no further in terms of potential allocation. Whether the development is an appropriate development, it's agreed between the main parties that the proposals represent an appropriate development, which is by definition harmful to the Greenbelt and should not be approved except in very special circumstances. It is also agreed between the main parties that substantial weight should be given to any harm to the Greenbelt in accordance with Para 148. What is not clear from the appellant is the weight to be given to Greenbelt harm in the balance if there is more than definitional harm. Ms Miles was of the view that there was no further weight than substantial weight to give to Greenbelt harm. However, if this is the case, why was there formal evidence on behalf of both parties as to the level of actual harm to the Greenbelt? Ms Miles thought that the weight to the harm to the Greenbelt was the same, whether it was significant harm or limited harm. The effect of the proposal on the Greenbelt in relation to openness and the purposes of including land in the Greenbelt. Firstly, openness. The framework defines one of the essential characteristics of the Greenbelt to be its openness. There is no formal definition of openness in the framework, but it is a matter of settled law that openness means an absence of built form, and the courts have confirmed that openness of the Greenbelt has a spatial as well as visual aspect, and there can be a spatial aspect even if there is no visual aspect. There is no law, policy, or guidance which mandates or even recommends an approach of combining spatial and visual aspects of openness in order to draw an overall conclusion of impact, and Mr. Gibbons did not draw attention to any authority. The development introduces approximately 8,000 metres squared of residential C2 and 2,485 metres squared of communal facilities with internal roads and 142 car parking spaces. For context, the Hamptons has a footprint of approximately 108 metres squared, and 79 Sandown Park has an approximate footprint of 115 metres squared. Mrs. Kirk states that this is considered typical of the area. The aggregated built footprint of Pembury Grange is 790 metres squared. The illustrative building footprints range between approximately 347 and 1,308 metres squared, which is substantially larger than existing nearby residential properties. This development footprint of almost 10,500 square metres being introduced into the Greenbelt amounts to a huge physical intrusion, both as standalone development and in its context. Car parking and roads are also relevant despite not having volume. The PPG sets out that included in the matters to be considered are also the duration of the development and its remediability and the degree of activity likely to be generated, such as traffic generation. It was agreed that the duration of the development is permanent, that there is no remediability possible, and that the degree of activity likely to be generated is significant compared to the current situation. Overall, there is a significant impact on the spatial aspect of openness. Visually, it is important to note the position on the site itself. It is agreed that there will be clear views of the proposals from the track element of Sandown Park, the avenue, and from Blackhurst Lane. From the Burston Nurseries decision letter, it was noted that the site was well contained, but that the development as a whole would be visible to residents, staff, and visitors across the site. That was considered relevant despite there being no public access. On these facts, the additional matter of a well-used footpath is a factor. For these users, there will be a significant impact on the visual aspect of openness. To a lesser extent, it does also amount to a visual intrusion. There are glimpses of the site in Tunbridge Wells Hospital from the A264 in winter, leading to an alteration in the perception of gap between Tunbridge Wells and Pembury from Pembury Road. The perception of openness from outside the site would be compromised. There is no netting off or cancelling out or combining of effects that is allowed. To reduce the overall effects on openness because the visual aspect is not as great as the spatial aspect is to manufacture an assessment of openness. One aspect adds to the other rather than the appellant's manufactured approach. Overall, there is a substantial loss of openness in both visual and spatial terms. Therefore, aside from the harm by definition, there is additional harm to the Greenbelt on account of harm by way of loss of openness, and harm to openness is agreed to exist. The purposes, boundaries of the Greenbelt should only be altered where exceptional circumstances are fully evidenced and justified through the preparation of updating of plans. Part of evidencing and justifying Greenbelt boundary releases through Greenbelt assessments. The boundaries are intended to have permanence in the long term. It is not for this inquiry to investigate the current Greenbelt boundaries or any proposed alterations to them. That is taking place elsewhere. Greenbelt boundaries will not change by virtue of this decision. So it is with some curiosity that the appellant has suggested that the A21 would form a better edge to the built-up area and would provide a strong defensible edge into the future. It is irrelevant. If the council is wrong about that, then it disagrees with regard to boundaries that would or could be provided by this site. The site to the south has an open gap and therefore does not have a strong boundary for Greenbelt purposes. Mr. Gibbons wanted to point to planting up the boundary, which within 15 years would be between 5 and 9 metres high. That is not a defensible boundary. In relation to the purposes, it does not matter how many purposes are harmed. One is enough. Furthermore, it does not matter how much harm is caused. Harm is harm. Turning to the first purpose, to check the unrestricted sprawl of large built-up areas. The PAS guidance relied upon by the appellant in relation to exploring whether the definition of sprawl should change is not helpful to the appellant. It refers to development that is planned positively through a local plan and well designed with good master planning. Sprawl. The proposals are not planned positively through a local plan, so do not meet this suggested amended definition in any event. The Greenbelt assessment concluded that in relation to this purpose, the relationship of TW5 was relatively weak. Mrs. Kirk focused on the site itself and concluded that having looked at the developable area of the proposals, development would be in an area of the parcel which is both physically and visually separated from the settlement edge of Tunbridge Wells by woodland and trees. The A21 lies in cutting for most of the eastern site boundary, and the noise is limited and does not intrude upon the site visually. There are physical links to the countryside and visual links to the countryside. She concluded that the site relates more strongly to the countryside than adjacent settlement, and that it makes a moderate contribution towards this purpose. Parcel TW5 included countryside to the south of the appeal site, which would have been removed as part of the development of the parcel. In contrast, the development of the appeal site would extend the settlement edge over an existing boundary towards Pembury Hospital. The appeal site in its current state thus checks the sprawl of Tunbridge Wells to the south and east. There is a contradiction for the appellant in relation to this purpose and this point. On the one hand, the site is said to be so contained by natural features surrounding it on four sides that development of the site would not constitute sprawl, and yet the same natural features are not considered to represent the relationship of the site to the countryside. The site is contained by natural features surrounding it, save for a gap to the southwest, and therefore there is no relationship to the urban edge. In contrast, despite the lack of intervisibility between the site and adjacent settlement, the appellant considers that the appeal site has a strong relationship with adjacent settlement. The bottom line is that the site itself is even less related to the urban edge than other areas of parcel TW5, particularly to the southwest. A boundary is only a boundary if it contains development on one side. There is development to the west of the A21 in and around Pembury. Development on the site jumps the Greenbelt boundary, and the development of Tunbridge Wells has sprawled out such that it has no edge in this location any longer. The level of contribution the site makes to the level of harm is in dispute between the parties, but there is no dispute that there is harm. To prevent neighbouring towns merging into one another, there is no argument from the appellant that the relationship between Pembury and Tunbridge Wells is at issue here, and rightly it has not been suggested that this purpose does not apply, as there are no neighbouring towns in this location. This purpose is not, as Mrs. Kirk explained, about the last piece of a puzzle or last wedge separating two neighbouring settlements being compromised. This is about the contribution a site makes to this purpose, not that it is the sole area. The appellant has sought to judge this by measuring absolute distances, which is not encouraged by the PAS guidance introduced. The reason given by the guidance is that the identity of a settlement is not really determined just by the distance to another settlement. The character of the place and of the land in between must be taken into account. Land not within settlement boundaries is relevant. The character of the land in and around settlement boundaries is relevant. What exists around the settlement boundary of Pembury is therefore relevant. Buildings such as the hospital, Tunbridge Wells at Pembury, are part of the character influencing the village of Pembury. Consequently, there is more impact on the physical gap than a straight line between the edges of the site and Pembury. It is important to consider the character of Pembury as a whole. Even if this does come down to measuring straight lines, it is still a matter of fact that the development on the site reduces the distance. Visibility is not relevant to this purpose in the NPPF or in any of the Greenbelt studies undertaken. And the Stage 2 assessment found that the connection provided by the A264 means that the open space within the parcel also makes an important contribution to the settlement gap. The appellant wants to read words into this statement, but whilst the study could have excluded the site from this conclusion, it did not. This is supported by the LUC sensitivity assessment of sub-area PE4 and by the Stage 2 assessment of PE6, which included the appeal site and which mentioned an urbanising influence and that there was significant development within the parcel. Neither description was used for TW5. The Greenbelt assessment concluded that the contribution of TW5 to Purpose B was relatively strong. Mrs. Kirk noted glimpses of the site and Tunbridge Wells Hospital available from the A264. A material change in circumstances since the Greenbelt assessments were undertaken is that planning permission has been granted at Owl's Nest, increasing the importance of the site. Development of Owl's Nest in combination with the site would reduce the open land between Tunbridge Wells and Pembury, such that the separation between the two is compromised. Furthermore, there are proposed allocations at Pembury, which would, if allocated, extend the settlement edge of Pembury to the south, and which would likely make the A21 the green belt boundary feature to the south and west of Pembury. As such, the open land to the west of the A21, of which the appeal site is part, in combination with the A21, will form the essential separation between the settlements of Tunbridge Wells and Pembury. Mrs. Kirk concludes that the site makes a strong contribution to this purpose. In light of the sensitivity study, the stage 2 assessment, and the assessment by Mrs. Kirk, the opinion of Mr. Gibbons does appear as an outlier in relation to this purpose, particularly as he uses the same developments to the east of the A21, Owl's Nest, the hospital, hotel and garden centre, to justify that the site is part of an urban fringe landscape. It seems illogical that built form can be an urban influence without a requirement for intervisibility, but that this same built form would not impact on separation because it is not visible. Again, notwithstanding how low he assesses the contribution to be to this purpose, he still found harm. To assist in safeguarding the countryside from encroachment, the stage 2 assessment provided that all land that retains openness can be considered to some extent to constitute countryside, but the contribution made to safeguarding the countryside from encroachment can be considered in terms of the extent to which land displays the characteristics of countryside, i.e. lack of development, and land uses which are associated with countryside rather than settlement, and in its relationship with the rest of the greenbelt. Mr. Gibbons agreed that the site is countryside and that it displays the characteristics of countryside, and that the land uses on the site are associated with countryside, agriculture and sheep grazing. The council's case is that it feels rural on the site also. There are no urbanising influences on the site. And references to urban fringe by Mr. Gibbons are misplaced, given that he agreed that it is important to avoid the inclusion of landscape quality as a factor in this assessment. If the site is contained by countryside, then it must also be contained from urban influences. Again, the appellant cannot have it both ways. Again, the visual impact is overplayed. Visual containment does not mean that encroachment is prevented. The site is open to the southwest, and the development within the site would weaken the safeguarding of the countryside to the south of the site. Mrs. Kirk considered the appeal site itself and has found that the appeal site has a degree of separation from settlement, but has appreciable links to the countryside to the north and south. She concludes that it makes a moderate contribution to this purpose. Again, the appellant agrees that the site makes some contribution to the purpose, but does not agree the level of contribution or the level of harm. In terms of preserving the setting and special character of historic towns, there is a relatively weak contribution in relation to this purpose, but still some contribution, and there is agreement between the parties in relation to this purpose. Overall, following the methodology of the LUC Greenbelt studies, Mrs. Kirk concludes that there is, as a minimum, a high level of harm caused by the development of the site. Save for the World War II pillbox, it is devoid of development. It is open landscape and is separated from existing settlement by woodland copses and tree belts, which represent a moderate greenbelt boundary and reduces the urban influence from adjacent settlement. Mrs. Kirk concludes that development would harm the aims and purposes of the greenbelt, harm the openness and integrity of the wider greenbelt, fundamentally reduce the sense of separation between Tunbridge Wells and Pembury, and would have negligible mitigation or greenbelt benefits. Even if Mrs. Kirk is wrong, the appellant agrees harm to openness and harm to full purposes. Overall, these harms are more than substantial, given that definitional harm is on its own substantial, and there is conflict with policies CP29 and MGB1. Whether the harm to the greenbelt by reason of inappropriateness and any other harm is clearly outweighed by other considerations, so as to amount to very special circumstances to justify the development. Very special circumstances will not exist unless the potential harm to the greenbelt, by reason of inappropriateness and any other harm, is clearly outweighed by other considerations. NPPF requires that other considerations must clearly outweigh the harm to the greenbelt and other harm. The balancing exercise to be conducted also requires the decision maker to have regard to other harm that would result from the proposed development. From Red Hill Aerodrome, the Court of Appeal clarified that the reference to other harm includes non-greenbelt factors. An inspector may therefore include in his balancing exercise any other matter relevant for planning purposes. That includes harm to the character and appearance of the area, and harm to heritage assets, and harm to trees. It is submitted that the balancing exercise comes nowhere near what is required, but first an analysis of the other harms must be undertaken, starting with landscape. and the methodology. There was an attack on the methodology of HDA during the landscape roundtable session. Whilst Mrs. Kirk properly pointed out defects in the appellant's approach, she also pointed out that the HDA methodology has been accepted by both Natural England and by other inspectors. All recent appeal decisions in which landscape has been an issue have referred to the HDA LVIA. Inspector Rose agreed with it and called it an up-to-date professional assessment. Inspector Woodwards agreed with the conclusions with regard to landscape character and sensitivity, and Inspector Manning's conclusions aligned with the HDA LVIA. Natural England worked with the council on the methodology and did not criticise it. Mrs. Kirk has properly assessed the site itself, and as she explained, she has assessed the wider landscape also. The comparison is made with the landscape character assessment, which is the representation of the wider landscape as well as the site itself. Her approach is GLIVIA compliant, and she was careful to point out to the inquiry it was not accurate to focus on one paragraph of her proof. Rather, it would be a fair reading of her evidence to take into account the wider methodology in her appendices. She had assessed the site, the setting of the AONB, the settlement edge, the wider landscape, and the sensitivity. There was no aggregation of effects, and there is nothing professionally inadequate about the landscape receptors. Bizarrely, despite this attempt to undermine Mrs. Kirk as an expert witness, as was evident in the conclusion of the RTS, the assessments of the parties were not actually poles apart. This supports Mrs. Kirk's position that methodologies may differ, but as long as the methodologies are fair, overall assessment of effect is unlikely to wildly differ. In terms of the policy position, landscape character assessments are key to the operation of Core Policy 4 and are required to be taken into consideration so that new development is appropriate by virtue of Core Policy 4, paragraph 2. Of relevance are the Tunbridge Wells Borough Landscape Character Assessment, the AONB Management Plan, and the Landscape Sensitivity Assessment of additional settlements in Tunbridge Wells. The NPPF via paragraph 174 provides for recognising the intrinsic character and beauty of the countryside. Para 176 provides that development within the setting of AONBs, to which great weight should be given to conserving landscape and scenic beauty in AONBs, which have the highest status of protection, and where the scale and extent of development within all these designated areas should be limited, should be sensitively located and designed to avoid or minimise adverse impacts on the designated areas. Turning to value, the parties do not agree as to the value or the sensitivity of the site. The policies and the landscape strategies and guidelines, including landscape character assessments, do give an indication of which aspects of the landscape are particularly valued and which are present in abundance on this appeal site. This is part of a high value landscape. Mrs. Kirk told the inquiry that on site one would see high quality and intact features, high scenic quality, and an experience that is pleasant and enjoyable. She also said the site is rural in character, and as soon as you step off the tarmac element, you go through 2 copses and onto the avenue, and you have the feeling of leaving the settlement and being in the countryside. This is a high-value rural character which has no real visual relationship or physical relationship with the urban form. The site is not designated locally, but it was designated until such local designations went out of fashion. There are also no local designations in the submission local plan. Any suggestion that the lack of a designation in the submission local plan in the roundtable session on behalf of the appellant is therefore misconceived. As Mrs. Kirk said, the absence of designations does not mean that there are no landscapes worthy of designation, and the fact that it is no longer does not change the quality of the landscape we are looking at. In terms of sensitivity, this is a high quality and picturesque landscape. The sub-area PE4 is most relevant in the LUC sensitivity study. The conclusions include maintaining settlement separation. The fields to the west of the A21 retain a landscape character that is important in the retention of an open approach to Tunbridge Wells. In relation to medium scale development, there is a high sensitivity. This is an important document which was minimised by the appellant during the roundtable session, called a poor document by Mr. Gibbons in terms of its applicability. The council points out that the findings of the report were accepted at the Hawkhurst Golf Club appeal. The sensitivity study was carried out by independent and qualified landscape professionals who assessed parcels in a balanced and proportionate way. Criticism was misconceived. Mrs. Kirk agrees with this sensitivity rating and states that the appeal site forms the last piece of a rural landscape at this edge of rural Tunbridge Wells before the Pembury bypass and contributes positively to the setting of the settlement. The site has strong associations with Pembury Grange, in keeping with its proximity and historic association. The site forms the immediate link with the rural edge of Tunbridge Wells and provides access to the AONB landscape to the north and northeast. A slightly lower sensitivity rating applies to development classified as small, as these proposals are not restricted to 2 and 2.5 story residential dwellings and represent an equivalent type of development to the care homes described under the description of medium scale development. The lower sensitivity rating does not apply, and the appellant has not sought to apply any such lower sensitivity rating from the study. The independent view of LUC with regard to PE4, of which the site is part, is that it has a high sensitivity to this type of development. As a result of its value and high susceptibility to change, the site has a high sensitivity. The magnitude of effect represented by the construction of the proposed development would also be high, leading to substantial adverse effects on the character of the site despite the mitigation measures proposed. Mr. Gibbons accepts that there will be significant adverse effects on the site, both in the short and long term. The council maintains that these effects are material to the judgment of landscape harm resulting from the development of the appeal site. If the correct site is chosen, for example, one with low sensitivity, and development is brought forward in a positive way, the residual effects within a site should not be significant. The Borough Landscape Character Assessment SPD, LCA 14 is relevant to this site. Under valued features and qualities, there is ancient routeways valued for their history and sense of place, particularly where they are narrow, deeply sunken and edged with trees, hedges and boundary banks. Although Blackhurst Lane and Sandown Park are not ancient, Blackhurst Lane is visible on an OS map dating back to the 1700s and Sandown Park dates back to the construction of Pembury Grange. Both rural lanes are edged with trees, hedges and boundary banks. Second, the ancient woodland, which is characteristic on the site. Thirdly, the small, irregularly shaped historic fields, bounded by hedgerows and small woodland, which is characteristic on site. Fourthly, a strong natural character, which is readily and extensively accessible on foot. Again, this applies. 6, the woodlands provide a rich perceptual experience for the local population to experience wildlife from footpaths and recreational routes. Then the sense of relative remoteness and a secret quality provided by the enclosure of woodland and ridges, a valued sense of escape. The sense of history provided by features including estates, parklands, ancient woodland and rural lanes. Those are features which are said to be of particular value in the landscape character and are defining what makes a character area special. The reason for drawing out these features as something over and above key characteristics is because they are to be protected as valued features and qualities. The landscape strategy is to conserve and enhance the valued features and qualities of the landscape and to ensure development proposals will not impact on the remote, secretive and empty character of this area. The proposals are not consistent with the landscape strategy for the character area and would harm the key characteristics of the site, which would have a harmful effect on the landscape character of the locality. The AONB, the High Weald AONB Management Plan, provides the definition of the natural beauty of the High Weald. The 5 defining components of character that define the natural beauty are geology, settlement, routeways, woodland, and field and heath. The boundary of the High Weald follows the line of Blackhurst Lane, which runs adjacent to the northern site boundary. To the south, the AONB boundary is 350 metres from the site, and the site contains and reflects the special characteristics of this AONB. It has a landform consistent with the High Weald. It contains woodland, including ancient woodland. It is composed of small, irregularly shaped fields bounded by hedgerows and woodland and typically used for livestock grazing. There are historic routeways around it. The PPG covers the setting to protected landscapes and states that long views from or to the designated landscape are identified as important, or where the landscape character of land within and adjoining the designated area is complementary. The character of the site is complementary to the character of the AONB. Pembury Road and Blackhurst Lane form the boundary and the footbridge is adjacent, and from these one can perceive the land beyond. The AONB boundaries are not marked on the ground. As Mrs. Kirk said in the roundtable session, the line of the AONB drawn on a map does not mean that one steps over the line and immediately is faced with a different quality landscape. There is no discernible change in landscape quality. The site and wider area form a countryside connection to the AONB. The site fills part of a gap with a landscape with AONB qualities, which adds to the experience of leaving the site. There does not need to be visual connections or perceptions. Mrs. Kirk has described the experience, which is more than visual. Furthermore, sir, you would have noticed on the site visit the intervisibility between Robinsgate Wood and the site. The area of AONB to the north of the site is already compromised by the A21 to the east and development to the west, which means that the rural connections to the north and south become increasingly sensitive to change. The site forms the southern setting to the AONB in this location and represents the remaining countryside connection to the AONB to the south. The development would compromise this connection and harm the setting of the AONB because it would sever the connection and association with it. Development within the setting should be sensitively located and designed to avoid or minimize adverse impacts. The severance of the connection to the AONB is nothing short of an adverse impact, contrary to paragraph 176. The rural character of the lanes, Sandown Park and Blackhurst Lane, are accepted. They are rural in character, and the perception of rurality would change as a result of the development. It matters not if the lanes are covered by the SPG or not, as they are still material receptors. Furthermore, the avenue has historic value in association with Pembury Grange. As to visual impacts, the greatest of these are from the avenue and Blackhurst Lane. In terms of the important landscape approach on Pembury Road, the council accepts that there would be no visibility in summer if the heights of the proposed development are reflective of the submitted wireframes and not reflective of the maximum heights parameters submitted as part of the planning application. As to whether internal or external lighting and other activity on the site will be visible at night is a matter in dispute. In winter, regardless of the heights of the buildings, the proposed development and the scale and form of the development as shown on the illustrative plans make it more obvious and detracting and would extend the perception of housing into the countryside. The hospital can be seen in winter, which is further away from Pembury Road and has a higher level of intervening tree cover. The differences between the seasons do not net off. As Mrs. Kirk said, her approach is to look at the worst case scenario. That is what people would live with for at least half of the year. Mrs. Kirk was also very clear about the users of Pembury Road. Whilst motorists are transient in nature and are focused on the road, the pedestrians and cyclists have a very different experience. The footpath cycleway is segregated, and there are many who use it for commuting and or leisure. Those who use it for the latter will enjoy the landscape. There will be views of the site from the A21 footbridge, viewpoint 17, which is well used, and the A21 itself in winter. Conclusion on value and effect on sensitivity and on effects. The appellant has underplayed value and sensitivity and overplayed lack of visual impacts, and this has also had an effect on effects and impact on effects. In any event, even on the appellant's case, there is still a residual major adverse effect for the site, and there are still significant adverse effects on visual receptors from the avenue and Blackhurst Lane, both of which are well used by the public. Specifically, there would be significant adverse visual effects from the avenue running through the site and from Blackhurst Lane. The development would be visible from viewpoint locations, including Pembury Road, the footbridge over the A21 itself, which currently contributes to the rural hinterland and arrival into Royal Tunbridge Wells. Substantial adverse landscape effects are predicted within the site, both in the short and long term. These effects are judged to be significant in landscape terms and a key decision-making issue. Moderate adverse effects are assessed for the wider landscape, including the setting to the High Weald and the settlement of Royal Tunbridge Wells. The proposals would harm the setting of the AONB by severing the north-south countryside connection between two parts of the designated landscape and by harming the character of the site, which currently contributes positively to the setting of the AONB. Unfortunately, the underplaying of value and sensitivity and the overplaying of mitigation combined with the disregard for effects at a local and site-specific levels all combine to reduce the credibility of the appellant's evidence and demonstrate that the predicted effects of the development are worse than estimated. Mrs. Kirk's evidence is commended. She is the author of the independent HDA LVIA, which was commended by Inspector Rose and accepted by Inspectors Woodwards and Manning. Once landscape character is changed in this way, it is changed forever. By causing harm, the local distinctiveness of the landscape character of the borough and of the setting of the High Weald AONB is not conserved and enhanced, and there is conflict with policy. And this is also contrary to the statutory duty by virtue of Section 85 of the Countryside Rights of Way Act. Regard to the duty must be afforded significant weight, and furthermore, it's contrary to paragraph 174. Such conflicts weigh heavily against this proposal. Turning to the heritage assets and Pembury Grange. The appeal site is part of the setting of the Grade 2 listed building, Pembury Grange. It formed part of the original estate to Pembury Grange, and the land historically formed part of the semi-rural setting of Pembury Grange between Pembury and Tunbridge Wells, and was clearly included in the estate to be a parkland setting for the house. This was an open setting across the specimen tree dotted landscape to Owl's Nest Wood and beyond. It is agreed that less than substantial harm is caused to the significance of Pembrey Grange between the two main parties, although there is disagreement as to the level of harm within that range. Ms Salter concludes that the harm lies in the medium to higher level. It is submitted there are cogent reasons for her interpretation and conclusions, and she provided clear reasons as to why. The appellant's witness misunderstands the prevalent layout of houses of this size and status in Tunbridge Wells historically, and the relationship with the wider landscaping that is a pleasant feature of the area. There is a fundamental misunderstanding of the importance of the relationship of the house to its surroundings, and also a heavy reliance on intervisibility, which is not the only factor of a development that could impact on significance. It is clearly set out within the planning practice guidance and supporting Historic England guidance that visibility is only one element of the many characteristics of setting that can contribute towards significance for heritage asset. Ms Salter's knowledge of this area assists her to inform the inquiry that such houses were deliberately designed to have a parkland setting with ornamental gardens and rockery within the immediate curtilage and natural landscape surrounding. Similar examples at other country mansions can be seen in the vicinity of Pembrey Grange, Blackhurst, Beechwood, Dunollen and Oakley. Pembrey Grange was one of the grandest of these country mansions. It was commissioned by the son of the developer of the original Calverley estate in Tunbridge Wells, who employed a popular Gothic revival architect whose work features on numerous lists, entries in the National Heritage List for England. The owner's history is relevant as the Calverley estate was laid out with the principal aim of the landowner to create country residences within parkland settings, a theme that continued throughout the 19th and early 20th century residential development of Tunbridge Wells. The park is mentioned in the catalogue, and the parkland is referenced in the 1908 sale catalogue. As Miss Salter explains, this is entirely typical with other country mansions all having similar layouts and relationships with the wider landscape. The appellant attempts to argue that the part of the setting of Pembrey Grange which contributes towards significance is confined to its immediate domestic garden curtilage, and that the breaking up of the estate in the 1930s, followed by the surrounding residential development, has greatly altered the way it can be appreciated. Miss Salter accepts that there has been development, but notes that by late 19th century, Sandown Park had itself been developed, and no subsequent development has been carried out within the parkland itself. Furthermore, the south side of the house where the 20th century development has been located was more of the working end of the estate, including stables and kitchen garden. Mr. Hawkins did not answer this point, but still rehearsed impact from Sandown Park without acknowledging the important point that the approach would always have been developed. The northern parkland where the site is located has not been developed. Mrs. Salter says that this is key, as the principal rooms of the house were designed to be oriented towards the northern parkland, so that these and the longer range views to the north could be admired. As Mr. Hood said, it was built to overlook the site and was designed to do so. The site plays an important role in the significance of Pembrey Grange in that it forms part of its wider historic parkland, clearly included within the estate plan, with the historic footpath leading from the ornamental gardens to the ancient woodland. The parkland setting could be appreciated from the house, with principal rooms facing the appeal site from the footpath and from the avenue moving from the entrance lodge to the main house. There is still, as Miss Salter describes, an evocative experience of its former estate when standing at the entrance to the avenue, the path from the house to its former lodge, with an area of open land that retains much of its parkland character. One is aware of the mansion and its grand presence and the tree-lined route to its former lodge, as well as the open parkland immediately adjacent to its domestic curtilage. The chimneys can be glimpsed and the fields can be seen from within the ornamental gardens and rockery. The appellant focuses on 20th century houses at the end of the avenue, but Mrs. Salter calls them a minor intrusion into the experience and states that there is an overriding sense of a large house with parkland. The gardener's cottage on Sandown Park remains an important visual clue to the former estate as well. The appellant also states that the estate is only legible through documentary sources. However, the lodge is clearly a lodge building, clearly linked by the avenue to Pembrey Grange. The overall picture can still be experienced on the ground by anyone. The parkland side of the setting has not been developed. The grazing in front of the country mansion is not unusual. The lodge is there. The avenue is there, clearly designed with trees lining it and legible as such. As Miss Salter said, most people are familiar with lodge, carriage drive, house behind. It is to underestimate the public to take the position of the appellant. As Miss Salter says, it is an unfolding experience. And once you have been there, you have it in mind and set up to lodge, avenue, house. And the setup is appreciated by all. Mr. Hawkins referenced what a layperson, as he put it, would understand on site. He is not such a person. Mr. Hood, however, is a layperson, and was clear that he lived in the house for 10 years before he looked at archival sources, and it was immediately clear to him the purpose of the avenue and the purpose of the lodge. He noted the gatepost adjacent to the lodge and said, "It screams gatehouse." He said that there are others on Pembury Road, and the characteristics are clear to even someone like me. And if the setup was clear to him and to his neighbours, and that setup was clear to him and to his neighbours simply on visual assessment. The site is one of the last elements of setting from which and to which the estate as it was intended can be appreciated in a manner which contributes towards the significance of Pembury Grange. The fields forming the site are set either side of the approach to the house from the Northern Lodge, which currently can be fully experienced in terms of the historic relationship and would be drastically altered by an intervening appeal proposal as indicatively laid out. Its wider setting forms an important part of its significance in indicating the status and the design intentions. Miss Salter is of the view that whilst there have been intrusions into the setting, the significance of Pembury Grange as an edge of town country estate and the overall experience of approaching a country house through its rural setting can still be appreciated. Furthermore, the 20th century development has not severed all connections of the house with its estate. It has caused harm by encroaching into the space, which allowed the house to be appreciated as a somewhat isolated country house, but this does not justify further encroachment and harm. The PPG directs local authorities to consider cumulative impact on significance through change in setting and advises that local authorities may need to consider the implications of cumulative change. There are various heritage values of Pembury Grange which have been underplayed by the appellant. Its value is not just in its architectural appearance and historic fabric, although both are important. There is evidential value in its positioning and estate layout, some of which has already been compromised and therefore should not be further compromised. It has historic value given its associations with important landowners in town, indeed the particular landowner who is responsible for the first permanent residential developments in the town. The style of the house by an architect who is popular locally, and location and layout. It has aesthetic value derived from the high quality architectural design and intricate and decorated style. It is important that it was not intended to be a town centre showpiece, but a country mansion with at least 2 lodges, gardener's house, large stables and kitchen gardens and ancillary buildings. The house, its estate, including the parkland, were designed together as a set piece, and this is also valuable evidence of this type of Victorian development, distinct from the urban London houses that were often primary residences. The historic and evidential value would be affected by these proposals. To focus on the architectural interest only of the building is to ignore and underplay under other aspects of its significance. Whilst it might be right that part of the wider landscape has already been eroded, this is not an argument to erode it further. Miss Salter explained that the full appreciation of this historic setting now is mainly appreciated from the appeal site. Indeed, it would erode it to such an extent as to sever the relationship between Pembury Grange and its landscape fully. She explains that the scale of the buildings and the hard landscaping will fundamentally change this part of its setting that forms part of its significance and so cause less than substantial harm to significance. It will intervene between the house and its North Lodge and sever their relationship completely. It is acknowledged that the lodge is no longer in the same ownership, but provides the experience still of approaching the house through the open landscape. There are therefore a number of elements of setting contributing to the significance, which would all be affected. Intervisibility is only one factor of setting to be considered alongside all other factors. The effects would include a permanent change in character of the land, the deliberately designed parkland setting to Pembury Grange, the severing of the historic and spatial association of the house with its Northern Lodge and principal approach from the main London to Hastings Road due to the intervention of significant built form and infrastructure lining the historic route, further dilution of the historic open setting of the house, closing in around it and isolating it from any sense of parkland setting, a change in character of the site from pastoral rural ambience and competition with the house as a dominant historic feature with the introduction of large-scale buildings. And the appellant's reference to the home for old women is completely irrelevant. As Miss Salter explains, this is not relevant to assessing historic heritage significance. Even on the appellant's case, there is harm. As a matter of law, this is harm to be afforded considerable weight in the planning balance. It is contrary to policy. With regard to the conservation area, the parties do not agree as to whether there is harm. Ms. Salter's opinion is that there is less than substantial harm on the mid to low end of the scale. The built history of the part of the town located in the conservation area is directly relevant to its growth as a spa town and its evolution as a desirable place to live. Pembury Road can be read as a discrete character area because of the low density and Arcadian character and large mansions with ancillary buildings, and these qualities are characteristic of other parts of the conservation area, such as Camden Park, Broadwater Down, and Neville and Hungershall parks. Similarly, these areas were developed with a vision of parkland residential development to complement the concentrated historic core of lodging houses around the Pantiles. They are approached by, for example, Langton Road and Eridge Road as routes to the historic core. Pembury Road is one of those principal routes into the conservation area and provides an important experience of arriving from semi-rural surroundings to this distinctive parkland development towards the historic core. The conservation area appraisal makes it clear that these properties were intended to recede behind trees, hedges, and other planting within a parkland setting, rather than being the dominant feature. However, glimpses of them also form part of the significance of the conservation area. The proposals would alter the perception from that of an Arcadian residential area to a more built-up urbanised area. Whilst there is not strong visibility of the site from within the conservation area, the absence of development provides a semi-rural setting to the conservation area, which contributes towards its significance. The Arcadian character of this part of the conservation area, as described in the conservation area appraisal, was deliberately preserved by the low density development in the 19th century, and the separation between Tunbridge Wells and Pembury was also preserved. Ms. Salter produced the London Daily News announcement of the sales listing of Pembury Grange, which noted the charming mansions in a distinguished neighbourhood. Para 12.1.4 of the CAA notes that some of the wealthiest people in Tunbridge Wells came to occupy the enormous mansions. They were only meant to be glimpsed through the trees lining the road. They were supposed to be secluded in parkland surroundings, with lodgings at the entrances being the clue to what lay beyond. The lodge buildings are readily seen, and the heavy boundary planting referred to by the appellant does not have the diminishing effect contended. Para 12.1.9 identifies the role that Pembury Road plays in the separation between the town and its surroundings. And I don't rehearse the quotation. The CAA also describes the eastern end of this conservation area, the end nearest the site, as the eastern gateway to Tunbridge Wells, which, although at a busy traffic node, is marked by a dense woodland block between Hallshole Road and Pembury Road, and heavy tree cover all around the junction. It is a green belt separating the small residential area of Sandown Park from the town. Para 12.2.14 notes some of the views that could be affected by the proposals and includes views across Sandown Park. Ms. Salter raised visibility given the fundamental change to the landscaping, the presence of the built form, the increased activity and the lighting of the site. Cars can be seen on Pembury Road during the day and night when the trees are not in leaf, and so development will be visible from Pembury Road. The argument about users of Pembury Road was also relevant to heritage. Any argument about it being heavily trafficked is misconceived. Pembury Road is also heavily used by walkers, runners, scooters and cyclists, and has a dedicated off-road cycle path allowing users to appreciate the wider setting. As Ms. Salter said, the road does not eradicate the experience of this being a historical principal route into the town. She makes the point that those walking or cycling have the opportunity to stop and experience. And Mr. Hood spoke of his experience of cycling the cycle path and being able to enjoy the features of the surroundings. Attributes of setting particular to the conservation area are the physical surroundings, including topography, other heritage assets, including Pembury Grange, the definition, scale and grain of the surrounding landscape, openness, green space, trees and vegetation, and history and degree of change over time. The experience of the conservation area would also be affected. Ms. Salter's view is that the openness and parkland character of the site contribute to the Arcadian pastoral character of this part of the conservation area, and it forms part of the separation of the town from the surrounding areas. She has acknowledged that there is tree cover inhibiting views, but she notes that there will be glimpses, and the presence of a large-scale development would be noted and would affect the views noted in the conservation area appraisal, altering the experience of that part of the setting of the conservation area that contributes towards significance. This is the open setting associated with one of the large houses that, along with its parkland setting, define the character of this part of the conservation area. There is nothing proportionate about the scale and massing of the proposals. With regard to GPA 3 guidance, the effect of residential development on the significance of Pembury Grange would include its position in relation to views from the conservation area, the relative conspicuousness in comparison with the existing views of mainly green infrastructure, the scale of the development proposed, the change of character that would be the result of a grouping of large buildings within the currently open space, and the permanency of the development. The cumulative harm to the significance of the conservation area and to the significance of Pembury Grange is not outweighed by the public benefits, and the internal balancing exercise under Para 202 MPPF means that heritage harm is still an issue. Even if it were outweighed by public benefits, heritage harm does not disappear and still falls to be considered in the planning balance. As to trees and ancient woodland, over the course of discussion at the inquiry, the council is satisfied through the newly proposed condition that the irreplaceable ancient woodland on site can be adequately protected, and this element of the council's case is no longer pursued. In relation to trees T4 and T5, Mr. Mashburn gave evidence on behalf of the council in this roundtable session. He was the officer consulted about the planning application, but he has since left the council to work in private practice, and yet he still returned to draft a proof, a rebuttal proof, and to give evidence. His professional opinion is still that development should be refused because he considers it likely that T4 and T5 will be lost. T4 and 5 are category A trees, and importantly, they form part of an avenue of trees which were planted at the end of the 19th century, either side of the avenue. Loss of them causes harm, not just in the loss of trees in and of themselves, but in their significant landscape value. As Mr. Mashburn described, these trees are the first chestnuts encountered, the first on the avenue. They are essential components of the avenue, have been growing for more than 100 years, and are key features of the site. He carefully explained during the roundtable session that the proposed internal road providing primary access to the whole of the site encompasses a Y junction. Whilst further details from the appellant have resolved concerns with the western element of the Y junction, he still has concerns regarding the northern element. There is no cross-section provided, and his opinion is that the road cannot be constructed and delivered without harming T4 and 5. He gave evidence about excavation and battering, and because of the site levels, this is not something that can be resolved by condition. His view is that the access to the northern part of the site cannot be constructed without harm likely to lead to loss. Any condition is therefore not necessary or reasonable because it is not possible. The proposal states that the new road with cellular confinement system and finishing course would be no greater than 0.5. Mr. Mashburn explains that the land east of T4 and northwest of T5 is already level with the RPAs of these trees and the Sandown Park carriageway, but drops away between these areas. The proposal would therefore result in a significant level change within the RPAs of these trees to accommodate a usable topography for carriageway and footways. As a result, it is likely that the proposed development would result in the loss of these trees in the medium term and possibly during the construction phase. It also appears that the amount of hard standing proposed within the RPAs for T4 and 5 would exceed the guidance. As a result, there is a risk of root dieback. The AIAMS states that other than pruning for normal maintenance and prudent management, no trees will be pruned because of this development. Mr. Mashburn is clear in his evidence that crown lifting would be required for T4 and 5 to allow construction of the proposed road and to provide permanent clearance for vehicular traffic. Given that the new road would be approximately 0.5 higher than the existing ground levels and large vehicles would need to pass underneath, substantial limbs may need to be removed. The risk profile of the trees would also be increased as a result of the development, which would be likely to increase management pressure on the trees. Mr. Mashburn stated in the RTS that this was nothing to do with lack of information and related to professional difference of opinion. Surface water drainage features are proposed beneath the new roads, including within the RPA of T5, which would require excavation within approximately 5 metres of the trunk of this tree. While such works could be carried out by manual excavation, it is not clear whether the drainage rod could be adjusted should any substantial roots or root mass be found during installation. An indicative foul drainage strategy has been submitted within the appellant's statement of case, which proposes a foul water rising main within the RPA of numerous trees near Sandown Park, including T4. The appellant considers this could be constructed using hand dig or trenchless technology. Mr. Mashburn raises concerns about whether trenchless technologies would be feasible here, and also whether there would be any scope to adjust the position of the pipe should roots be encountered. He also states that installation of drainage runs under cellular confinement systems is contrary to best practice. The proposed development would result in harm to existing trees, which are protected by TPO, and would be contrary to policy. Turning to the very special circumstances, the parties have agreed a list of what benefits could be considered very special circumstances. Need. It is agreed that the development would help meet the identified need for specialist housing for older persons in the area. This has been given significant weight. However, as set out by Mr. Ireland and Ms. James, the need is not critical because of the existing and pipeline supply and the fact that the council is planning positively for such developments within the submission local plan. The council considers that there are alternative sites, which in combination are more sustainable and less sensitive than the appeal site to meet the need for extra care housing. The contribution towards housing land supply overall. The council accepts that there is a need for housing, and this is also given significant weight by the council. However, the shortfall and the actions taken by the council to address the shortfall are relevant. If a limited shortfall was a reason to grant planning permission for 108 homes in the Greenbelt, then there is no need for the high hurdle in paragraph 147 in the first place. In January 2021, Inspector Rose found that a 4.83-year supply, a difference of 0.17 years, was slight shortfall. In November 2020, a supply of 4.69 years, difference of 0.33 years, was found to be relatively small in Tunbridge Wells. In February 2022, Inspector Woodwards concluded that the council had a housing land supply of 4.38 years, which was found to be relatively modest. The Highgate Hill decision letter concluded that the council had a supply of 4.61 years, which was found to be not insignificant. It is noteworthy that local plan was at varying stages in all of the above appeals and is the most advanced during this inquiry. The plan was not at examination in any other appeal. With the parties agreeing a housing land supply of 4.66 years, the closest position is that of the Harshnocke appeal. It is submitted that the description that a housing land supply only 0.3 years higher was relatively small also applies to this shortfall. Whilst there is a need for market housing, this applies up and down the country. There is nothing exceptional or rare about it, and the need will be met in full via the local plan. What this proposal does not provide is any affordable housing, which Inspector Rose called a clear and pressing need. This proposal also does not provide any self-build or custom-build housing. In the Hawkhurst Golf Club appeal, there was affordable housing, self-build housing, and a care home. And the inspector found the reality is that the circumstances of the housing shortfall, including challenges around providing for affordable housing, self-build, custom-build, and care home housing, are not unusual. The potential to release larger homes. There is no evidence that larger homes would be released in Tunbridge Wells or how many might be released. In any event, as Ms Miles agreed, this benefit is a byproduct of meeting the need of this specialist housing. It is not a separate benefit because it's part and parcel of meeting housing need and will come forward elsewhere. Furthermore, unlike Burston nurseries, there is no local first priority to purchasers. The on-site health and well-being, this is accepted. But again, this is a byproduct of meeting the need of this specialist housing and is planned to come forward through the local plan and windfall sites. The potential to reduce demand on local public services and health resources is again a byproduct. The appellant has not put forward any estimate of what potential savings or reduction in demand there could be. In any event, this is not accepted. The NHS have not confirmed this, and Ms James's experience is that all occupiers in one location would be registered with a local GP practice, thus intensifying pressure on some services. In the Pickwick decision letter, the inspector was not convinced that this was a separate public benefit. Economic benefits in the form of 50 to 60 additional jobs for full-time and part-time staff did not translate into FTE numbers through Ms Miles's evidence. Ms Miles produced no evidence to show that Tunbridge Wells had a higher level of unemployment compared to the rest of Kent or the rest of the UK, such that this benefit should be elevated in weight. There will be short-term economic benefits for the local economy via construction. In contrast to the Sonning Common decision letter, there is no procurement condition. There are no local apprenticeships or local jobs being secured by virtue of the Section 106 agreement. The job creation and construction will be mostly short-term and will come forward on other planned developments. Job creation in the care sector will arise from other schemes. Ms Miles was asked to find an appeal decision before the inquiry in which any inspector had given economic benefits significant weight on their own, but none was found. The 21% biodiversity net gain is accepted, but for example, in Burston nurseries, there was a biodiversity net gain of over 137% for habitats and over 7,600% for hedgerows, which was given moderate weight. And in Haverhill Road, there was a 234% biodiversity net gain and a country park. These benefits come nowhere near meeting very special circumstances and are wholly inadequate, especially when compared to other appeals. My Appendix 1 to these submissions contains a comprehensive analysis of the other appeal decisions before this inquiry. But by way of example, the Hawkhurst Golf Club appeal was defended by this local authority. It was major development in the OMB and was subject to the exceptional circumstances test, which is a lower test than very special circumstances. But even if it is not a lower test, the same point stands. The scheme provided more benefits than this appeal, but was still dismissed. In the former Broke Hill Golf Course, the housing land supply was between 1.9 and 2.8 years. There was a chronic under-provision of housing supply and a situation which continues to decline. Sevenoaks had the lowest figure for net additions to stock in Kent for 2010 to 2020. The new plan was said to be some years away, but the scheme, which included extra care housing of 180 units and affordable housing, was dismissed in the Greenbelt. Before the inquiry are 10 appeal decisions concerning extra care housing in the Greenbelt. 6 were allowed, and in only one of those did the council genuinely have a higher housing land supply than Tunbridge Wells. The decisions in which extra care housing was approved in the Greenbelt have common themes. The housing land supply is lower than this council. There is no prospect of a local plan. There are no adopted or emerging policies to deal with this specialist need. There are more benefits being provided than luxury homes for older people. For example, a country park, affordable housing, self-build housing, local support, and highways and access improvements. Turning to the planning balance, applying the approach from para 45 of Monkhill, section 38.6 applies throughout, and the proposal does not comply with the development plan. Para 11C does not apply. Para 11D applies because there is a lack of a 5-year housing land supply, but footnote 7 policies apply, and in the case of para 147 and 202 do provide clear reasons for refusal. The proposal is in conflict with several development plan policies relating in particular to harm to the Greenbelt, to landscape and heritage and trees, all of which can be afforded full or moderate weight, and so conflict is significant. The material considerations, including the NPPF because of footnote 7 and para 11D1, weigh against the proposal. The considerable weight to be given to the harms under section 66 of the Listed Buildings Act and section 85 Crow Act further weigh against the proposal. The benefits include housing and older persons housing and a 21% biodiversity net gain, which are all afforded significant weight. However, despite the benefits, the harm to the Greenbelt, more than definitional and so very substantial, harm to the setting of the AONB, to the landscape, to heritage assets and to trees, the very special circumstances cannot overcome all of these harms in their totality. To conclude, this scheme is in the wrong place at the wrong time. The local plan is at examination. The submission local plan will meet the borough's housing needs with a buffer of approximately 1,000 dwellings and meet the need for extra care housing on more sustainable and less sensitive sites, which have all been properly assessed. The appeal scheme comes forward with little in the very special circumstances basket other than specialist housing and 21% biodiversity net gain. It is of no comparison to schemes approved in the Greenbelt. It is of no comparison to schemes dismissed in the AONB, such as Hawkhurst Golf Club. Housing and specialist housing need will be met. The council is committed to that. This scheme causes harm to Greenbelt, landscape, heritage assets, trees. Such permanent harms to deliver housing, which will come forward anyway, cannot be justified. But more than that, more importantly, because the site is in the Greenbelt, it must be more than justifiable. As the inspector in the Oak Farm decision letter said, the overall balance would have to favour the appellant's case, not just marginally, but decisively. The high hurdle of very special circumstances clearly outweighing Greenbelt and all other harm is simply not made out. And so you are respectfully invited to dismiss the appeal. Thank you.
Thank you very much, Ms Lambert. Thank you. Thank you. I suggest we take a 10-minute break now. If that's acceptable to the parties.
Yes, thank you, sir.
Thank you very much. Thank you. Welcome back. Are the parties ready to resume? Miss Bird, can you hear me okay?
I can, sir, thank you. Yes.
Thank you very much. Thank you.
Can I just confirm
check if the appellants are here? Sorry, I can't.
Yeah, yes, we're here.
Thank you very much, Miss Bird. Thank you.
So I take it that you have a written copy.
I have, yes. Thank you very much. Thank you.
So if this deeply unwelcome development goes ahead, the lives of the residents of Sandown Park and Blackhurst Lane will be changed for the worse. The Rule 6 party supports the council's case in its entirety. The appellant has failed to come near to demonstrating that very special circumstances exist which would justify a grant of planning permission. Notwithstanding the council's compelling case on the main issues, FOSP has persisted in its objection to this proposal on highway grounds. This is because the highway authorities, in this instance, have failed to consider the immediately local highway impacts. Residents' concerns were brushed aside. The authorities' focus was on the functioning of the strategic road network, which is only half of the problem. Beyond a peak hour traffic count at the Sandown Park Blackhurst Lane junction, conducted by the appellant in 2018, the impact of the additional development trips on Sandown Park and Blackhurst Lane were essentially ignored until this inquiry. The appellant was aware of local concerns about traffic from the beginning. The planning statement records that the main concern expressed by those attending the community consultation event in November 2019, excuse me, related to potential traffic generated by the proposed development along Sandown Park, residents, staff, visitors, and services. The planning statement goes on to say, of course, the C2 use generates substantially less traffic than a conventional C3 housing development. That refrain was heard many times during the inquiry, but is not a satisfactory answer to residents' concerns. The appellant's transport assessment, the consultation responses of Highways England, now National Highways, and Kent County Council, and the appellant's transport technical notes all focus on the impact of the proposal on the SRN, and specifically the capacity of the Pembury Road, Halls Hole Road, Blackhurst Lane Junction, which is acknowledged to be extremely sensitive to increases in peak hour traffic. It's common ground that the increase in ratio of flow to capacity, or RFC, of this junction will be limited to between 0.01 and 0.03 during peak hours, which is minimal. Those low figures are superficially persuasive, but they're only part of the true picture. The figures do not allow for comparison between the number of vehicle movements on Sandown Park currently and the number likely to be generated by the proposal. They do not reflect the increase in vehicle numbers outside peak times. They do not speak to the implications of the increase in cyclist and pedestrian traffic from the development, which on the appellant's case will also use Sandown Park. Nor do they speak to the safety implications for pupils and staff at Skinner's Kent Academy. They do not account for the likelihood that the overall number of vehicle movements generated by the development may be more akin to a C3 than a C2 use, even though the peak times may not be the same. Authorities do not always get things right, especially when resources are limited and they fear an award of costs. It's still astonishing that the safety implications for the 1,000 plus pupils at Skinner's Kent Academy have not been explicitly considered until this inquiry. The appellant appears to take issue with the fact that the Academy is not part of the Rule 6 party and is not separately represented in this appeal. That is true, but irrelevant. The Academy objects to the proposal in strong terms. Members of FOSP have children and grandchildren at the school. They're worried and they have good reason to be. FOSP has presented its own evidence on the current highway safety conditions on Sandown Park and Blackhurst Lane, together with a commissioned automatic traffic count, ATC, for the period Thursday the 17th to Wednesday the 23rd of March 2022. It records vehicle numbers, types and speeds, and plus still photographs from the ATC camera. The appellant did not submit a proof of evidence on this issue, but responded with a transport rebuttal from Mr. Andrew Blacker. Unfortunately, despite the council's best efforts, Kent County Council did not attend the inquiry. The National Planning Policy Framework. It's common ground that NPPF paragraph 111 is a material consideration in this appeal. The inspector identified it as being of major relevance. It's also common ground that a proposal which does not have a severe residual cumulative impact on the road network may nevertheless have an unacceptable impact on highway safety, which is contrary to this policy. There's no indication on the face of the policy or any other relevant guidance that these two impacts can properly be conflated. It's clear that paragraph 111 should be read together with the preceding paragraph 110D, which requires that any significant impacts from the development on the transport network in terms of capacity and congestion or on highway safety can be cost effectively mitigated to an acceptable degree. The NPPF is obviously not concerned with insignificant impacts. Significance and acceptability require evaluation and are matters of judgment. The current highway safety conditions are the starting point for that evaluation and should not be dismissed out of hand as the appellant has done. Sandown Park is a cul-de-sac and not a through road. Excuse me. The majority of drivers are residents. The only significant non-residential traffic is that generated by the academy, parents dropping off children, sometimes with scant regard to safety, and the 86 or so staff who travel in by car. They too can reasonably be presumed to be familiar with the road conditions. Academy pupil crossings. The highway consultees have not considered the safety of pedestrians and cyclists beyond the personal injury accident data. This is an extraordinary omission given the presence of Skinner's Kent Academy and the measures the school feels compelled to take to ensure the safety of pupils at the Blackhurst Lane crossings. In his evidence, Simon Hicks, the Academy's estate manager, explained why members of staff are positioned outside the school boundary. He said, "We do our utmost to manage the traffic, bikes and pedestrians as best we can. We do have a number of staff on duty at peak times to ensure the students cross safely and get safely into the academy." During the Highways RTS, the appellant was asked whether it had ever complied with KCC's suggestion in its consultation response to contact the school to understand how current attendance is affected by COVID-19 and traffic data collection and its reliability can then be discussed. The appellant was not able to give an immediate answer. You asked, sir, if the information could be provided later. It's not been provided. A reasonable conclusion is that the appellant had no direct contact with anyone from SKA until the interested parties session on the first day of this inquiry when Mr. Hicks gave evidence. The principal's late consultation email dated the 7th of March 2022, which is attached for ease of reference to these closing submissions, states that she had only just learned of the proposed development. The overwhelming impression is that the appellant wished to hear as little as possible from the academy, an attitude which is inexplicable given the obvious impact of traffic on pupils' safety. It's common ground that there's no formal or informal pedestrian crossing on Sandown Park where pupils cross from the unused stub to the Sandown Park entrance. The stub connects with Sandown Park at the bend near the junction with Blackhurst Lane. Mr. Blacker accepts that pupils do cross here, and FOSP has presented video evidence showing they do so in large numbers. Neither the Highway Authority nor the appellant have considered the current safety implications of the fact that there is no formal or informal crossing over Sandown Park at this point, and so during peak times pupils have to cross the road through a line of waiting cars on a bend in the road where visibility is limited. Neither the Highway Authority nor the appellant have suggested this is an acceptable arrangement. It's simply not addressed. Crossing a road through one line of stationary traffic is inherently unsafe, especially on a bend, and especially if the pedestrian is a child. Drivers of vehicles approaching from the opposite direction may not see them in time to stop. Mr. Blacker's answer to this, given in the Highway Safety RTS, was that there are pupils who cross Sandown Park, but traffic is moving fairly slowly. But pupils also cross cross the road outside peak hours when traffic is faster, particularly to get to the playing fields further down on the south side of Sandown Park. Mr. Shorrock gave an account of a near miss between a car and a group of pupils in exactly these circumstances. Mr. Blacker emphasised the importance of local familiarity during the Highway Safety RTS. He accepted that there is a high frequency of pupils crossing the road and said everybody is aware of that situation. I think we all drive and should drive appropriately to the conditions around us. Mr. Blacker also praises the Academy's management of the Blackhurst Lane pedestrian crossings during peak times in his rebuttal, but said in the RTS that he does not understand why the Academy feels compelled to take these measures. The contradiction is baffling. In any event, Managing pupil crossings is not a normal burden which a school should expect to shoulder in ordinary circumstances. Ms. Baker, whose children attend the academy, gave evidence that in her decades of experience as a secondary teacher, she has never known staff to be stationed outside the boundary of the school to manage pupil movements in this way. This was not contradicted by the appellant. Parking. There is clear evidence that Sandown Park is used for parking or dropping off academy pupils during peak times, and this is despite the school's encouragement to use the formal drop-off on the Blackhurst Lane side of the school campus. The inspector queried whether parents who drop off on Sandown Park are going against the school's policy, and Mr. Hicks answered candidly that they are. However, this is despite obvious signs directing parents to Blackhurst Lane. It's difficult to see what more the school could do. The Blackhurst Lane drop-off cannot conveniently accommodate everyone, and there is a highway safety impact with parents stopping in the middle of the carriageway to let children out. School parking on Sandown Park during peak times also limits the space in the northbound lane of the carriageway, making it difficult for northbound traffic to pass the waiting southbound traffic. If the development goes ahead, on the appellant's prediction, the northbound traffic will increase by 14 vehicle movements during the peak morning hour. That's likely to be a conservative prediction and is not a negligible increase. Outside peak times, when parking restricts the width of the carriageway, which it does at intervals along the length of Sandown Park, two cars can only pass each other if one drives up on the pavement. The camber and the pavement profile allow this, and the safety implications are obvious. The additional 356 trips between 7 AM and 7 PM, which the appellant predicts, substantially increase the likelihood that this will occur. Considering speed, FOSP has also presented evidence of high impact collisions on Sandown Park at the bend near the junction of Blackhurst Lane. The pedestrian barriers are dented in places, and no doubt so you'll have noticed that on your site visit. With respect to Mr. Blacker, the response he gave to Mr. Shorrock during the highway safety RTS on this point didn't make sense. He said that the barriers are there to protect pedestrians rather than keep cars on the road. Dented barriers are surely physical evidence that on occasion, the barriers were needed to prevent a vehicle from encroaching on the footway. These damage-only collisions are obviously relevant to an assessment of highway safety conditions, but are not part of the PIA data. It's not reasonable to discount this evidence as the appellant has done. Mr. Blacker explained during the RTS that he had assessed the road geometry on this bend and concluded that it was satisfactory. There's no record of his assessment, but in any event, his conclusions are not disputed. High impact collisions have nevertheless occurred on this bend. The more vehicle movements there are on the road, especially in the early stages of a new development, when drivers are less likely to be familiar with the road conditions, the greater the likelihood of an accident due to driver error. There is a 30-mile-an-hour speed limit on Sandown Park. The traffic survey completed by FOSP shows that the highest 85th percentile speed is 35.6 miles an hour. Vehicles can and do speed on this road. The traffic watch count provides objective evidence in support of Mr. Shorrock's accounts. Driving marginally over the speed limit between 30 and 35 miles an hour is fairly common. Northbound, 405 trips out of 2,589 over the survey period were recorded at that speed. 35 to 40 miles an hour is not uncommon. 120 trips out of 2,589 were at that speed. 40 to 45 miles an hour was recorded for 36 trips over the survey period, reducing to 12 trips at 45 miles to 50 miles an hour. 2 trips were recorded between 55 and 60 miles an hour. One particularly reckless individual drove between 75 and 80 miles an hour on Sunday, the 20th of March, 2022, at around 4 o'clock in the afternoon. Southbound speeds are comparable, but did not exceed 55 miles an hour. This evidence demonstrates that the characteristics of Sandown Park, long and straight until the blind bend at the south end, allow a substantial minority of drivers to travel at speeds which are not considered safe for the road conditions. A small minority take very significant risks. From FOSP's perspective, the current highway safety conditions are obviously unacceptable, but in the absence of guidance on what unacceptable means in the context of MPPF paragraph 111, or any applicable standards other than PIA records, which are mentioned in the Transport Assessments PPG, but not in the MPPF itself, an unassailably objective conclusion would be that the current conditions are on the borderline. Their continued acceptability depends on the vigilance of academy staff and sensible road users, and on the maintenance of the status quo. The next issue to consider is what the highway safety impact of the development trips will be. At the planning stage, apparently in response to resident concerns about traffic on Sandown Park, the proposal routed some traffic via Blackhurst Lane. The statement says it was suggested that Blackhurst Lane, which serves fewer houses, could be used to share traffic flows, so that not all traffic is used Sandown Park Road, which has more houses along it. The draft proposals have been amended to reflect this, and a vehicular means of access is now also provided from the site to Blackhurst Lane. It is also now intended that Blackhurst Lane be used initially as the construction means of access, so as to reduce the number of people that are inconvenienced. That plan has now been reversed again, and the appellant says that all traffic, including construction vehicles, but accepting emergency services, will be routed via Sandown Park. It follows that when assessing the day-to-day impact of the proposal, vehicle movements from development should be compared to the existing traffic flows along Sandown Park. For the avoidance of doubt, FOSS maintains that emergency vehicles using Blackhurst Lane will pose a safety risk. Mr. Backer's bare assertion that emergency vehicles would not need to travel at speed is no reassurance. Considering C2 or C3 use, the non-objection from National Highways and Kent County Council is conditional on the development generating C2 levels of vehicle use, yet KCC also insist on C3 parking provision. WSP, the appellant's transport consultants, advised that C2 use would be approximately 65 to 70% lower than trip generations generated by standard C3 residential development of the same scale. And this is because a range of community and support facilities are included on the site to support and provide for the day-to-day needs of residents. The trip generation rates used by the appellant are common ground, and these are based in agreement with KCC on the trip characteristics of Bramshott Place Care community in Hampshire. The appellant was at pains to remind the inquiry that the application is for a C2 use, and this will be restricted by condition. That cannot sensibly be disputed. However, it conveniently ignores the fact that C2 encompasses different levels of care provision and a correspondingly wide range of planning impacts. The PPG makes this clear. The inspector will no doubt recall the council's planning witness, Ms. James, being cross-examined at some length on the contents of a consultation response from the Kenton Medway Clinical Commissioning Group. The point being put was that the author of the letter did not understand the difference between a care home and extra care as provided by the appeal scheme, the latter putting much less pressure on local health services, both the C2 uses. So the appellant's refrain that this is a C2 scheme is very far from a complete answer to the question of what the planning impact, including highway impact, will be. KCC's insistence on C3 parking provision reflects the reality that an extra care community is not a care home, as does the appellant's interim travel plan, which calls the proposal a retirement village and contains measures to encourage active travel by residents as well as staff. The appellant's trip generation rates were not immediately agreed by the highway authorities, and nearly a year passed between the initial consultation response from KCC and its ultimate non-objection letter. And in that interim period, the appellant was required to produce 3 transport technical notes, all addressing the impact of the proposal on the SRN. Highways England's concern was that even if a C2 classification is accepted, it typically has trips throughout the day, regardless of peak hour or not for residents. And even if the site is restricted to over 55s, many over 55-year-olds are still working and therefore could be moving during the peak hour network. It's important to consider that an assessment which accords with the majority of housing development for 108 units, regardless of age factor. And of course, we appreciate that the primary resident age restriction is now 60 years. In response to that, the appellant's transport technical note refers to its transport assessment, which sets out the 12-hour predicted traffic flow profile for the proposal on which it relies. On its own trip generation rates, the proposal will generate an additional 356 vehicle trips in a 12-hour period between 7 AM and 7 PM on a weekday. And all of these, save for access by emergency services, which are presumably not included, will be along Sandown Park. The appellant's interim travel plan encourages cycling for both residents and staff, including the provision of cycle vouchers for each household and storage, locker and shower facilities for staff. The appellant is adamant that cyclists will access the site via Sandown Park and not Blackhurst Lane, and it's therefore likely that the proposal will substantially increase the use of Sandown Park by cyclists. FOSP's own traffic count. The appellant's manual classified counts were conducted at the Pembury Road, Walsall Road and Blackhurst Lane and the Blackhurst Lane Sandown Park junctions during peak flows on the 26th of June 2018, and then an automatic count was taken on the A264 in July 2018. The appellant did not carry out a count on Sandown Park outside peak hours. In March 2022, FOSS commissioned Traffic Watch UK to carry out an ATC of north and southbound traffic along Sandown Park, as well as east and westbound traffic and traffic along Blackhurst Lane. The results of the ATC were provided to the appellant on request well in advance of the deadline for submission of proofs of evidence and have not been challenged. On Thursday, the 17th of March, the busiest weekday surveyed, FOSS traffic count shows that there were 431 northbound and 438 southbound vehicle movements along Sandown Park over a 24-hour period. For the purposes of comparison with the appellant's predicted trip rates of 356 over 12 hours, the ATC report shows a total of 696 trips over 12 hours. On the quietest weekday surveyed, which is Monday, the 21st of March, FOSS count recorded 667 trips over 12 hours. The appellant's predicted 356 movements between 7 AM and 7 PM represent the additional vehicle movements, which must be added to arrive at a realistic assessment of impact over the 12-hour period. During the morning peak, the appellant's figures predict an additional 19 two-way trips made up of 14 arrivals and 5 departures. These numbers were referred to several times by Mr. Blacker at the Highway RTS. The worst case peak scenario, according to the appellant, is an additional 5 cars added to the southbound queue on Sandown Park in the unlikely event that each car leaves the development at roughly the same time. Even if that conservative estimate is realistic, there will inevitably be some increase in queuing times at the Sandown Park Blackhurst Lane junction, just as the council's delegated report acknowledges. FOSS does not suggest that this will have a detrimental impact on the SRN, but a significant impact on highway safety is obvious. The queue of traffic on Sandown Park is already a danger, both to academy pupils who cross the road through the queue and cyclists who have to ride past on the carriageway which has no cycle lane, or alternatively, ride on the footway. Moreover, the development impact will not be limited to peak hours. So you're invited to note that FOSS ATC shows a consistent level of vehicle movements along Sandown Park outside the morning and evening peaks. Thursday, the 17th of March 2022 provides a fair representation. The peak hour southbound is, as one would expect, between 8 AM and 9 AM, but the number of vehicle movements is fairly consistent throughout the day thereafter. An hourly maximum of 36 vehicles is recorded between 1 PM and 2 PM, and the count doesn't then drop below 24 vehicles per hour until the evening. Northbound, the hourly totals range between 22 and 31 vehicles during the day and don't drop below 25. The peak hour northbound is between 5 and 6 PM, again as you would expect, 47 vehicles and gradually reducing until 9 PM. That's consistent with the appellant's trip generation figures, which also predict a fairly consistent number of movements during the day, ranging from 49 between 9 and 10 to 30 between 3 and 4. Movements don't drop below 30 per hour until 4 PM. If the appellant's figures are reliable, then on a representative weekday between 1 and 2 PM, the residents of Sandown Park will experience 43 additional movements on top of the existing 65, which is an increase of 66%. The fact that these additional vehicle movements only amount to an increase of between 0.01 and 0.03 in the ratio of flow to capacity on the SRN during peak times is plainly a material consideration. However, people who live, work and go to school on Sandown Park will experience the direct impact of the proposal on Sandown Park and Blackhurst Lane. This is equally material, but has not been adequately considered. During the Highway RTS, Mr. Blacker said the following: does the development can trigger something that doesn't occur at the moment? No, it doesn't trigger something that doesn't occur at the moment. There isn't a problem at the moment in that people aren't being struck by cars. There may be instances of near misses, but that collision hasn't occurred and I have no evidence of that occurring, and I have no evidence that the additional development traffic would generate a situation that is different to what's there today. This is not a reasonable approach. The PIA data is not the only relevant basis for assessing the potential impact of a major new development. The PPG makes it clear that assessment should be tailored to local circumstances, and other information may need to be considered where there is robust evidence for doing so locally. That evidence was available here. There's no policy support for the proposition that only PIA records are capable of indicating that there's a problem at the moment, and the major proposal will significantly exacerbate that problem. FOSP's case is that these additional movements, on which the appellant's own figures represent more than a 50% increase in traffic between 7 AM and 7 PM, are plainly something that doesn't occur at the moment and would have a significant impact on the highway safety conditions of Sandown Park in particular. Moving on to consider the new roundabout. Although not directly caused by the proposal, the new roundabout at the Pembury Road, Halls Hole Road, Blackhurst Lane Junction is another thing that doesn't occur at the moment. Its potential impact on the pre and post development highway safety conditions on Sandown Park and Blackhurst Lane have been given no consideration outside this inquiry. It appears likely that the development will go ahead, and given that the appellant was required by KCC to assess the impact of development traffic on the capacity of the roundabout, it is a material consideration in this appeal. There's no information on the likely impact of the roundabout on the development or vice versa beyond the WSP assessment of traffic flows through it. The roundabout drawing was added to the Rule 6 Appellant Statement of Common Ground at the behest of the appellant, and it's not clear, and it remains unclear, what conclusions the appellant will invite the inspector to draw from it. The appellant's unwillingness to let Mr. Hicks of the Academy give evidence about his understanding of the roundabout proposals only adds to the impression that this has not been properly thought through. It's clear from the appellant's transport assessment that the potential impact of junction improvement on pupil movements over Blackhurst Lane was considered, and I won't read out the quote from paragraph 2.4.3. However, there's no corresponding reference to pupil movements over Sandown Park. It's not completely clear whether pedestrian crossing facilities which would need to be retained are the formal toucan crossing at the mouth of Blackhurst Lane or the informal crossing by the pedestrian entrance to the Academy. In any event, as Mr. Blacker accepted during the Highways RTS, the new roundabout does not add a crossing over Sandown Park, and no apparent thought has been given to the fact that Sandown Park, near to where pupils cross the carriageway, will become a roundabout exit/entrance. Counsel for the appellant put to Mr. Hicks that WSP have not assessed there to be any highway safety or any adverse impact of the roundabout, referring to WSP's technical note dated the 13th of May 2021. However, WSP has not itself assessed safety implications of the proposed roundabout. The purpose of the technical note was to assess the impact of the additional trips generated by the Sandown Park development on the assessment results presented in the King Standing Way transport assessment. On safety, all the technical note says is that from a review of the above documents, which are the King Standing Way transport assessment and the section 106, it's believed that a stage 1 safety audit of the roundabout has been completed and agreed. That may be a reasonable belief, but it's only a belief. The RSA1 is not publicly available, and it's not been demonstrated that it assessed the implications for pedestrian movements of large numbers of pupils and staff at the Academy in particular. And there's no evidence that that's actually happened. The fact that the Academy were not consulted on the roundabout tends to suggest that it has not, as do the changes proposed to the pedestrian crossing. The roundabout does provide a new staggered pedestrian cyclist crossing, but does not appear to provide for the retention of the informal crossing, which is currently heavily used by Sandown Park pupils to reach the pedestrian entrance to the Academy on Blackhurst Lane. Nor is any formal crossing over Sandown Park provided. The crowds of pupils who currently cross the lights near the Pembury Road junction will therefore be filtered through this staggered crossing. It does not take an expert to see that the roundabout plan raises serious questions which have not been answered. How will the crowds of pupils who currently cross Blackhurst Lane at the lights filter through the restricted pedestrian space on the proposed staggered crossing? At the present time, there are 2 crossings over Blackhurst Lane, formal and informal. How will the loss of one crossing affect pupil safety? If Sandown Park becomes a roundabout exit, how will this affect the speed of northbound traffic in the AM peak? And this matters because some pupils will be crossing the road through the presumably still queuing southbound traffic. and what impact will the roundabout have on pedestrians crossing Sandown Park and Blackhurst Lane outside peak hours when traffic is moving faster. The inspector is being invited to take on trust that all of this has been considered, and there's no evidence before the inquiry beyond Mr. Blacker's bare assertion that it has. As he stated, he was not involved in the King Standing Way application. It may, of course, all be considered in the stage 2 road safety assessment, but again, there's no evidence of that. The potential consequences are very serious if there's not, excuse me, if this is not properly thought through, ideally in conjunction with the Academy. It matters for the purposes of this appeal because the inspector cannot reasonably conclude that the addition of vehicle movements from the development to a roundabout which is unsafe for pedestrians and potentially for cyclists will have to dismount at the end of the unused stump, walk up to the staggered crossing to continue along Pembury Road cycle lane towards Tunbridge Wells, would be acceptable. In summary, the proposal will obviously have an impact on the highway safety conditions on Sandown Park and on Blackhurst Lane in emergencies because of the additional vehicle movements. And that's significant because of the physical characteristics of Sandown Park, the presence of the Academy, and also the increase in pedestrian and cycle traffic from the proposed development. The final question to consider, so, is whether that impact is acceptable. Considering the highway consultation responses, the All Six Party is well aware that the non-objection from Highways England and Kent County Council is a high bar to get over. We submit that a different approach by USO would be justified in the particular circumstances of this appeal because it would cure the defect in the Highway Authority's assessment. They concluded that the proposal complies with MPPF paragraph 111 because of the minimal impact of the development trips on the capacity of the junction, i.e. the Pembury Road, Walsall Road and Blackhurst Lane junction, and consequently the strategic road network. However, that only addresses one part of the paragraph 111 test, residual cumulative impact on the highway network. It does not address the second part, the acceptability or otherwise of the proposal's impact on highway safety. And it's common ground that those two considerations are separate. Highways England's ultimate non-objection is based on two considerations, principally that the council would be treating this development as a C2 rather than a C3 use. Acceptance that the proposal based on C2 use is expected to add 0.01% of traffic to the network on the SRN arms of the roundabout. Thirdly, a review of the TRIX data. Picking up Kent County Council's non-objection and the factors that's based on at paragraph 63. Firstly, a review of the TRIX data. Secondly, the finding that the additional development trips only have a small impact on capacity at the junction, which can't be classed as severe. Thirdly, the assessment of the King Standing Way Business Park application and its impact on the local road network. Fourthly, an acceptance that increases to the RFC are limited, that there might be minor to moderate impacts on the traffic network, but these are unlikely to cause a severe impact with the junction operation not significantly affected. And overall, the applicant having shown that the existing road network is not severely impacted by development traffic. There are two essential points that arise from that review of the highways consultation responses. Firstly, the focus was on the impact of the proposal on the ratio of flow to capacity of the SRN during peak hours and not on increased traffic on the roads in the immediate vicinity of the appeal site, i.e. Sandown Park and Blackhurst Lane. As Mr. Blacker accepted at the end of the Highways RTS, Sandown Park is not part of the strategic road network. Secondly, consideration of highway safety impacts was limited to review of the personal injury, PIA data. Skinner's Kent Academy's view on the highway safety implications of the proposal was not sought pre-application or during the application process. The consultation responses are silent on highway safety beyond what the PIA data shows. That's not reasonable, particularly given the extraordinary measures the Academy has already taken to ensure pupil safety. The only evidence before the inquiry, other than FOSPs, which explicitly addresses highway safety on Sandown Park and Blackhurst Lane, is in Mr. Blacker's transport rebuttal and his oral evidence at the Highway Safety RTS. When writing his rebuttal, Mr. Blacker had available FOSP traffic count data and he essentially brushes off the concerns of local residents. The following are the main examples. Mr. Blacker says he's not aware of any issues with speeding along Sandown Park, which would warrant traffic calming measures. And in the light of FOSS data, which Mr. Blacker has plainly analysed, it's difficult to understand what degree of speeding would warrant such measures. Mr. Blacker accepts that there's only sufficient width available for one vehicle to pass cars parked on Sandown Park. He concludes there's nothing to stop one vehicle pulling in behind the parked car and giving way. That is true. However, he dismisses out of hand Mr. Shorrock's evidence that drivers can and do drive up on the footway due to parked cars. The fact that this is not shown in photographs is unsurprising. Mr. Blacker also cites FOSS maximum recorded northbound hourly flows of 55 vehicles, concluding that the likelihood of coming face to face with an oncoming vehicle and having to give way is considered low. What he doesn't do is add the projected development trips to this figure, which for the same weekday period, 5 to 6 p.m, are at 11 in each direction, or evaluate this impact. Mr. Blacker confirms that he has witnessed poor driving practice, but not dangerous driving during the peak periods due to slow vehicle speeds. There's no reasoned evaluation about what impact the development trips will have on this. And Mr. Blacker resorts to bare assertion. He says, I do not believe that the proposed development would have a significant or detrimental impact on existing driver behaviour, practice or safety in the locality. He does not explain what that belief is based on. He does not explain why, for example, the addition of a new community of drivers who are less familiar with the road conditions, and in particular an increase in commercial vehicle trips, will have no significant impact. Mr. Blacker praises the Academy's management of pupil crossings, but again falls back on his belief that there's no significant safety issue with the current arrangement. His conclusion that proposed development would not have a significant impact on existing conditions is yet again based on unreasoned belief. His rebuttal does not address the proposed roundabout at all, which is extraordinary given that the appellant seems to place reliance on it. Mr. Blacker's beliefs also unreasonably discount the objective risks posed by emergency vehicles travelling down Blackhurst Lane at speed, additional vehicle movements during non-peak hours when speeding is more likely, and more commercial drivers who are less likely to be familiar with the road conditions, and despite Mr. Blacker's belief to the contrary, do tend to be under time pressure. Overall, the appellant has not presented a reasoned evaluation in answer to the Rule 6 parties' evidence, which is based on very many years of local observation and knowledge, and has not demonstrated that the proposal complies with MPPF paragraph 111. If, sir, nevertheless you consider that the proposal does comply, the inevitable additional development trips are a matter relevant for planning purposes, which may be included in the inspector's greenbelt balancing exercise and clearly weigh against a grant of planning permission, as the delegated report acknowledges. Moving briefly on to consider heritage, FOSS considers that the council has made an extremely strong case on harm to heritage assets, which it fully ignores. It's obvious that if the proposal goes ahead, the setting of Pembury Grange, and so its significance as a heritage asset, will be permanently and irremediably harmed. On a related matter, it became apparent during the course of the inquiry that the appellant would, contrary to all previous indications, object to the definitive map modification order recording a public right-of-way over the avenue, which is the publicly accessible part of the setting of Pembury Grange. This issue has now been resolved by an agreed condition, but the appellant's initial approach, going so far as to point out that the planning statement describing the avenue as a public right-of-way is not legally binding, and the question of the appellant's plans for the avenue if the DMMO is not confirmed doesn't matter, is symptomatic of a high-handed disregard for residents. The avenue affords access to the rural tranquility of the appeal site, and both matter to residents very much indeed. In the process of a public inquiry, it's easy to forget the people who say the least are those who will have to live with the harm if permission is granted. That harm clearly outweighs the proposal's purported benefits, and the inspector is respectfully requested to dismiss the appeal.
You okay, Ms. Bird?
Yes, sorry, so I was slightly struggling with my throat this morning. Excuse me.
Thank you very much, Ms. Bird. Thank you. It is now 20 to 1. Mr. Jones,
So he can hear you, sir. We're just having issue with his camera.
Okay, I just wonder where about the timing now, and if and when we should take a lunch break, and that depends on Mr. Jones's estimates of how long he expects to take in closing.
I can tell you that.
So it's 68 pages.
And I think it's going to be about.
Yeah, based on the council's was 50 and the timing, so at least an hour, if not a bit more.
Yes, I mean, well, if your balance is 68, you said.
Yes.
I think Ms. Lambert, yours was 58, but included a little bit of information.
Yes, I think it was about 50 without the extra
50, and your pace at reading was about an hour and a half. I think you were reading it out for.
I think so.
So I imagine Mr. Jones. Imagine you'd be an hour and a half, Mr. Jones. I imagine an hour is optimistic, but you might be a faster reader than I'm crediting you for.
He's agreeing at least an hour and a half.
An hour and a half. And I obviously don't want to stop you mid-flow as well. So I just wonder whether we should take a break for lunch and then hear from you, Mr. Jones. I don't know how the other parties feel about that.
We're happy with that, sir.
Ms. Lambert?
We don't mind that, sir. We just, as it's Friday and it's rather hot, we wouldn't mind if it was a shorter lunch break.
Yeah, okay, that's fine. Well, a 20-minute lunch break? Is that 20 to 30 minutes? Is 30 minutes? Is that?
That's fine for us.
It's fine.
30 minutes, Ms. Lambert, or 20 minutes?
30 minutes is fine.
30 minutes is fine. Okay, Mr. Jones, is that so? It is. Miss Miles has confirmed that's acceptable to you. So if she says it's okay, I presume it's okay with you.
I do what I'm told, sir.
You sound like you're underwater, Mr. Jones, but I'm sure you're not.
Sorry, the angle of the camera probably.
Not yet.
So it's 20 to 1 now, just gone. So shall we resume at 1:10?
Yes,
We'll
that's
hear
fine.
hear closings from the appellant. Okay. Okay, we'll take a 30-minute adjournment. Thank you very much.
Thank you, sir.
Good afternoon. It's now 1:10, so we shall resume. Mr. Jones, I've not had your closing submissions yet in writing. Have they been sent? Can people hear me? Lambert's nodding.
Yeah, I can hear you, sir. But no one else.
I think an email's just been sent, so it might be on that.
Okay. Right, I've just got it. Yeah, thank you.
Sorry, sir. Mr. Jones is just joining the video feed.
Oh, that's okay. Can you hear
Hey, Mr. Jones, I can see and hear you.
Have you got everything? Has Mrs. Miles has emailed closing, I hope.
I've got your closings, Mr. Jones. Miss Lambert, Miss Bird, have you got closings from the appellant?
Yes, sir.
Yes, sir. Thank you very much.
Okay. Over to you, Mr. Jones. Thank you.
Thank you very much. I managed just to put in a few little points in the text responding. So this is the preliminary observations are out of order. I just make this general statement and ask you to check your notes as to what was actually said by witnesses at the appeal hearing. We do not agree that the council's closing submissions represent an entirely accurate characterization that should be of the evidence, but rather than go through it line by line, we rely upon you to look at your notes and the recording. So it shouldn't be thought that we because I don't go through each line where we have an issue. A couple of general points is the approach to evidence. The fact that the witness evidence was not challenged at an inquiry, this is another inquiry, does not undermine its status that I have in respect of what Miss Lambert said about the evidence of Miss Venables, that it was agreed and not challenged. If anything, goes to its credit. But that the fact that another inspector may have approved an approach adopted in another inquiry does not mean that he or she has endorsed the approach adopted in the present appeal, unless evidence is led to show that the same approaches were adopted. That's not been done by the LPA in this case, but again, Miss Lambert repeated on a number of occasions why Miss Kirk's approach had been endorsed elsewhere, but there's no evidence, and we did raise this at the inquiry. If you're going to do that, you need to show that the exact same approach was taken. We don't know, we haven't seen the evidence. As to weight, so this is trite law, but you're entitled to give a less weight or no weight of evidence of oral evidence of unnoted conversations. And this is not only the conversations of Mr. Ireland with KCC, and you can do that without a finding of dishonesty. And you're also entitled to draw an adverse inference from the failure of the council to produce documents which they ask you to rely on. And again, I give other examples. What Miss Lambert has now called in closing a basic asset agreement, slightly different wording to what we were told before, with Network Rail. We've got no evidence of it, its terms. I'm not even sure, as we'll come on to see, whether the council even had it. Miss Lambert says less than substantial harm is this is in terms of heritage, is afforded considerable weight. But at para 199 actually says great weight should be given to the assets conservation. So just to note that. It's also said in closing by the council that Miss Kirk's approach at looking at, quote, the worst case scenario, you remember this is the winter view. Well, even if there is a winter view, and she didn't take did not view the site outside of winter when making her assessment, it's wrong to treat that as the position for the whole assessment. Obviously, you assess the impact overall, which is what Mr. Gibbons has done, and not take a worst case. For some months you can see it, and then you take the worst case to assume that's the year round. We say that's the wrong approach. Ms. Lamb has produced two substantial appendices, which is not read out. Obviously, it's not possible for me to proceed to go into it in detail. It didn't appear, this is the analysis of inspector's decision and the council's evidence or opening statement. But all we do know, what we do know, having looked at it on Beachmore Diving Centre, for example, there we see a 7.6 land supply, but care apartments allowed as very special circumstances in the green belt. So obviously, I'm not going to be able to respond to that substantial piece of work. As a matter of law, there is no prescribed manner by which very special circumstances are treated. The Court of Appeal have made it very clear it's not a mathematical exercise of the nature that Miss Lambert now seems to suggest in her closing. And it's wrong to suggest that any one particular category cannot amount to a separate very special circumstance. Miss Lambert was going along the decisions that we had and saying, oh, well, in that one, they've treated economic benefits with downsizing or right sizing, so they can't be separate. That as a matter of law is just simply wrong. And if you were to follow that, that would be erroneous. I mean, we note in Beachmore Diving Centre again, moderate weight was given to downsize, as they call it, rather than as a separate benefit, even though there was substantially more than a 5-year supply. And so if you compare that with the present case where there is no 5-year supply. But those decisions by your colleagues obviously all determine on their facts, and whilst we can get useful guidance from them, which all parties look to, obviously they're not setting down any legal tests. So those were just some notes, and that's why I'm afraid they're not very well typed. And apologies, I was just doing them, but I thought they'd be helpful for you to have at least something in writing. And I now turn to what was the beginning of the closing. Obviously, the appeal relates to the refusal by Tunbridge Wells Borough Council of the applicant's outline planning application. I'll come back to that in a moment. And we set out there what the application is, and it is for class C2. As an outline planning application, the appeal proposal seeks to establish the principle of the development of a C2 care community on the appeal site, along with the detailed means of access from Sandown Park. Now, in the light of the way in which the LPA has sought to defend the reasons for refusal, it is, we say, important to recall that outline planning applications are used to gain an understanding as to whether the nature of a development is acceptable. And this obviously, as you can appreciate, helps to ensure viability up front. And obviously, specific details, reserved matters, are confirmed and determined later. Planning permission should only be refused in respect of an outline matter which is reserved if the decision maker can be satisfied that the development is incapable of being made acceptable at reserved matter stage. And so we observe that that does not appear to have been the approach adopted by officers, both planning and in particular trees. Although we are grateful it was confirmed this morning that the woodland ground has gone. The detailed description of the appeal site is set out in section 2, statement of common ground between the council and the appellant. And the appeal proposal is described in section 2 of Miss Miles's proof of evidence. And it's also addressed extensively in the various technical reports that have been submitted with the application. Can I just make this point? Cooper Estates, the strategic land, the appellants, have a preemption agreement with Audley Villages. And I pause to observe that there's been no challenge from the LPA to the commitment by Audley Villages to the application. And again, the LPA also quite rightly does not challenge the deliverability of the site, this site, for extra care, should it get permission, nor the time scale by which this development could be delivered. And as we come on to look at what alternatives are said to exist, we suggest that may be quite relevant. Audley provide high quality retirement properties and care for older people, and they successfully manage 19 villages in the UK, including in many historic settings, including in the Green Belt. Audley Sandown Park is an example, both in the Green Belt and within a Grade 2 registered parkland, including as well as numerous Grade 2 listed buildings actually being located within it. The reasons for refusal were delegated powers for 5 reasons, as you know. The council withdrew the 5th in respect to renewables energy, accepting there that it could be dealt with by reserved matters, which was welcome, but does suggest an attitude at this authority that isn't in sync with the correct approach to outline applications. I won't read out the reasons. The Rule 6 party, from whom we've just heard of, Friends of Sandown Park, has formed, raised concern with impact of the proposal on the highway network, and in oral evidence this has also developed to an argument on highway safety. But of course the relevant Highways Authority, KCC, and the National Highways have been fully consulted and involved in the application process. Just pausing there as we'll come, one suspects that what is partly irksome for the Rule 6 party is in respect of other development that they may or may not have objected to, rather than the highway implications of this development. The application has not been refused on highway safety grounds or in respect of adverse impacts on the highways network. And it's agreed by all the expert evidence before the inquiry that the residual cumulative impact of the development would not be severe in accordance with the NPPF. These closing submissions seek to address these main issues, including the continued lack of a 5-year housing supply, the critical need for extra care accommodation nationally within the borough, and the lack of sufficient suitable deliverable supply to meet the critical need. Development plan, we have section 38.6 and sections 1970. Town and Country Planning Act require decisions are made in accordance with the development plan unless material considerations indicate otherwise. And the development plan comprises, and we set out the SAVE policies, Tunbridge Wells 2006, the Tunbridge Wells Core Strategy 2010, and the Tunbridge Wells Site Allocation DPD, the so-called SPAL. Now, a list of policies relevant to this appeal have been agreed with Council. However, many of the policies cited by the Council in the Statement of Common Ground are either, we say, not compromised by the proposal, the development complies with these policies, or will only properly become relevant at reserved matter stage and are not relevant to the main issues of this appeal, nor indeed were cited in the reasons for refusal. The agreed planning commissions will we think, assist in guiding future reserved matters submissions to ensure accordance with the current development plan policies. The Council's decision notice referred to the SAVE policies MGB 1 EN, 1 EN 5, 23 and EN 25, Tunbridge Wells Local Plan, and core policies 2, 4, 9 and 14 of Tunbridge Wells Core Strategy of 2010. Council's planning witness, Ms James, agreed these policies were the only policies relevant to determination of the appeal. The Council and the appellant differ on the weight to be given to these policies in some respects. Ultimately, as the courts have pointed out, the calculation of weight is not a mathematical exercise, and weight subject to a Wednesbury unreasonableness is a matter. I can delete it. Is a matter for the decision maker. The Council's development plan is very old, and the Council has evidently failed in its duty to accord with para 33 of the framework because the review of the plan has not been completed within 5 years of the adoption of the plan. Although it's noted, of course, that the Council has commenced a review of its plan, which has found that there is a significant need for additional housing, and that land must be released from the green belt, and major development must occur within areas of outstanding natural beauty in order to meet those needs. And we'll come back to that in a moment. The SAVE policies of the 2006 local plan were adopted 16 years ago, and the evidence base supporting that plan is older still, of course. Core strategy was adopted 12 years ago and covered a period that started in 2006. Its common ground development plan predates the MPPF 2012, and its housing requirement is out of date. Council argues this does not render all of its policies out of date. The weight to be given to existing policies. And I've got a footnote there. You can, I think, yeah, you can put a line, just a line through the footnote. That's just where I give the decisions that refer to appropriate weight. But as I say, I'm happy to deal with that with submission. Now it's been raised in closing. The weight to be given to existing policies is dependent on their consistency with the framework, and as explained at 219 of the framework, due weight should be given to them according to their degree of consistency. But it's also important that Council agree the housing requirement. It's also important that the Council agree that the housing requirement of the development plan is out of date when considering paragraph 11D of the framework. Footnote 8 is clear that policies which are most important for determining the application are out of date. And in paragraph 11D, that makes clear that includes for applications involving the provision of housing, situations where the planning authority cannot demonstrate a 5-year supply of deliverable housing with the appropriate buffer as set out in paragraph 74. As I addressed later, Ms James thought the LPA been unable to demonstrate a 5-year housing supply for 7 to 10 years. body of appeal decisions before this inquiry show that this LPA has made little or no impact on reducing the deficit over the last 3 years. The evidence thus before the inquiry is of that should be rather than an ongoing flat line on the level of continued non-compliance with the 5-year housing supply. More specifically, in respect of elderly care, despite the appellant's best efforts in 2016, the adopted development plan documents do not contain any policies that proactively seek to deliver accommodation for older people, and this is agreed by the council. It's disappointing that despite the work undertaken by the council in respect of the submission's local plan, this too is failing adequately to identify and plan for the extra care needs of the borough, with the council's position in respect of extra care need changing at the examination. At both the examination in respect of this appeal, the position is, that should be, that the sites proposed for the allocation by the council do not adequately, that should be, address the need that exists now or in the future. There is, I'm afraid to say, a combination of complacency and arrogance, which we've just seen replicated in the LPA's closing submissions. And we'll come to look a little bit closer at the approach of the council, which is relied on so heavily in closing. Only at a late stage, following representations and appearances by the appellant, has the council committed at the examination to make modifications to the plan and its policies, to tighten up the policies, as Mr. Ireland put it. Hence, the hurried, as yet, that should be inconclusive. Sorry, that's quite an important typo. Inconclusive negotiations with house builders. There's no commitments as yet, and you've heard the evidence. But this also includes a rewriting of both major allocation sites and a rewriting of the policy for the so-called cinema site. So, as of today's date, unless it's changed since yesterday, no redraft has been produced in respect of any of these policies upon which the council now relies. The emerging policies, that's the 2 allocations and also the site of the cinema, all of which at the EIP, the council has undertaken to redraft. We pause to observe the council's evidence base for the need, which is seeking to meet in its submission plan, uses a much lower prevalence rate, which even Mr. Ireland did not consider was appropriate. Mr. Ireland's explanation was that this was acceptable because the council were aware of the broader and narrower approaches to elderly care. But that was, it's not incompressible, it's incomprehensible nonsense. And it's repeated in the LPA's closing submissions today. I don't know what it means. It means nothing. They are using a lower prevalence rate as the evidence base for the plan that at the same time they submit shows that they are proactive. And even Mr. Ireland was not prepared to use that prevalence rate before you. And I simply do not understand. It is nonsense to suggest that you can somehow square the circle by keeping the same prevalence rate. But in any event, paragraph 27, in the context of this appeal now, it's clear that the submission plan is inadequate, both in identifying the need and proposing sufficient sites to meet that need. So the local authority cannot put before you any policy in respect to the 2 allocated sites or the cinema site, the wording which they are going to propose. That's where we've got to at the EIP. So you can't, with respect, put any weight on those policies. As This provides the context for the appellant's position in terms of weight to be afforded to policy and development plan, citing the council's reasons for refusal. And I'm going to go through this. Ultimately, sir, you'll put your own, first of all, weight on the policies, and then the weight on whether you find that development complies with or doesn't comply, and to what degree it doesn't comply, and what weight should be given. But Mr. James for the LPA argues that significant weight should be attributed to those policies, and this is MGB1 and Core Policy 2. This is the Green Belt. Ms. Miles argues that limited weight should be given. The first sentence of Safe Policy MGB1 refers to the openness of the Metropolitan Green Belt to be preserved, and no development would conflict with the purposes of including land within it will be permitted. And whilst the first criteria states the general extent of the green belt will remain for the plan period, the submission local plan includes the release of land from the green belt. The council has acknowledged that its housing need cannot be delivered on non-green belt land, and that includes non-AONB land, and cannot be delivered on brownfield land alone. Now, obviously the council considers exceptional circumstances exist to release land from the green belt, and that's a matter for your colleague to consider. But if we bring this context back to Safe Policies MGB1 and Core Policy 2, it is clear that the council recognise that significant development must occur within land that is presently green belt. The council acknowledges in order to meet the current housing and elderly care need as well as future, there is no alternative but to use land which is currently in the green belt. So we do say it is right that limited weight is attributed to these policies in that context, because if there is delay, which there is going to be delay with the redrafting and things of policies, but in any event the need is now, the council accepts that in order to meet the need, land which is at green belt now will be used, and it has to be treated as green belt now. So you, sir, know that as matters stand, with no adopted submission plan and objections and other issues, that in order to fulfill the need, one has to look at the green belt, and that would be on very special circumstances basis. Turning then to EN1, Ms. James argued that full weight should be attached to this policy, but accepting the rebuttal, the conflict is only alleged against criteria 3 and 4 of this policy. Actually, we can take out which require. I think I took out, but it's to be noted that the precise conflict was not identified in the officer's report itself, nor in the reason for refusal. And this may be indicative of the actual weight which the LPA gave this policy in the determination of the application, given that it's only in the rebuttal that we see 3 and 4 criteria even addressed. Miss Miles considered that appropriate weight should be given to this policy because it is broadly consistent with the framework, but is more applicable at the reserved matters stage. Miss Miles concluded that the policy should be afforded moderate weight. This approach is entirely lawful, and despite a lot of time spent cross-examination and now in closing, no authority has been cited by my learned friend to show that the approach of Miss Miles was not lawful. I mean, more troubling on lawful, This is the approach of the local planning authority. The LPA comments on the indicative plans, but has significantly avoided calling evidence to say that there is no possible set of reserve matters which would be acceptable at the reserve matter stage. So with regard to criteria 3, Ms James acknowledged that the appeal proposal is made in outline, but has attached significant weight in her decision to the illustrative material and seemingly ignores the fact council will have control over design, scale, layout and landscape through reserve matters. Ms James also appears to be under the impression that all buildings will be built to the maximum height parameters, which clearly would not be the case when consideration is given to the submission documents. The appellant sought to agree a condition with the council to reduce the maximum height parameters to 12.78, but this was rejected by the council. However, you'll see the wireframes included within the evidence of Mr Gibbons clearly demonstrate the development would be barely visible at the model height set out in his figure 6, appendix C to his appendix. The appellant concludes that a reserve matters stage compliance with SAVE policy EN1 is capable of being demonstrated. And again, as I said, no comprehensive evidence has been produced by the council to gainsay that. Ms James also now argues the proposal would result in significant harm to the landscape character of the area and that the site is an important space. Hence, she finds conflict with criteria 4. Ms James claims that the site is an important space relating to Pembury Grange, which of course is not to be lost. However, there's no loss of a building through the proposed development, so there's no loss related space. The site has not been within the same ownership as Pembury Grange for most of the 20th century and now beyond, as is demonstrated by the heritage evidence. The site is also not subject to any space or other designation and is agreed to be private agricultural land. The appellant therefore disagrees that there's any conflict with this criteria. Overall, the appeal proposal, can we say, accord with SAVE policy EN1. SAVE policy EN5, development of conservation area. Ms James considers full weight should be given to SAVE policy EN5. Ms Mars considers that appropriate weight should be given to the policy because it's broadly consistent with the framework. And Ms Mars explained that the policy should be afforded moderate weight in the planning assessment. In any event, there's no conflict with the requirements of the policy as discussed in the evidence of Mr Hawking. And that is a different issue to which we will go to in a moment. SAVE policy EN13, tree and woodland protection. Again, Ms James attached full weight to this policy. It's to be applied to reserve matters today. Will also be applied at the reserve matters stage, which will follow the grant of outline planning. Ms Miles attaches moderate weight for the outline stage. And as we've seen this morning, part of the issue relating to the woodland protection is to be dealt with in precisely that manner. The evidence of Mr Prophy, the arboriculturalist, called by the appellant, demonstrates that the appeal proposal would not damage or destroy trees protected by TPO or ancient woodland. The second part has obviously fallen out this morning. As such, the appellant contends that the appeal proposal accords with this policy. Turn then to important landscape approaches, EN23. Ms James in this considers significant weight should be attached to this policy. Ms Miles considers only limited weight should be applied. It was agreed by the council at the site visit that the appeal site was approximately 318 metres from the conservation area on Pembury Road. And Mr James helpfully pointed out that the actual boundary of the conservation area where the actual where the 380 meters is measured from is within the field to the north of the road. So that therefore the actual distance from the important landscape approach to the appeal site is clearly in excess of 318 meters. As the inspector will have seen on the site visit, there are not only retained fields along this important approach, but there are topical changes, significant existing vegetation. And I just summarize what it leads Mrs. Gibbons to conclude that they wouldn't be visible from Pembury Road, or there'd be barely a glimpse in winter. So we'll come back to that, but in a moment. EN27, development control criteria for all new development proposals affecting rural landscapes. Both are agreed this policy should have full weight. The council attached modest weight to this policy, whereas the appellant attaches, should not have full weight. Council attached moderate weight and the appellant attaches limited weight. Appellant's evidence demonstrates that when one has regard to the criteria of the policy, proposal is capable of according with the policy because the development will have a minimum impact on the landscape character of the locality and not result in an unsympathetic challenge to a character of a rural lane, which is of landscape amenity and nature conservation or historic or archaeological importance. The council also agreed through the statement of common ground that neither Blackhurst Lane or Sandown Park are defined or designated as rural lanes within the rural lane SPG. Core policy for environment. This policy is afforded significant weight by the council. The policy is engaged because of the sites, there should be apostrophe there, location in the countryside and setting of the area of outstanding natural beauty. It is important to note that the policy does not preclude development that would cause harm. There is no blanket ban on development. Paragraph 5.38 of the supporting text states this policy seeks to ensure the delivery of new development, such as for housing, retail, and employment, is balanced against the need to conserve and enhance the character and distinctiveness of the borough's natural and built-in environment in terms of the intrinsic characters and the diversity of the landscape, its biodiversity and its geodiversity and its heritage status. As such, the policy requires that a balanced approach be taken. The appellant's evidence, Mr. Gibbons, Mr. Hawkins, Mr. Brophy, demonstrate that it will conserve the rural landscape, including the ANOB. It's also demonstrated the proposal would result in no loss of biodiversity. And the council has agreed that significant weight should be treated to the 21% net gain. Core Policy 9, Development in Rural Tunbridge Wells. Council and the applicant agree that the limited weight is attributed to the policy because the housing requirements set out within the policy is out of date. Council also acknowledged that criteria 3 to 7 are not relevant to the appeal. Development then in villages and rural areas. Council agreed and the appellant that only limited weight is attributed to policy because of the housing requirement set out within the policy is out of date, and the policy seeks to restrict development to the limits to built development, which are being reviewed as part of the submission local plan. The council also accepts that the requirements to protect the countryside for its own sake is also out of date and not in conformity with the framework. The inspector in the recent High Hill appeal also agreed this policy was out of date and should be given limited weight. Notwithstanding the above, we do say these policies must also be considered in the context of para 11(9) of the framework, which states that where there are situations where the local planning authority cannot demonstrate a 5-year supply of housing, and it's agreed that there is a 4.6 supply in the case, then the policies most important for determining the appeal are out of date, and the framework requires that such circumstances planning permissions are granted unless the two specified conditions apply, which we see there. It is a so-called tilted balance, and the objectives of that balancing exercise is to rectify the lack of 5-year housing need. It is clear and agreed the council does not have a 5-year housing supply. And as stated above, Miss James said she can't recall a time when the council has had a supply. She settled on a time frame of at least 7 to 10 years. Whether the shortfall is small is a matter of disagreement, discussed further below. But for the purposes of para 11D, it's sufficient that tilted balance is triggered by a footnote of the framework, unless para 11(9) Roman 1 and footer 7 provide a clear reason to refuse planning permission. Footnote 7 of the framework includes design heritage assets, designated green belt and area of outstanding natural beauty, and irreplaceable habitat. Sites within those areas are not automatically excluded from the tilted balance. However, development on site such areas must pass the policy tests in the relevant provisions of the framework. And there's no clear reason to refuse permission. In this case, this requires the appeal process to pass the following tests, and we set them out there, which you're familiar with. Not an inappropriate development if it is very special circumstances, etc. So I won't read those bullet points out. It's about it being sensitively located, designed, and there will be no degradation or loss in the ancient woodland. The appellant accepts that the appeal process is inappropriate proposal, is inappropriate development in the green belt, and therefore is by definition harmful to the green belt, and substantial weight must be given to that harm. The appellant accepts there is a spatial infringement on the concept of openness, and there would be a visual impact on a small area of countryside surrounding the site as a result of permanent development on the site. But it is now agreed that there is no indivisibility between the appeal site and Pembury. Or indeed between the appeal site and the Oldsness Wood site. It's also agreed that Tunbridge Wells Hospital is not within the development limits of Pembury. The extent of development, the extent of visual impact and the perception of change as a result of the proposed development be very small, and that given the nature of the environment, of the containment of the site, including its vegetated boundaries and the presence of the A21 dual carriageway, we say that development on the site would not constitute unrestricted sprawl of the built-up area. We'll come to this a bit later on green belt. As such, the appellant will ask you to conclude that the actual harm to the green belt is low, and whilst there is additional harm, it does not materially add to the substantial harm already attributed against the development by virtue of its inappropriate status. So in other words, substantial harm for policy harm, we then have very limited harm, and when added together, we still say it's in the broad range of substantial harm. You don't change change the weighting, and so I suggest to you that's perfectly lawful, and that's an approach followed by your colleagues up and down the land. The appellant's evidence is on the facts of the case. The harm to the green belt and any other harm resulting from the proposal can be outweighed by the very special circumstances in this case, and that the site's green belt designation does not provide a clear reason for refusal. The appeal site is agreed to be outside of, but within the setting of the High Wood area of outstanding natural beauty. Great weight is given to the designation of an area of outstanding natural beauty in the line with para 176 of the MPPF. Paragraph 176 does not place a prohibition on development, even major development, within areas of outstanding natural beauty. In fact, major development can be allowed in the areas of outstanding natural beauty where exceptional circumstances exist and the development is in the public interest. Para 176 states that development in the setting of an area of outstanding natural beauty should be sensitively located and designed to avoid or minimize adverse impacts on the designated site. The appeal site is sensitively located and would be barely seen, as we will see, from the area of outstanding natural beauty, with intervisibility between the appeal site and the area of outstanding natural beauty being negligible. There are certainly no long or important views from the site from the area of outstanding natural beauty. The proposal is situated on a contained site, and that by retaining the existing woodland, which we shall do, and landscape features, together with the proposed mitigation, to which I will return in a moment, the development would naturally reflect the character of the surrounding landscape. As such, the appeal proposal is considered to be sensitively located and can be designed to minimize the adverse impacts on the AONB. And the site's proximity to land designated as an area of outstanding natural beauty does not provide clear reason to refuse planning permission. So, moving, we accept also that the site's located within the setting of Pembury Grange, grade 2 listed building, and it's also agreed that the appeal site is within the setting of Pembury Road character area of the Royal Tunbridge Wells Conservation Area. Great weight is given to the conservation of both Pembury Grange and to the significance of the Pembury Road Conservation Area. The proposal, however, would result only in a negligible harm of less substantial harm to the setting of Pembury Grange, and would have a neutral impact on the significance of the Pembury Road Conservation Area. On the facts of the case, and whilst attaching great weight to this less than substantial harm, this is outweighed by the benefits of the proposal, and as such, para 202, we say of the framework, does not provide a clear reason to refuse permission. The evidence presented supports the position that the illustrative scheme can be implemented without the loss of existing sustainable trees, nor would it propose an unacceptable threat to health, vitality, or future sustainability range of retained trees once in operational usage. The location of the 15-metre buffer to the Ancient Woodland was agreed by the council at the appeal site visit, and agreed that it reflects a minimum buffer as required by Natural England. The 15-metre buffer, now agreed, is also consistent with the location of the buffer shown on the application plans from the outset. As such, there will be an allocation. As such, there will be no degradation or loss of irreplaceable habitats. So no harm to the ancient woodland. And as such, para 180C, the framework is not engaged, so cannot provide a clear reason to refuse planning permission. Just got to make sure my glasses are clear. Sometimes. So, paragraph 59, the effect of this then is that there's no clear reason to refuse planning permission. And again, we say the presumption can apply. The examination of the submission local plan is underway, and although examination has progressed, as we've given in evidence and informed you, sir, the inspector has declined invitations to make a formal ruling that the council has discharged the duty to cooperate. Ms. Miles has attended, presented at the examination, has heard the objections of many others at the plan. It's quite clear that at minimum, major modifications to the plan are going to be necessary to address the many shortcomings, both evidence-based policy formulation, and it's only if the plan proceeds before beyond examination. At the earliest, you've heard, sir, the next spring before the council's in receipt of the inspector's report. Plan as such, overall, quite apart from anything else, little weight can be attached to its policies. Nonetheless, the submission local plan does confirm that land must be released from the green belt along with the allocation of major developments within areas of outstanding natural beauty in order, we say, to meet the needs of older people. So heritage, so that we can turn away from the tilted balance, which and deal with heritage. And I'll deal with this, I hope, sir, relatively shortly. You've got the evidence, you've been on the site visit, you've been into the houses, into the flat, and you walked the site. The round table successfully covered a number of points. The LPA remains of their revised view that proposals will cause a medium to high level. We say revised, big emphasis has been made, I think, by my only friend, of decisions made either for or with officer recommendation. And in this case, we're a decision we're appealing with the officers. But the position here is that there was a shift by the officer from her report, as you know, from medium to high, and that, it's said in evidence, is to do with the discovery of the documentation. We'll have a look at that and see whether that is a credible position. The Pembury Grange, the appellant's built heritage consultant set out, I hope you'll feel helpfully, the extent and character of the setting of Pembury Grange, and that it's significantly changed over the 20th and 21st century. Post 19th century changes to the areas have altered the way in which the elements of the building present setting contribute to its significance. A site which has not been maintained as parkland or having been jointly owned with Pembury Grange and for no longer than the estate existed makes a low contribution to the significance of the building. This limited contribution is made through the site forming part of the building's edge of settlement concept. This was the view, or the position of the appellant's heritage consultant when completing the original application, built heritage assessment, which the conservation officer response described as thorough and compliant with the paragraph 189 of 2021. You'll recall at the round table, we drew attention to that fact, that it was like in that respect, it has been clearly this assessment has clearly been analysed and regarded as compliant. The legibility of the extent and character of the former estate relied upon by the LPA now rests largely with archival documentation. The LPA correctly identifies that these sources are an element of the listed building's historic interest, but does not sufficiently take into account of changes on the ground on the way in which the building is experienced. It is now possible to approach Pembury Grange without passing through or being highly aware of the late 20th century suburban character space of Sandown Park, while some elements of the former estate do survive and may be understood as being related to the listed building with the aid of documentary sources. They do not form part of the enclosed close setting within which the building is now most readily appreciated. There are no views to the building, for example, from the trackway that bisects the site. Its present not being appreciable until one has already passed several modern residences on Sandown Park. So you'll have experienced that on your site visit and formed a view. Pembury Grange has itself undergone changes of use, first as an institutional home for the aged, then conversion for multiple occupation. The split up private gardens allocated to each of the current occupants is illustrative of the area's wider change. I should have an apostrophe in that area. Apostrophe's wider change to support modern residential developments, modern residential use. The proposal would not alter the intrinsic architectural historic interest of the building, as plainly vested with its surviving built fabric, nor would they diminish the ability to appreciate the interest from its several private gardens or a Pembury Grange or Sandown Park. The very limited, negligible degree, less than substantial harm identified by the appellant's heritage consultant, Mr. Hawkins, arises from the general change of character of the site and has been given great weight in the assessment of potential impacts and should weigh against the many public benefits of the proposed development. So the conservation area, in regard to the impacts on the significance of the Royal Tunbridge Wells conservation area, the assertion of the local planning authority that a low medium degree of less than substantial harm will be incurred, we say, is just unreasonable. The site forms no part of the way in which the conservation area is experienced, and as set out in the appellant's, we seem not to like apostrophes, the heritage landscape evidence, the proposal simply will not change the experience of being within the conservation area. The closest character area is highly linear, and while many short and intermediate views to adjoining woodland and pastoral spaces contribute to its significance, the site is not one of those appreciable setting elements. So the proposals are considered to represent a neutral impact to the significance of the conservation area as a whole, and they will not alter the ability to appreciate the distinctiveness of its various character areas legibility of their relationship to each other or their individual architectural and historic interest. No adverse impacts are considered to arise to the significance of the conservation area. So green belt, we do of course, I mean, recognise that the proposal represents inappropriate development in the green belt, and there would be harm to the four relevant purposes, including land within the including land within the green belt. However, we're in conflict with the council as to the nature and the size of that harm. We say the overall harm to the green belt would be low, and Miss Miles deals also with very special circumstances we'll deal with later. Mrs. Kirk in cross-examination agreed in cross-examination the appeal site represented only 23% of the area of parcel TW5, and that development of the appeal site would be less harmful than development of the whole of TW5 in both spatial and visual terms. She agreed with a statement of para 3.7 of stage 3 green belt study that the release of larger areas clearly has more potential to weaken the integrity of the green belt by extending into land. Mr. Gibbons says, Mr. Gibbons says it's also highly relevant to whether harm will be localized or spread into adjacent areas. That is what we talked about, the wider countryside. Miss Kirk agreed, and we had lots of conversation about the wonderful A21, and its containing tree cover is a key element in separation of settlements, and recognise it as a form of boundary. She struggled, however, to agree that the fields immediately adjacent to the A264 Pembury Road that give the sense of openness that are referred to and referenced in the text of TW5. She did agree, though, that visual aspects are relevant, and accept that she had not undertaken an assessment of effects in summer. Now, this is now defended on the worst case scenario, but for the reasons I've already indicated, that approach is plainly flawed. You've got to look at it in the best way and most accurate way that you can. She agreed the site is located on a ridgetop plateau and is relatively flat. Mr. Gibbons was clear development of the appeal site would plainly have a lesser effect on the greenbelt than the release of the whole of TW5. Boundaries. It's agreed that there are no agreed or nationally agreed approach to greenbelt assessment. We're not proposing, as you said, to amend the greenbelt through this appeal, but we maintain that the physical boundaries are an important element making any judgments on harm. Whilst we have a weak boundary at the southern southwest corner of the appeal site, planting is proposed, and you heard from Mr. Gibbons on that, which will strengthen this boundary. And this approach is consistent with the similar approach taken with the Council Stage 3 Green Belt study. And you'll recall that from Mr. Gibbons' cross-examination. So could you also obviously note, as you will, that obviously our site was not subject to the Stage 3 examination, because that was reserved only for those that sites the council was contemplating bringing forward. That is a matter of objection by a number of parties at the EIP. Mr. Gibbons, in examination chief, explained that Mrs. Kirk, or Mrs. Kirk, had adapted the council Stage 3 Greenbelt assessment. This is a 3-step process which considers boundaries as part of step 2. However, Ms. Kirk had admitted step 2, which considers the outer boundaries of the site. Indeed, Mrs. Kirk stated in examination in chief and in cross-examination that boundaries are not relevant. That's an issue we've got between us because Mr. Gibbons explained boundaries are highly relevant. He confirmed that in examination in chief that a strong boundary will reduce any harm to the surrounding green belt. Indeed, Ms. Kirk considers existing green boundaries to be important, but ignores other boundaries if they are within the green belt. We say all boundaries are important when considering level of harm. It's obviously relevant, we say, it's a matter of common sense to consider the boundaries of the site when assessing the level of harm. Mrs. Kirk agreed there is a connection to Sandown Park on the western boundary of the site. She also agreed that in terms of the site, the northern boundary is strong. She agreed the eastern boundary is also strong. And we also had the A2 and the issue there with the trees. You will see, sir, how long it takes a tree to grow, but you had evidence from Mr. Gibbons in the end of seven years. The southern boundary, Ancient Woodland at the southeast corner. It's about 20 minutes walk, 20 meters wide. Sorry. Yeah. On the southern boundary, we have the Ancient Woodland at the south east corner, which we now reached agreement on. You've got the woodland in the centre, and there is a circa 20 metre wide area of woodland, a moderate feature. There's a disagreement between Miss Kirk says it's weak, then later agreed to moderate. It is the weaker boundary is at the southwest end, but that is, as I said earlier in closing, where we're looking to undertake planting to close the boundary. And as I said before, and I've given the reference in the closing, that is a similar approach was taken in the stage 3 assessment of sites by the council. Mrs. Kirk agreed the inspector should take the proposed planting into account. And we obviously invite you, sir, to do so in that assessment. I've spoken about indivisibility. It was an issue that initially seemed controversial, but then agreement seemed to break out, which was good. Mrs. Kirk agreed no indivisibility between the site and Pembury. Mr. Gibbons agrees and says it's a key element. Mrs. Kirk also agreed no indivisibility between the site and allocation south of Pembury. She also agreed no indivisibility between the appeal site and Owl's Nest Wood. It's agreed that Tunbridge Wells is not in Pembury or in the limits to built development and not inset in the green belt. And the green belt washes over, and that Owl's Nest is also not in Pembury built development limits. It's now agreed also that none of the hospital, Pembury or Owl's Nest, are in the agreed ZVI. So there was actually, although it emerged more in the round table, an agreement of Mrs. Kirk coming in this extent closer to the position of Mr. Gibbons. The countryside, in terms of impact on the countryside, Mrs. Kirk agreed we're looking at impact on wider as well as locally to the site, And again, we give the reference to the Council Stage 3 Greenbelt Study, paragraph 3.7, which takes that approach. And she agreed that distance is also relevant. And again, on the Greenbelt Study, para 3.6, harm will typically increase with distance from the settlement edges. In terms of openness, it is accepted as a matter of law that there is both a spatial and visual aspect to openness. Can I just pause there, because I think Miss Lambert then made a submission where she said Mr. Gibbons wasn't able to draw attention to any case authority where you could give an overall assessment of both the spatial and visual impact. I'm not sure this goes anywhere, but there isn't any authority to say that it is unlawful to take an overall assessment. And actually, if you look at the Court of Appeal decision that's in your bundle, sir, the one I've already referred to before, in opening and implicitly on the mathematical, not to use a mathematical formula, the assessment of openness as well is not something that is carried out in a sort of mathematical slice. You look at various elements, and there's plenty, again, of appeal decisions where your colleagues wrap the two together. So we accept that there will be a clear, so the short point is there is no legal error that Mr. Gibbons has fallen into, quite the reverse, nor actually is there anything really suggested by Miss Lambert that he has. She's just said he hasn't pointed to an authority that says you could do X. Well, that doesn't mean you can't do it. And indeed, as I say, it's entirely keeping with the Court of Appeal's approach. We accept that there will be a clear spatial infringement of the concept of openness. There will be visual impacts on the site and on a small area of the countryside surrounding the site. However, delete the extent of visual impact of the proposed buildings would be very small, and that of the perception of this change, and therefore the perceived harm to the essential characteristics of openness would be very small. Although clearly on the site itself, that is different. And that's the other aspect, sir, that you're aware of. And I've given the references to Mr. Gibbons' proof. And that is, we are looking at the impact on the landscape, on the locality. And that plainly is different than if you were just looking at the site. Although the site is part of the wider countryside, it's part of the locality, but clearly it's not a question, and nor are the reasons for refusal referenced by the site. And then the Greenbelt study referred to perceived openness. So far from being an eccentric or acting wrongly, Mr. Gibbons is in explaining the limited perceived impact. He's using a concept which is used in the Council's own Greenbelt study. So turning then to purpose A to check the unrestricted sprawl of large built-up areas, we say the development on the appeal site would not constitute unrestricted sprawl and would have limited conflict with this Greenbelt purpose, would form a natural, well-planned extension to the existing urban edge that would relate well to both topography and land use, and would be naturally contained by features which serve to check unrestricted sprawl in the built-up areas beyond the appeal site. Furthermore, the A21 to the east, with its associated cutting, woodland and woodland beyond, the large area of woodland and the area of outstanding natural beauty designation to the north, and the ancient woodland to the southeast, would form strong edges, as we've said, to the built-up area, and the existing woodland alone along the southern edge of the site, and proposed planting along southern edge boundary, which we've mentioned, will make a firm edge, restricting further sprawl. And that's overall, the appeal site makes a relatively weak contribution to this green belt purpose. Mrs. Kirk's accepted that good defensible boundaries are relevant to preventing unrestricted sprawl. And we say that must also therefore follow when one's looking at development, albeit inappropriate development within the green belt. The word unrestricted sprawl must bring something to the party. It's not just inappropriate development, it's unrestricted sprawl. And you'll recall I debated that with Mrs. Kirk, cross-examination. But we do say that she misunderstands the word unrestricted, and probably also I would add in, if you could add into your notes, and also sprawl. And that's why we've also got that difference about boundaries. Something that sprawls, unrestrictedly is not a site in our submission, my submission, that would have tight and well-defined boundaries. That is, you wouldn't look at it and say, oh, that's unrestricted sprawl. So we do say that the site is well contained, and that's not just topographically to Sandown Park. It's separated from wider countryside by vegetation, also topography. And also, as a consequence of effects of sprawl, are limited to the site. Obviously, it's inappropriate development. If it wasn't, we wouldn't be looking at any of these issues. But it wouldn't represent unrestricted sprawl because of its containment. As Mr. Gibbons stated, the site is connected to the urban edge, also due to the perception of its context. And we see that both in terms of its use and its proximity. I say its use, the use of, which we've just heard about, the pathway and people going. So that the use and what you'll have seen on sites which Mr. Gibbons has given evidence about. B, which we've touched on, to prevent towns merging into each other. It is towns. We accept, for these purposes, that Pembury is a town. Not sure why, but it is not in fact a town, but there we are. So we've accepted that it is, but and applied the analysis. The appeal site proposals would have only a very small effect on the physical gap. You'll see 8% in Mr. Gibbons' evidence between the gap between Tunbridge Wells and Pembury, and there would be no perception of the towns merging, town and village merging, or the merging with the hospital garden centre or Owl's Nest proposals as a consequence of the nature of the topography, the strong physical barriers created both by the A21 and the A264 Pembury Road, and the associated vegetation. So just to add there, it is towns. So although we don't accept that there would be any perception of merger with the hospital, even if they were, that wouldn't offend the purpose of the green belt. Of this purpose of the green belt, which is to stop the merging of towns, and that is different to developments over which, whether it be a hospital or a little hamlet or whatever, the green belt washes over. But in any event, we don't accept that it does cause any material harm to any gap between Tunbridge Wells and the hospital. We say as well, Mrs. Kirk, although I put him has misunderstood the concept of indivisibility in her evidence. And as we said, there's no indivisibility between the appeal site, Pembury, and no indivisibility with the proposed allocations to the south, Pembury, as erroneously suggested by Ms. Kirk, and also due to the strength of the intervening features, no indivisibility between the hospital at Owlsdale Woods and the proposals. Similarly, there's no location where the appeal site proposals and the town of Pembury would be seen in combination. And I do say, well, it's not for me to say, but Mr. Gibbons has said, you will form a view, that there's only the barest potential for a glimpse of both the hospital and the appeal site proposals in the winter. There'd be little perception of the change in the gap between the towns within the landscape and no sense whatsoever of the towns merging. And we do say that the appeal site makes a weak, straight, no contribution to this green belt purpose. It is on neighbouring towns merging, not coalescence with built development elsewhere, and I already touched on that. It's focused, the NPPF, on neighbouring towns merging. And I'm repeating what I said off script just a moment ago, but Mrs. Kirk did agree Pembury Hospital is not part of a neighbouring town, but wriggled here as she said it was in the gap. She agreed that Pembury Hospital is not between Pembury and the appeal site. She agreed that indivisibility is a material consideration, and that there is, as I've said, only the barest potential glimpse from a short section of the Pembury Road in winter, and no potential for summer views. Lack of indivisibility is key to perception of various of the green belt purposes. Perception of openness, for example, is affected where one can see it from the A264 Pembury Road, and there would be no sense of any change to the perception of openness. In terms of merging, as can be seen from the Pembury Road, there is only potential, the tiniest glimpse of development on site and tiniest glimpse of the hospital. Glimpses only at a very lowest level of effect. It's agreed that the hospital is not in the town of Pembury. In terms of merging, the physical difference in distance, as I've said, is would only be an 8% reduction, so that's physically. In terms of visibility, no combination, as we've just seen, of visibility. We accept the spatial infringement of the concept of openness, and we don't know how many times Mr. Gibbons has to say it, because he's always being accused of only looking at visual. But the assessment in Mr. Gibbons' proof is entirely consistent with stage 2 Greenbelt assessment. It considers boundaries as part of the overall assessment of potential harm. Lack of visibility and strong buffers in terms of potential for merging clearly provide separation between the two. And no indivisibility whatsoever means that there is no perception of merging as a consequence. The Owl's Nest as well was known about when stage 1 study was done. It's acknowledged within the stage 1 Greenbelt survey. So clearly when they did stage 2 study, they must have known about Owl's Nest and considered it. And Mr. Gibbons considered it in his proof in any event. In terms of allocation, south of Pembury, no intervisibility between the site and the allocations, so would have had no effect on the stage 2 study for the parcel of TW5. The Owl's Nest is also well contained, very wooded site, so no visibility as a consequence. Also, the Owl's Nest is not proposed to be taken out of the green belt. In terms of safeguarding countryside from encroachment, we acknowledge that the site clearly has characteristics of countryside as it's currently under agricultural use, but we say there are urbanising influences in the landscape surrounding the site. Sandown Park, A21, Hospital Garden Centre, etc., that reduce the sense of the landscape around it that sit as being countryside. Due to the containment of the site, there are no long views to the wider countryside, and this lack of visibility reduces the extent to which the site is associated with the wider countryside. This is urban fringe, as Mr. Gibbons referred to it, land, not open countryside, and the appeal site makes a relatively weak contribution to the purpose of safeguarding the countryside from encroachment. Mrs. Kirk agreed it's relevant to see how the site relates to the wider countryside. Strangely, however, she did not agree that if a site is widely visible, it would encroach more into the countryside. So I put an exclamation mark there. It's a bit like Mr. Ireland and his prevalence rates. It's incomprehensible to me, but matter for you, but I respectfully suggest that it is comprehensible. Mrs. Kirk did agree that urbanising influences are relevant. She agreed the site is located between suburban area of Sandown Park and the A21, but also adjacent to the rural landscape to the north and south, and did agree all are relevant. There is, as you will see, a difference of opinion as to the extent, and you have Mr. Gibbons' evidence, which I will invite you to prefer, having now been on the site visit. With one small exception of mention of links to the countryside north-south, Mrs. Kirk has simply accepted the TW5 stage 2 assessment. Mr. Gibbons, and so you will recall the effects of release of the appeal site, we say, and Mr. Gibbons say, would be less than the release of the whole of TW5. Bizarrely, again, Mrs. Kirk would not agree. Again, that we are happy to leave that to your judgment, but we say again, this is another, frankly, nonsensical approach taken by the council's witnesses. They may not agree with us, but it is simply untenable to suggest that the removal of part of it can have a bigger effect than the whole, particularly when you've seen the site, which clearly has a characteristics. It's urban fringe in terms of proximity, and we rely on Mr. Gibbons' evidence to say that its impact on the wider countryside is more limited. The boundaries are relevant here as well because they provide separation, and there's no connectivity such as provided by the Pembury Road in the text of TW5. There's no such connectivity provided between the appeal site and the wider countryside. Containment is so strong that there are no views to the wider countryside, and there are only relatively short views looking towards Pembury Road. No long views into the wider countryside. And again, that's all by reference to the evidence of Mr. given. In this respect, the ZVI is relevant insofar as there's a very small part of the countryside where there would be a perception of change, and that's Mr. Gibbons' evidence. Relationship to wider countryside is highly relevant. The methodology of stage 2 assessment for purpose 3, page 24, makes constant reference to wider countryside. And we say this site is rural edge, or what Mr. Gibbons has called peri-urban, and so not deep countryside. And we do stand, and you'll recall the cross-examination, that the dual carriageway is a strong boundary feature. Finally then, purpose, historic, deal with very shortly. Parties are in agreement that the appeal site makes a relatively weak contribution to this purpose of the green belt. Landscape and visual issues, and as I said before, the reason refusal states in terms of landscape and visual, significant harm to locality, not to the site. It is agreed that there will be effects on the site itself. Of course there will be. And on the character of Sandown Park, the track which passes between the two parts of the site. But many of the characteristics of the site, such as mature vegetation, will be retained. We say the effects on the overall character of the landscape surrounding the site will be very small. All landscapes have value, but this is a locally valued landscape. It contains elements of value, the ancient woodland, which we dealt with, mature trees, listed building at Pembury Grange. But it's not a designated landscape or a regionally or nationally valued landscape. The site is not part of registered park and garden or in the compendium. There are no ecological designations and no long views or key points to the area of outstanding natural beauty. The integration and compatibility of the proposals with its surrounding landscape is key to consideration of effects on landscape character. We say the scale massing of the proposals in principle would be compatible with that found within the surrounding landscape. Proposals will integrate with the character and the surrounding landscape, which is characterised by both the A2 and development within Sandown Park and around the hospital and the garden centres. And as you'll recall, the debate, compatible does not mean the same as this is also an outline planning permission where scale and other matters are reserved. You have got my submissions on the approach that should be taken. It's one of having to be satisfied that there is no application on reserved matters in terms of scale that can overcome any in principle difficulties. We say the council have inappropriately relied on their sensitivity assessment, which applies to a larger area, which we touched on just a while ago, for TW5, which has a particular focus on the importance of the fields adjacent to Pembury Road. We say the site plays no part in the contribution that the fields immediately north of Pembury Road play in contributing to the perception of a gap between Tunbridge Wells and Pembury in either green belt or landscape sensitivities terms. And you'll recall that debate, I'm sure, and you'll recall from your site visit the position of those fields. There's a fundamental difference between Mrs. Kirk's approach to landscape assessment, which focuses on the effect on the site, and the approach of Mr. Gibbons, which focuses on the effect of the character of the landscape as a whole. We say Mr. Gibbons' approach is supported by references in core document 556, assessing landscape value outside national designations. We've given the reference. Both of those refer to references assessing sites in the wider landscape, and we've set those out. They're quoted there in the core document. Mrs. Kirk, with paragraph 110, agreed with the round table that the locality includes the landscape within approximately 500 metres of the site, and the walking route undertaken at the site is a good indicator of the locality, and this includes the A21 Sandown Park, Blackhurst Lane, Pembury Road, and the hospital, garden centre, etc. on the Tunbridge Road, all of which contribute to the locality in which the site would be perceived. Just turning to landscape methodology, we do say, as a learned friend indicated, we do, that Mrs. Kirk's methodology is flawed in a number of respects, in fact, but particularly referring to areas of landscape as landscape receptors rather than elements or as components of the landscape. And this leads to what Mr. Gibbons has called double counting, although Miss Kirk confirmed in oral evidence at the round table that these should not be seen as an aggregation. Well, it's a wrong approach, and has a misunderstanding of the concept of both susceptibility and the considerations of geographical extent. And Mrs. Kirk has not provided an assessment of the effects on components, elements of the landscape that contribute to character. She's failed to consider elements or components that are not present within this landscape, which can be important as elements which are present. And there's no coherent assessment of the effect on the overall character and landscape of the surrounding site. Turning to the impact setting of the area of outstanding natural beauty, there would not be significant harm as alleged in the reason for refusal. There would be no direct effects on the area of outstanding natural beauty whatsoever. And I just pause, there is at all stages, we saw in closing, an emphasis or a misemphasis of levels of harm and tweaking things up beyond anything that they can reasonably sustain. The term setting is defined in the High Weald area of outstanding natural beauty management plan, page 67. The surroundings in which the AOB is experienced by people, and this is expanded on page 21. The term setting is used to refer to the area outside the area of outstanding natural beauty, where development and other activities may affect land within the area of outstanding natural beauty. And you heard from Mr. Gibbons on that in both his evidence and cross-examination. In this case, it's accepted the development is within the setting of the AOB, but the proposal would barely be seen from the area of outstanding natural beauty. Intervisibility between the proposals, the area of outstanding natural beauty would be negligible. There would be almost no visibility of the proposals from the area of outstanding natural beauty, certainly no long views or important views, and we cross-refer to the MPPG. From the area of outstanding natural beauty, there would be, as Mr. Gibbons found, views of the proposals only from short stretch of permissive path within the private work in Robin Gate Wood to the north of the south site, and we heard from the owner of slightly bizarre evidence from the owner of that site, so you'll know where it is. From a short stretch of the A21 approaching the site, seen through a gap in the roadside vegetation and over the Garden of Hamptons, and then from the footbridge over the A21, seen through a gap in the roadside vegetation and over the Garden of the Hamptons. And again, I know there's discussion about how quickly the trees on the side would grow on the side of the A21, but overall there's a very limited view from the footbridge seen in the context of the dual carriageway. Is it, one asks as well, a place where people will go and dwell on that bridge to perceive the area of outstanding natural beauty and its setting? The answer, I think, the answer to that is one that almost answers itself for anyone who's actually gone on the bridge. In the medium term, the proposals would be screened by proposed planting and regrowth of existing vegetation along the A21, and you've been able to see some of the regrowth that's occurred on the A21 since cutbacks have taken. I don't mean financial cutbacks, but cutting down had taken place, and how it's coming back. And in particular, the views from the footbridge were discussed at the round table, and Mr. Gibbons said they would be blocked in years 5 and 7 by trees on the A21 embankment. I don't believe that's challenged. It wasn't challenged at the round table, which is the time that it should have been if it was. So you can note that, I think, is unchallenged. The MPPF at 176 calls for development within the setting to be sensitively located and designed to avoid or minimize adverse impacts. This is exactly what the proposals do by taking advantage of the natural features of the site, surrounding landscape, which provides significant screening and naturally restricts extent of visibility. By restricting height parameters and the proposing mitigation, planting that would naturally reflect the character of the surrounding wooded landscape would all assist. It's not just by restricting the height, it's not simply in terms of visual, it's also spatial as well, in terms of volume. Regarding Mrs. Kirk's alleged countryside connection between the A&B and to the north and the south of the Pembury Road, as you say, there is no visual connection. We tried it. The appeal site proposal would not somehow create a disconnection from the A&B to the north or to the south. I mean, the A&B is linked to the east of Pembury. There's no footpath link that would allow you to experience two parts of the A&B by passing through the landscape. So there is no disconnect, as I think Mrs. Kirk was talking about a countryside connection. There is no connection for this. Sometimes you can have situations where you go along and you experience along the way various different countryside experiences, but that's not this case. They're not linked. There would be no effects, but perceptual aspects of landscape character of the area of outstanding natural beauty, such as tranquility. I mean, given the context of the A21, sir, you will have been there. Again, I leave it to you to form an assessment as to its impact. And of course, noise is a relevant factor in terms of setting. Finally, the council's approach is inconsistent, as we've said, with the approach taken in the EIP to Tudley Village allocation, where there is intervisibility between area of outstanding natural beauty and allocations proposed, and to other major development around the edges of the area of outstanding natural beauty more locally, Knight's Wood development to the north west, the hospital development to the east, the Tesco site to the southwest, and also allocations south of Pembury are also within areas of outstanding natural beauty. Briefly on the rural lanes, here's a not significant harm as a reason for refusal. Para 101 of the officer's report stated both Sandown Park and Buckhurst are designated a rural lane. That this was a flawed and egregious error. Dealt with that in cross-examination. They're not designated. That's now agreed in the statement of common ground. The SPG plainly does not apply. And whilst we say peri-urban, rural fringe, we are in agreement with the council that both Sandown Park but Blackhurst Lane will have some characteristics of rural lanes. However, neither Buckhurst Lane nor Sandown have represented the sunken lanes pictured in the High Weald area of outstanding natural beauty management plan, and neither are highlighted as having origins or features of importance in the council's rural lanes SPG or landscape character assessment. That's why the SPG was carried out, to look at them. And we know that they were aware of them because they appear on the map, but they're not designated. And they're not of historic value, as per Appendix A to the SPG, or lanes with origins on Roman roads, drove roads, or ironways, as per Appendix A. They have no elevated status. Mrs. Kirk, however, said the key effects on the rural lanes are visual amenity of people using the lanes, as opposed to changes to the lanes themselves. This is a visual harm led rather than a harm to the character of the lanes itself. Council's key concern is with regard to the short part of Sandown, part that passes between the two parts of the site, or to be precise, the effects on visual amenity. With the exception of a short length of the lane, where the site access would be constructed, the character of the lane as a track passing between an avenue of trees would in fact remain. However, it's acknowledged there would be effects on visual amenity, albeit these have been assessed by both Mr. Gibbons and Ms. Kirks on a worst case scenario. And in this case, that means where the details of the architectural proposals are unknown and there's nothing to say at the reserved matters stage about the quality of architecture, could not be such that it could reduce the effects experienced. The effects need not be bad per se, and I give the reference to Mr. Gibbons' proof on that. With regards to Blackhurst Lane, as the inspector, you see, as you've seen on site visit, the character of the lane to the west at Malden Way and beyond is suburban, includes street lights, curbs, white lining, and to the east, the lane is truncated by the barrier across the road and the A21. Whilst there's been some recent tree loss and the lane immediately to the west of the road has woodland on both sides, the effect of the proposals would be restricted to a short length of the lane. The proposed planting would mitigate the effects in the medium term and beyond, truncating views of the proposals. Whilst a narrower emergency exit will remain, this represents a small gap and would have no effect on the wider character of the lane. Important landscape approach. From Pembury Road, I try and do this speedily because there's not much to it. No summer visibility, winter visibility from the Pembury Road restricted to the barest of glimpses. Buildings, as you heard from Mr. Gibbons, will be screened by foreground vegetation. Density of branch structure. Any winter glimpses of light will be seen in the context of existing lighting street lights, cars along Pembury Road, and in the context of existing glimpses of light within Sandown Park. Albeit we do not consider buildings would be seen, we have offered a light and materials condition which would deal with any remaining concerns that council might have during the daytime and lighting conditions to ensure effects of lighting are minimized. Mrs. Kirk's evidence was unreliable, we say, on the views from Pembury Road. Mrs. Kirk, admitting the evidence, she had not visited the site in summer before submitting her evidence. It's clear on site, I am told, that she did not have a clear understanding of the location, the site, or features relative to the road. That would be a matter for you, sir, to decide. I wasn't there. While she, I think, acknowledged in her LVA that there would be no views in summer, and in the roundtable she admitted that there would only be glimpse views in winter, she then insisted that summer effects would remain minor adverse, even though the ZVI was agreed as not reaching the road. So it's another add to the list of local authority approaches in this case that are just incomprehensible. Similarly, whilst accepting the GPS video wires were correct, she maintained the proposals could overtop the vegetation, where clearly this would not be the case. You'll be able to judge that, sir. But in reality, the GPS verified photo wires demonstrate that the proposals would not be seen in summer, and that there is almost no chance of seeing the proposals in winter. The proposals would not overtop the foreground vegetation, and although we say that this is not necessary from this location, we have offered height conditions to restrict the height of the building to deal with any concerns that they may have in this regard. There is an outside possibility, you heard from Mr. Gibbings, that one might see a twinkle of light through the trees in winter. But seen from the lit corridor that is Penbury Road, and in the context of existing lighting within Sandown Park, we say, and our expert evidence say, these effects would be negligible. Turning to trees, and as we say, so this is a classic example of where we say the council hasn't really come to terms with this being an outline application. Won't repeat what we said in opening and evidence, but see where we are to date, sir. The evidence presented today, we say, supports the appellant's position that the illustrative scheme can be implemented without loss of existing sustainable trees, nor would it pose an unacceptable threat to health, vitality, or future sustainability range of any retained trees once in operational usage. That is the site, not the trees. No specific evidence has been provided by the LPA through the inquiry process in support of their stated reason for refusal. That's number 4, in that they consider the proposed development may result in harm to existing trees. The council's case has now shrunk to concerns, as of this morning, although we're pleased it's reduced, by the former tree officer about T4 and T5. Importantly, the council, have not demonstrated that the information supplied to them is insufficient for them to make an assessment as to the impact of the development proposal, nor that any such information could not be provided in response to an appropriately worded planning committee. Mr. Brophy has also given unchallenged evidence of elsewhere where similar works have been carried out without harm to trees, and you've got that in his main evidence and rebuttal. The matter of Mr. Mashburn's concern re-pruning of trees T4 and T5 was an item that I'm told was apparently touched on the site visit. Mr. Mashburn stated his preferred normal default highway clearance height for adopted carriageways, but he was silent as to making a direct recommendation as to the actual clearances that would be needed for the site, nor did he dispute, not my opinion, our opinion, the appellant. This should be the appellant's expert opinion, which apparently was expressed at the time to assist your understanding, sir, that the overarching direction in the tree schedule, that of a canopy lifting up to 4 meters. That, as I say, is something, sir, that I'm told occurred in assisting you on the site visit. But the main point is, sir, it's really 134. Condition 22, combined with Mr. Brophy's evidence and experience, is sufficient to give the LPA sufficient control in obtaining detail that would robustly demonstrate that an operational non-adopted roadway could be constructed within the route protection areas of trees T4 and T5 without resulting in conditions that would result in detrimental impact on the health, vitality and condition of the trees. So we say, sir, that's really the end of it. It's a start, because we've always said it we dealt with by condition, and we say that's the end of it as well. We do say something about the buffer that's now dealt with by condition. It's now been agreed, and I won't read it, other than to say this acceptance is key to reinforcing the appellant's position that the woodland area has always been appropriately considered by the design process from the outset of the project work. It should also be removed, obviously, from the case against the development Because hitherto, until this morning, this was a factor weighed in against the development. So now it's not against the development. And as a planning consideration, Miss Miles said it would have a planning benefit of ensuring that part of the area of the ancient woodland, which is currently ploughed, and I should add to that, will not be ploughed, will not be disturbed, will not be disturbed. And she puts that as a planning benefit in our answer to your questions. But that was not included as a very special circumstance, but a planning benefit. So as we say there, the appellant has accepted these suggested conditions, and we think that the trees issue is a non-issue. Well, we think all of them. But and then turning to another non-issue, highways, please. Again, we don't repeat what's been set out. It's not just Mr. Blacker, I should say, in response to third parties closing. He's not the only person to have put expert evidence before you. You have the expert evidence of KCC in writing and their responses, and also that of the National Highways Agency. So dealing with some of the issues, it has become more and more that the Pembrey proposed roundabout improvement, which doesn't arise as a result of these development proposals, seems to be the issue that has been latched onto, even though it does not appear that many of the people actually object, or anyone has actually objected to it. The consented roundabout scheme at the junction of Pembrey Road and Blackhurst Lane was agreed by the local highway authority, which is KCC, and included a stage 1 road safety audit. This scheme has been designed to manage the current and future travel movements through and around this junction. To the best of our knowledge, Skinner's Kent Academy raised no objection to the changes to this junction. Our evidence demonstrates the appeal site can be accommodated in both the existing arrangements or the consented King's Standing roundabout scheme. So, in a sense, those that are objecting about this roundabout are really at the wrong target. But that's another matter. Construction traffic. Through our discussions, they've raised concerns about the impact of construction on Sandown Park, specifically during school opening, closing. It's agreed a condition will cover the construction management plan, has the ability to control operational times and routing, or routing, as Americans would say. It was also discussed that development will not require construction access via Blackhurst Lane. That was, I think I made that clear in opening. Parking. At the request of KCC, we've been asked to provide C3 parking as opposed to C2 parking standards. And this appears to have caused some level of concern to local residents with regard to the types of homes to be provided in the future. I just pause to add, I'm coming on to chip generation. It does nothing in terms of the trip generation, because the trip generation is what it is. So you'll recall, sir, it was discussed how traffic generation from the appeal site will be low during the network peaks. In the morning peak of 8 in the morning to 9, it's forecast that 5 vehicles will leave and 14 will arrive. During the evening peak, 11 vehicles will arrive and 11 vehicles will depart. The impact on the existing queuing would be limited, especially during the worst periods of queuing on Sandown Park between 8:15 and 8:35 during term time weekday mornings. The additional trips from the appeal site do not have a severe impact on the surrounding road network and will not make the existing movement of people or vehicles unsafe as a result of this small increase in traffic. On Sandown Park, friends of Sandown Park raised concerns over vehicles driving on the footways, vehicles unable to pass along Sandown Road. The appeal site will provide parking for residents and visitors within the site. So it's highly unlikely that residents or visitors of the appeal site will add to the existing on-street parking demand on Sandown Park. And indeed, we're being taken to task for over-providing in parking, so there won't be any incentive to park further away on the public highway. It's evident from the site visit, you will see just how lower the level of traffic movements are on Sandown Park, with the site visit parkie walking the carriageway for almost half the length of Sandown Park. As I'm told, sir, but you'll know whether you did or you didn't, but I'm assuming you did, along with Mr. Blacker and others. You will have also noticed how, if there were any vehicles using Sandown Park, then there was sufficient room for them to pass vehicles in the carriageway. Injury, accidents and street furniture damage. FOSPA presented photographic evidence of damaged street furniture and vehicles which collided with pedestrian guard railings. We discussed the alignment at the Sandown Park at its southern end as you approach the junction of Blackhurst Lane. We reviewed the alignment, this section of the road, and the correct visibility is available for drivers travelling at 30 miles an hour. During the site visit, I understand we observed, or you observed, the party observed damage to the railings, which could be seen, but was evident in most cases. Damage was not recent. There has been no evidence of any injury accidents on either Sandown Park or Blackhurst Lane over the last 5 years. So we say the local planning authority in this respect were right, or KCC were right. There is no reasonable basis for refusal on highway safety or impact on the highway network ground. Turning then to whether the council can demonstrate a 5-year supply of deliverable housing sites. Para 73, as you know, sets a requirement for local planning authorities to identify and update annually a supply of specific deliverable sites sufficient to provide a minimum. Could I emphasize, sir, as well, it's a minimum, because my own friend in Closing Wax, quite lyrical, that at various times inspectors had been persuaded of the promises that we're getting there, and that the persistent shortfall was only very small. It is a minimum that we're looking at. This is the bottom, not the top, of housing granted against their housing requirements, set out in adopted strategic policies, or against their local housing needs, where the strategic policies are more than 5 years old. The council and the appellant have agreed the supply is 4.66. As such, there's no need in this bill to drill down into delivery of sites within the agreed supply. However, council argue the shortfall supply is small, and this is not accepted by us. But on any view, the LPA is not addressing the existing shortfall, which is consistent. Ms. Miles was referred to in cross-examination to Mr. Island's evidence. We referred to the council's action plan, the measures the council is taking to address this shortfall. But with reference to what has occurred, the following can be noted. In March, Inspector Manning concluded 2020, the council had a 4.61 year supply. That was a decrease from the position in February 2021, when Inspector Rowe concluded supply was 4.88. Inspector Westbrook concluded that the supply was 4.69 in November 2020. Therefore, although mathematically the shortfall may be regarded at the time as small, the length of time that there's been a shortfall is relevant, as is the fact that despite the council's action plans, there has been no improvement at all in resolving the shortfall in the last 2 years. Undeniable that there's a significant need to boost the supply of housing in the borough. The need for extra care. The appeal scheme is intended to provide extra care, housing with care as defined in the PPG. Housing with care falls between care quality commissions, CQC, registered homes and sheltered housing. Comprises a purpose-designed older person's home set within a care community, community facilities, and importantly where CQC registered care is available on site to meet the care and support needs of residents. PPG identifies the need for specialist housing for older people is critical. The only housing expressed in such immediate terms, and we do say that's relevant, nowhere else is the need for housing expressed to be critical, and one can't think really of a more serious word than critical. Even worse than the word I use, chronic. Critical. The recent white paper, People at the Heart of Care, states an important priority to growth investment, both grant-funded and private sector. Over the local plan period from 2020 to 2038, the number of people aged over 65 in the borough in Tunbridge Wells is expected to grow by 40%. Those aged over 75, growth is expected to be 50%, 68%, and those over 85. It's common ground that there are 183 existing extra care housing units, private and affordable, in the local authority area. This equates to a prevalence of 16 units per 1,000 aged over 75 years, age 75, broken down on a 10-year basis, and then there are 121 and 62 affordable equivalent prevalence rates of 10.5 per 1,000 and 5.5 per 1,000 aged 75 plus. It's common ground between the parties that there is a pipeline of 2 schemes with extant planning permission. Firstly, a further 89 private housing with care units at the former Aviva bus depot, deliverable in the short term, and secondly, the proposed 72 housing with care units at St Michael's Burswood, which is agreed should not be included in the 5-year supply at the current time. Parties have both agreed that the 2018 post ONS population projections are most appropriate for the assessment of housing with care need, as they provide the most up-to-date projections. It is to these projections which the prevalence rates for housing care should be applied. And in one sense, I do agree with my learning friend. She said, with all these models, it's what you put in that's right. And that's why this council's position, with its prevalence rates on the local plan, is so woeful. In the market position statement, KCC place a much greater emphasis on housing with care being an alternative to residential care, yet provide, as we've said, and Ms. Venable said, no clarity as to their need assessment. It appears that KCC have therefore narrowed the rate, despite the fact that they incorporate a proportion of the need for care beds within it. This seems another nonsensical approach, given current PPG and the national drive to increase the supply of housing care. Mr. Ireland's memo provides no further indication as how to the gross need was calculated. And we do say the lack of clear methodology was identified in the Edenbridge Club appeal. The position does not appear to be changed. Could you add, sir, and I'll rely on you to look it up, in cross-examination, Mr. Ireland accepted at the end that your colleague in that appeal was correct in his assessment as to the lack of transparency. And I'll ask you just to look at the note. It did take a while, but in the end he accepted that your colleague was correct and that there is a lack of transparency, and that on those aspects, Mr. Ireland could not assist us. In his evidence, Mr. Ireland refers to the gross combined tenure need for extra care in the Tunbridge Wells Borough Council submission local plan as being a narrower need at 25 per thousand age 75 plus. At cross-examination, he agreed this should be increased to combined tenure of 45 units per thousand on the basis that both need for enhanced sheltered and extra care should be combined to provide a total prevalence for housing with care. On either basis, there is an existing shortfall, given that the current, as I've said, prevalence in the TWBC area is 16 units, 1,000 per thousand age 75 plus. The combined tenure prevalence of 45 units per thousand age 75 plus only returns the council to its need position for housing with care, forming part of the wider need for 170 units per thousand age 75 plus for specialist housing care for older people. And this is based on the More Choice, Greater Voice toolkit set out in the Sevenoaks and Tunbridge Wells Strategic Housing Market Assessment, the SMART. Notably, the revised prevalence rate makes no additional allowance for county council's intended transfer, and you'll recall this in my cross-examination, of the 30% of the need for care home beds to housing with care over a 10-year period. Neither has it increased for the now critical need for specialist housing for older people. Now, Mrs. Venables gave evidence about that, and her assessment of need is based on Housing in Later Life toolkit and an alternative toolkit used by TWBC with prevalence rates described by Mr. Ireland in his evidence to the Shiplake Planning Inquiry in August 2019 as being more recent. In his experience at that time, both toolkits are widely used by public sector to develop strategy for older people's housing. To support a shift towards providing a range of housing options for older people and align with health and social care agenda, seeking to provide enhanced sheltered and extra care as an alternative to residential and nursing care provision. Based on this toolkit, prevalence rates for private provision only were suggested at 30, 45 and 90 units per thousand age 75, depending on the type of scheme proposed in the evidence the Shiplake appeal. And you'll recall I took Mr. Ireland to it and Mrs. Venables took us to the Shiplake appeal. While the highest of those rates related to a scheme assumed to incorporate a proportion of older people without a care need, the scheme was with a prevalence of 45 private units per thousand is most akin to the appeal site, incorporating need for enhanced sheltered care and 5 older people who would otherwise live in a care home. This prevalence rate is even higher than the preferred by the appellants, which assumes 40 private housing with care home per 1,075 for those aged 75 and more. And this rate is considered to most closely accord with the current critical requirement for specialist housing for older people. It provides an increased weighting for future provision of housing with care as an alternative to care beds and sheltered housing. It's consistent with home ownership levels for those aged 65 and over in the TWBC area, and importantly provides for an adjustment to the standard 75 age cohort when a proportion, around 20% of those occupying housing with care schemes are aged between 65 and 74. And this isn't, just pausing there, this is not some sort of double counting, because you just add So as was alleged in closing by Mrs. Venables, this is something which she highlighted and which, as you'll see, your colleague accepted. He wasn't in a position, and Mrs. Venables has explained why, not statistically in a position to carry out a mathematical exercise, but why given the absence of a toolkit based on it, but allowance needs to be made for that cohort of younger elderly people who need care. And in this appeal, Mr. Ireland considers the appellant's prevalence rate to be unrealistic. Well, it's interesting to note, however, and we took into the recent strategic market assessment produced by ICENI suggested that a combined prevalence rate should provide a starting point. And we looked at that during the evidence. So a starting point isn't an end point. The difference between the parties, assuming the Kent CCC split of 70-30 private to affordable based on 45 units equates to 31.5 private units per thousand for 75 plus, compared to the appellant's preferred rate of 40 private units per thousand for 75 plus, as the appropriate level of provision of private housing with care. So what this means, on this basis, the appellant's assessment of need for private extra care based on the 2025, the earliest the appeal scheme could be made available, and assuming the 89 planned private units at the bus depot, St John's route, are developed, gives us a figure of 337. The assessed need for private extra care increases to 408 units by 2038, the end of the planned period, assuming that both the bus depot, St Michael's Burswood scheme are developed and operational. I just pause. As to the catchment area, the LPA called no expert evidence to challenge the evidence of the appellant. And you'll record, and I again ask you to look at the notes, Mr. Ireland admitted he wasn't an expert on either catchment or indeed market. The above figures exclude the three sites proposed for the allocation and the recently introduced former cinema site, for which a planning application is yet to be submitted. In terms of meeting the existing need, we question whether and when these sites will be deliverable within the local plan, particularly given the constraints of the former cinema site, their suitability for appeal for use as private housing with care, given that there is also a need for affordable housing provision. Pause there, sir, and I'm going to come back to it in a moment on need. But the only expert evidence you heard on whether on the market for extra care accommodation was Mrs. Venables. Again, Mr. Ireland having shot out from the hip, as he was wont to do, some oral views in cross-examination, admitted and conceded he wasn't an expert on the market for affordable housing, and agreed with me that his evidence should be withdrawn. A concession not noted, I noticed, in my learned friend's closing submissions, where she then purported to say that he gave expert as evidence on the market for housing as a planner. Check your notes, that's not right. I don't think he was giving planning evidence, but he certainly was in no position, as he admitted, to give evidence on the market. It is clear from the position adopted at the EIP on Tuesday that any application is likely, and Mr. James said, be opposed by the civic forum and amenity groups. In any event, these are things that are inevitable for applications that have yet even to be made. The potential amount of private housing with care units, deliverability and timing should therefore be considered within this context. There is a current shortfall, housing with care, which needs to be addressed. Aiming to meet an existing need over the course of the emerging plan doesn't guarantee its timely delivery. At this stage, it's unlikely any of these sites in the submission will be developed to meet a need by 2025. Assessing deliverability on a smoke and mirrors basis, which we've had, means that addressing the current shortfall is not guaranteed in a location where supply is already woefully inadequate. An assessment for the need of the market catchment of the appeal site has been completed alongside the assessment for the need of the TWBC local authority area. The extent of the market catchment is based on research into catchment areas for existing operational housing with care developments, and therefore provides robust evidence there's a strong need for additional provision for 406 private units in 2025, when existing and planned developments are included. It is, just to add, so it is cheeky of my learned friend in her closings to attack Mrs. Venables on catchment areas, having called no expert on catchment areas, having put to the witness that the catchment areas should be based only on local authority area, and Miss Venables has done that as well as her own catchment area, and then put to her provision just outside the local authority area on the basis it's really close to the local authority area. I mean, that if that is the local authority's approach, which it is woeful, frankly, and there is no surprise that this authority continues to promise but under-deliver. And so if you could note that, since the council now seems to suggest, having no evidence, that you should prefer not its evidence, but its assertions in cross-examination, which are, it should be a local authority catchment unless it's close, whatever that means, to the local authority area. The initial findings of the 2021 census provide a snapshot position in 2021. However, updated projections on the growth of elderly will not be available until 2023. And you heard again from Ms. Venables, and there was a sense of opportunism with Mr. Ireland, I suggest, which was outside the approach one would expect from an expert. Ms. Venables was able to set us straight as to the proper approach to the statistics. Housing with care performed well during the pandemic when compared with older people living, as we heard from her, or for those living in the wider community, as residents could self-isolate effectively in their own homes with care and support as required. The ready availability of care and support was a positive factor in residents' decisions to move to such developments, and the 99% occupancy levels evidenced by KCC in their own schemes during the pandemic further substantiates the attraction of specialist housing. My learned friend has asserted, and there's no evidence for it, that people who might be would only be interested, I think, either in private or affordable housing, and so would not take any notice of any affordable housing provision for elderly care. There's no evidence to support that, and the evidence that was given by the expert and wasn't challenged on this aspect, Mrs. Venables, is that the 99 occupancy levels indicate that it is likely to be popular. It's only in closing submissions that my learned friend has just herself sought to give evidence as to the extra care market. No expert was called for the council to gainsay Mrs. Venables' evidence, and I respectfully suggest that that should be preferred to the submissions of my learned friend. In terms of weight applicable to the benefits of housing with care, Ms. James suggests she should apply her own judgment to relevant appeal decisions to provide a balanced approach. We now have the annex, but that didn't appear in Ms. James's evidence. It's clear, however, there was a misunderstanding of the evidence, the array of health and well-being benefits with which Housing with Care has to offer, including the reduction in costs to social care and health systems, which is even noted in the PPG. It's also common ground that the appeal scheme will have social benefits for future residents in terms of health, well-being facilities provided on site, enabling residents to obtain independence. The provision of lifetime homes within general housing supply should, of course, be encouraged, but this doesn't provide a substitute with Housing with Care. Whilst it may help to fulfil the separately assessed need for shelters and age-specific housing, does not supply of housing where care is available on a 24-hour basis or enable the wider benefits of living with care in the community. The appeal scheme is outlined with experienced care village operator on board to deliver care community intended to both appeal to and cater for existing need for private home with care. We again offer, if you would like, sir, an invitation to visit an existing orderly village if you want to do on an accompanied basis, as others have done. That is also obviously acceptable. The assumptions that units within the scheme can only be 1 or 2 bedrooms rather assumes a one-size-fits-all approach to the identified need and dismisses the fact older individuals also require an element of choice when downsizing or right-sizing in excess of 3-bedroom family homes, which may no longer be suitable for their care needs or be difficult to manage. If you just add, sir, I think there was a modicum of agreement that I put to Miss James that in order to attract people to right size, there would be a market for those from larger sizes that would want 3-bedroom. She did seem to accept that, but again, if she accepted that on the one hand, but still rejected the notion of 3 bedrooms on the other, which I didn't understand. But you can check your notes, sir. But I believe that is the position. It is common ground the appeal scheme will help meet need for specialist housing for older people in the area. Shortfall in Housing with Care means that older people will continue to have little alternative but remain in their existing under-occupied family-sized homes. We don't need to give evidence on it for Tunbridge Wells. It is regarded as a national phenomenon in planning, in elderly care policy in the documents we've produced. And there's no evidence produced by the council to suggest that Tunbridge Wells is anywhere different to the national approach identified in the various care and other documents in the evidence of Ms. Venables. The appeal site would deliver high quality designed community care and reduce reliance on the NHS and the release of large family homes. Policy 86 regarding lifetime homes, again, it doesn't remove the need for extra care or lift the burden on the NHS and social health service. Meeting the need, alternative sites. I can deal with this quite quickly. Statement of common ground is existing supply of 183 extra care. It's agreed that 161 extra care units are in the pipeline, and we've already discussed the Arriva bus site. Ms. Venables' assessment of the net need for private care based on 2025 means that the bus care at St John's is 337. Assuming that we have the 89 from last time is 337, and the Burswood delivers 72 units. The question then remains is whether sites proposed for allocation and submission plan, along with any windfalls, are sufficient to meet this need. We set out the need there. Woodsgate Corner, Pembury. That is specialist housing for older people, either extra care or residential. In one, well, I'll come to it, but the either or just kills it. It can't be both. That's almost the end of it. But as you know, so there's a lot of points about Woodsgate, owned by Tesco. It was with an extant park and ride permission. It was refused as a major development, as an area of outstanding natural beauty for the motor village. The submission local plan is preferred to allocate the site within an area of outstanding natural beauty as opposed to the appeal site. Much discussion relating to the site, the council producing a letter from Natural England on the Reg 19 version of the submission local plan, which the council argues demonstrates that Natural England agree that a development on Woodscape is not a major development. We don't accept this assertion that up to 80 care home beds would not amount to a major development within the allocation of the when the allocation of the site immediately to the east of PE6 site PE1 would constitute major development. And at the examination hearing, as we heard, Ms. Gilbert stated would be the scale of development would be considered the application stage, and there was flexibility to reduce the numbers. As such, there's no certainty that 80 extra care would come forward if an extra care scheme at all, as opposed to a care home or even an affordable extra care is delivered. It might be, and given the developable area of 1.65 hectares, it seems to the appellants likely, and to Miss Venables, that significant less than 80 units are developed. And in any event, if the site was to come forward, it's a dual alternate allocated site. There plainly can't be any certainty that it would deliver any extra care. And as I said, Miss Venables, the only expert in the field, considered that the location of the Tesco car park, the lacking of frontage, limited its appeal, and therefore it came forward as extra care. It would only come forward as affordable extra care, and that would not identify the unmet need that we've identified. But in Ms. Venables' experience, the site is more likely to come forward for a care home. Either way, it can't be relied on for private extra care. In any event, the council's delivery trajectory states that this site will not come forward until 2032, and therefore does nothing to address the unmet need. And that continues to be the council's public trajectory for the site. So you can just rely on the council's trajectory to see it's not going to deliver by 2025. Paddock Wood, requiring the housing for older people, and strategic site of Tudley Village, for which the policies in the plan require provision of housing for older people. There are significant unresolved objections to the two strategic allocations, both in principle, but also they don't provide for any quantum, location or phasing, only that 2 extra care facilities should be provided, one within each of the allocations. It was clear from the examination significant work would be done, and as a result of our representations, there's going to be a redrafting of the policy. Haven't seen it. Mr. Ireland said in evidence since the examination session, the strategic sites in June, one developer at the site at east of Paddock Wood has agreed to include extra care. Even if there is the case, the quantum, but as I've said, that none of that is guaranteed, none of that is fixed. These are talks. Even if that is the case, the quantum of extra care to be delivered is unknown. There's no requirement within the submission plan for a minimum number to be delivered in either of the allocations. No mention of phasing. So it's still the case that it might not come forward later, so later in the plan program, which extends beyond the 2038, as is evidenced by the delivery trajectory which you had. It's also widely accepted that large-scale strategic sites, this is Lichfield, and in the evidence we produced, and extra share operators are slow. The strategic sites are slow in coming forward. Extra care operators, and you heard from Mrs. Venables, often have to compete with residential operators and are unsuccessful, and that's also in appeal decisions. And if they are successful, they're only brought forward in the later stages. So what we have is 2 allocations, which are unlikely to deliver any extra care units until the planned period. It's nothing to do in any event to deal with the short-term unmet need. And indeed, as was stated by the council in the local plan examination, these sites aren't expected to start until 2031 at the earliest and would deliver housing beyond the planned period. As such, neither allocation assists the council in meeting the unmet need. And I say allocation, they're not an allocation at the moment. Till the plan's adopted and we actually see the policy, we don't actually see, we haven't got, as I've said, now, because the council's indicated they're going to rewrite the policies, what's going to be said. So it is our position that whilst extra care might eventually be delivered on their sites, there's no information at present from which the council could rely on the quantum of units. No evidence for use, sir, which could be said to address the unmet need either in 2025, 2038. Windfall sites. Mr. Ireland argued that council had a history of granting windfall sites for extra care. There are 3 sites, 3 referred to in his rebuttal evidence, the Dairy, Hale Court, Burles Lodge, all of which are included in the existing supply of 183. Dairy was in fact an allocation through the site allocation DPD, so not a windfall site in the strictest sense anyway. In any event, the development was completed in 2017. Hale Court was completed in 2016, delivered 19 extra care units, 5 private, 14 affordable. Burles Lodge was completed in 2017, comprised the redevelopment of a nursing home with an extra care, 48 flats, all affordable. So, as we put in evidence to you, sir, as such, in the last 5 years, the council has in fact actually only delivered just about 5 private extra care units on windfall sites and 62 affordable extra care home units on windfall sites. The council hasn't pointed to any other more recent windfall sites. It cannot be reasonably expected windfall sites are a reliable way of ensuring the unmet need for 337 private extra care units in 2025, 407 private extra care in 2038 will be achieved. Cinema side, I try and deal with it. The council also induced at a late stage through the evidence of Miss James, which we responded to through Ms. Miles' planning rebuttal. I'm not going to get into the speed or delivery, given this was fairly late by the council. The council responded the day before the inquiry opened, further information, and we submitted a response. Cinema has a long, complex history. I mean, it's pretty absurd, which is repeated again, the assertion by Miss James that they built a railway, then they demolished something, and therefore they can do anything they want to do. Well, the history speaks for itself. It's the extant implemented planning permission for 108 units, C3 housing, restricted by condition to occupation of 65. No explicit requirement for the occupants to be in receipt of extra care. No reference to extra care within the officer's report. The Section 106 obliges the owner to pay education contributions, which wouldn't be expected of a C2. Plainly, this site cannot be relied upon to deliver extra care by 2025. Delivery by 2038 is uncertain. That extant permission is regarded as unviable, but the council at the 11th hour, and we say without any good reason, the delay sought to provide additional information which trickled in, purports to address the appellant's concern regarding the developability of the new promoter retirement village for 165 care units. But when you look at it, the information, there remains concerns. The Statement of Common Ground, Appendix 1, confirms the extent planning permission for 108 units is commercially unviable, as I've said. So it's therefore clear that the extant permission cannot be relied by the council to meet its extra care. Question remains, what weight should be attached to the council's pre-application discussions and PPA with the retirement village for alternative scheme in considering whether the need for extra care can be met? The PPA is nothing special. That should have an H in, not noting. The agreement with Network Rail on asset protection has not been produced. Neither is the PPA, despite numerous requests from the appellant. Insofar as the asset protection agreement, it's unclear whether the council even has it. Now, the council can do what it wants in not providing it, but it can't then expect you to rely on things that aren't before you, sir, and which cannot be tested. And in particular, what assumptions are made in those agreements. Council say it be submitted in July 2022, and obviously place emphasis on 4 pre-application meetings. Council cannot predetermine the application, neither obviously can you, sir. You refer by the appellant to the definition of deliverability. This has been ignored in the LPA assessment and is not mentioned in its closing. We set it out, so you're familiar with it. Plainly, it cannot be regarded as deliverable. And although there is a detailed permission, there's clear evidence, the statement of common ground, matter 11, it's commercially unviable. It cannot there be considered deliverable under A. Having regard to B, the development of 165 units is clearly a major development. There's no outline permission, and the site has not been allocated in the development plan for extra care. It cannot be regarded as deliverable either. The site cannot be regarded as deliverable by 2025, and so will do nothing to meet the unmet need for 337. Therefore, clear there are no other alternative sites in the pipeline to meet the unmet need for extra care in 2025. The appeal site is the only alternative site available and backed by an operator to come forward to contribute to meeting that needs. As to whether, in any event, the site could be delivered in the longer term and whether in the plan 2038 as discussed, in the planning rebuttal, there is a weak railway line beneath the site. Whilst the statement of common ground, matter 11, states the retirement village has appointed a technical team to advise. That's not sufficient to give confidence in how the concerns will be identified. And the concerns have led to successive previous attempts of developer failing. None of that evidence has been put before you, sir. It's the council who's seeking to ask you to rely upon it, even though no planning application has been made. The council was, as I say, asked for a copy of it, but this has not been forthcoming. The issue with the tunnel has been a barrier to previous development. Sorry, sir, and a reason, whilst others have fallen out. It's not a figment of our imagination. Further, to attach weight to the retirement village proposal now would be in effect to predetermine the outcome of their application. It hasn't even been made. And Mrs. Miles attended, as I know Miss James did, session on Tuesday, and where Tunbridge Wells Town Forum spoke against the loss of the cinema and in opposition to 165 units within the town. I mean, we don't have to rely on this as evidence. That is the sort of thing that happens with those developments. The council concluded examination, the local plan policy need not change. Considering the merits of an unsubmitted application. However, sorry, we need to add in. However, by the end of the hearing, there had been agreement to look again at the policy, and again we await, as I've said, the redraft. So you just need to add that note in. By the end, the council has agreed to re-look at its submission draft. Whether the council chooses to ignore its own development planning policy is matter for clear council, of course, but clearly seems to be the case that the retirement village proposal will not be received by all, including Town Forum, due to the loss of the cinema and significant additional residential units. So whatever it is, you haven't got to determine this, but it is simply premature to attach any weight to that proposal, and actually be quite wrong for the reasons we've just said in predetermining. So you can only consider what's before you, and that is a commercially unviable older persons development on a site which will not be delivered, and an existing emerging allocation, and there's no mention of providing any extra care units. We await to see, I know that there's going to be a redraft, but we wait to see what the redraft is. So this site cannot be relied upon for meeting the extra care needs. Summary, there's clear unmet need for 337 private extra care, 2025 408 in 2038. There are no existing sites in the pipeline to meet this need, and none, that should be not none, none of the sites identified by the council will come forward by 2025. Even if the allocated sites do come forward later in the planned period, there's much uncertainty. So having regard to the critical need of extra care in the borough and the lack of sites, the proposed development is plainly needed. And then we go to very special circumstances, which again picks up on a lot of what you've already heard. It's common ground that the appeals scheme of up to 108 units for older people would, and then we quote, make a valuable contribution to meeting the council's 5-year housing supply, help meet the identified need for specialist housing for older people in the area, would also reduce demand on local public service and health resorts. That's in the statement of common ground, so you may think the answers from Ms. James initially to your question on the NHS letter is surprising. Has the potential to release larger houses that are under-occupied by older persons. Again, that's in the statement of common ground, so I ask you to look at that when you're looking at my learned friends closing. Have social benefits for future residents in terms of health well-being that would be provided on site, and naming them to retain independence. The appellant's position is all these benefits amount to very special circumstances to outweigh the harm to the Greenbelt and any other harm, including the less than substantial harm to the heritage assets. That's harm rather than haim. There's a bit of a typo there. The appellant's evidence has shown that there is a significant unmet need that will not be met by existing pipeline or supply and cannot be reasonably replied on. There's a critical need for this development. On the facts of the case and the evidence before the inspector, there's very little harm flowing to the proposed development. Obviously, you'll make your judgments, but that's the expert evidence that we have. Given the council's acceptance of an unmet housing need, specific need for elderly persons accommodation, and that significant weight can be attributed to this when considering whether proposals constitute sustainable development, and that this provides substantial weight in favour of the scheme, is the applicant's firm position that the Planning Permission should be granted when all material considerations, relevant planning policies are weighed in the balance. So you will do your own way. You may weigh it slightly different to Miss Miles or to Miss James, but we do say to you, whichever way the cookie crumbles, there is only one way, and it should, if we're to take seriously what the Secretary of State says we should, that we have a critical need to fulfil. There is paras 147, 148 requires substantial weight to be given, of course, to harm to the green belt. If the proposal is inappropriate development, as we acknowledge, then we must prove very special circumstances exist. Very special circumstances don't have to be rare or common to be special. Councils say that housing alone is unlikely to clearly outweigh the harm. However, the position of the 2015 written ministerial framework were not incorporated into the framework, nor the PPG guidance. The appellant's case never proceed on the basis that extra care need alone as a single VSB, although we do refer to the Colony Heath Bill, where they expect to conclude the 3 types of housing, being market, self-build and affordable housing, collectively demonstrate very special circumstances. As such, housing needs has clearly been accepted elsewhere on appeal as being capable of outweighing harm to the green belt. So just pausing there, we do rely on other benefits, but sir, we do say, and I do say and submit to you, it is open to you to find that the in the need for elderly housing of itself is good enough. Para 199 framework requires that when considering the impact of the proposed development on the significance of a designated asset and the more important asset, the greater the weight should be. This is irrespective that any potential harm amounts to substantial harm. Total loss or less harm to the significance. It's agreed that the harm to heritage assets is less than substantial. And in line with 202, where development proposal will lead to less substantial harm to the significance of a designated asset, this harm should be weighed against public benefits. It's undeniable. So we've accepted that great, and I've said in opening, it's great weight given to even less than substantial harm. But it's undeniable we're in the midst of a housing crisis, no 5-year housing supply. The council has confirmed this shortfall is not new. And as we say, potentially 7 to 10 years of persistent undersupply. Whilst mathematically the council argued the shortfall is small, it's persisted for many years and not reduced. I'm sure the council hasn't been saying previously that we're not doing our best. I'm sure they said the same thing before. But the proof of the pudding's in the eating. We say significant weight can be considered the provision of the additional housing, just in its normal context as well as elderly. And as Ms Miles considers the provision of additional housing on the appeal side and the contribution this makes, the council's historic and persistent shortage of housing. Every year you're below is another year of unmet need. So you're creating a backlog, which is overlooked by the council, and they've enclosed and say, oh, it's always just very small that we're not meeting the minimum today. The appeal is intended to provide extra care housing as defined in the PPG. Our case 216 is not predicated on a shortfall in 5-year supply, as the evidence makes clear. In fact, even if there was a plus 5-year supply, there would still be a critical unmet need for the extra care units proposed by this appeal. The need would not fall away by the presence of supply in the general market, because this is an identified specific need. The proposed allocations and submission of local plan are clearly not sufficient or deliverable to meet the identified need for extra care. The council has no other robust evidence, as we've just been through, that sufficient windfall sites would come forward. In fact, even if the inspector does accept the council's position with regard to the cinema site, then there would remain an unmet need for extra care, and we show the figures. So even if you do give the council the benefit of the doubt on a site that hasn't come forward for years and has no planning permission and no planning application, even then it wouldn't do the job. The PPG identifies, obviously it's critical, they are a statutory protected group. Just as we have to look at the statutory requirements for listed buildings, as we've done, and we've been reminded by my learned friend, we have to look at the equality impact assessment, that's the statutory protected nature of the elderly. The extra care needs of the borough's older people is simply not being met by this council in a sufficient way. Council's submission local plan is wholly inadequate and cannot be relied to meet the extra care needs, as Ms Miles and Ms Venables have indicated. The council, as I say, can't rely on wind farm sites. It's clear and critical, paragraph 218. Then, as I've said, these are separate, are capable of being treated separately, as the council seem to recognise its statement of common ground. The freeing up of homes, allowing older people to free up, it brings other housing into circulation. This is a separate benefit from providing for people for the right type of home that they need. It's a completely separate benefit. It's Ms James argued the reduced rate should be attributed to the release of family homes in the wider area, given the provision of 3-bed units within the development. her reasons are flawed, and we set them out. This was an illustrative mix, and as I said earlier, when dealing with the 3-bedroom provision, that is to seem to be accepted by Miss James, would attract, and you can check your notes, people from larger houses out. Paragraph 62 of the framework requires a variety of the size and type and tenure of housing. And Miss James says it's a waste of space for 3 bedrooms. That's, with all respect, a personal option rather than a reasoned and rational assessment. We don't all have to, and the planning system isn't that we live in whatever is the mere utilitarian size space for us to exist in. And indeed, if we've given examples why particularly elderly couples might want extra bedrooms. Fourthly, as Miss Miles explained, Audley Village offers top end of the market, and whilst we accept obviously there can be judges a choice for others, but there must also be a choice for this market. And in the recent appeal decision at Alban that you had, the inspector recognised that some, similar to Tunbridge Wells, a large proportion of those agreed over 65 were owner occupiers, and a considerable number of older householders under occupied their houses. The evidence base for the submission local plan suggests a significant proportion of future household group which would generate a need for family-sized house. This is reflective of the national picture, so it is therefore a separate benefit to the local market that these would be freed up. Like the inspector in Auburn, as discussed in 94 and 95 of that decision, this should be given significant weight. And in the appeal decision also at Westmoreland that you had, neighbouring authority, the inspector recognised paragraph 42, provision of specialist housing more suited to the needs of older persons, is likely to encourage them to move, make a valuable contribution to the overall needs, which should be weighed in the balance. There's no evidence in any of those decisions that there was some forensic analysis of what houses would be freed up. But the evidence clearly, there is no evidence here that Tunbridge Wells, of all places, would be a place where there are not large over-occupied houses, particularly occupied by the elderly wealthy, who will be attracted to our scheme. These are the ones likely to be unlocking large houses. The benefits to the NHS, again, many of the community residents will already be already registered as GPs, but the proposed care community will have on-site communal facilities and will take pressure off the NHS. 226, Ms. James referred to the NHS letter. This was all very bizarre, I have to say. It was clear that the NHS letter had misunderstood what was being proposed. Miss James should have questioned the letter, but I'm afraid, and you'll judge the witnesses on their approach, this was another example of this authority, even when it was plainly wrong, just irredentously pursuing a point that was a thoroughly bad point in order to defeat an application for extra care in the community. There is no in addition, para 227 to the well-documented evidence of extra care villages reducing the pressure on the NHS, which is in evidence before you. Government reports a C2 proposal. As a C2 proposal, there will be on-site staff available to support residents. These staff will be provided as part of the care package produced, and you've got section 106 of the minimum requirement by residents moving into the development, at least 2 hours of care. This personal support, that doesn't mean there won't be people with more. And you heard evidence on this. This personal support can assist in determining when external doctors need to be called thereby reducing the number of unnecessary visits by a GP to a patient at home. My goodness, this is so important when we hear the news today. Furthermore, planned GP visits can be combined so that multiple patients can be seen by one GP on a trip, something not possible outside the care home. I mean, all these things are quite obvious, really, and that's why the objective evidence that we produced recognises it. And your colleagues, Auburn again at Para 104, the secure community environment, sense of independence can reduce social isolation, better fitness, healthier lifestyles. Reasonable survive these factors likely to result in a lower number of visits to the GP, reduced hospital admissions, overall savings to the NHS. And the inspector, your colleague, went on to attach significant weight to these social benefits. So in conclusion, they're very, very clear benefits. We would say, again, capable of being separate are the economic benefits, the employment benefits in terms of provisions. I don't understand the submission that we haven't been able to give evidence of full-time equivalent jobs. I mean, it is true that Miss Miles was a bit exhausted with my the question. We got there, but we got there in the end, and there's never been any challenge to our evidence on 50 full-time equivalent jobs by the local planning authority. It's a bit odd to find it now emerging only in closing. Again, I'm afraid just a reflection of a disappointing approach of the local planning authority, and one that doesn't bode well. Ms. Lambert is cheerleading you on, sir, to say, don't worry, nothing to worry about here. We'll get it right. You don't have to worry. Again, just judge the pudding and the figures and the attitude. This is not an authority looking or achieving, I don't know whether, as we can see with the local plan and their attitude to the points taken on this point, and the attitude that the planning officer would be giving evidence to you to say that this is harmful to the NHS, for example. Anyway, sir, paragraph on employment, there's a variety of occupation, most of whom that was established will be full-time jobs. And these are good jobs, and these are jobs that we are told by government that we should now be valuing much more, and this is to be welcomed. There is disappointing that the authority should seem to be suggesting that job creation is only important if you're in an area where there's a higher than average unemployment figure. That is disappointing, and no doubt disappointing to the people of Tunbridge Wells to hear that put as part of the council's case. Significant weight should be attached to these economic benefits of the development. And then turning to the environment biodiversity metric, I will not read first paragraph out because there's agreement of a 21% net gain above in excess of the policy requirement, and that is agreed to be significant. It's common ground that significant weight can be given to that basis. I hasten to add, just because it's common ground does not mean that the expert evidence that we gave to satisfy the council that a 21 net gain should then henceforth be looked at as having lesser weight. As I said before, in respect of Miss Venable's uncontested evidence in the other appeal, the fact that the planning authority is prepared to agree it indicates, particularly this authority, that our evidence is strong, not weak. In conclusion, having gone through all of that, and you've sat through all of this, sir, the next submission probably does sound a bit surprising, even to myself. Basic planning merits of the case are straightforward. When you come down to it, you'll make your decision, notwithstanding all the points. It's a case of need v harm. each attaching great weight to harms. It's the appellant's position that the scales are tipped firmly in favour of allowing the appeal. There is, in this case, though, a clear and demonstrable need for extra care dwelling, which is critical and will not be met by the existing pipeline and planned supply. There's little way, contrast, there is little in the way of harms arising from the proposal. While there's a clear spatial infringement of openness, you will have to give, as I said, substantial weight to that harm. The development is barely visible, has very, very limited zone of visual influence. And so I do say it is quite possible to add that limited actual harm to policy harm and still arrive with an overall conclusion, perfectly lawfully, that the overall harm is substantial. I mean, these judgments are broad brush judgments, and therefore substantial can accommodate it. The development would have a negligible impact on the setting and a neutral impact on the significance of the conservation area. They're both less than substantial and at the negligible end of the spectrum. Again, as policy, less than substantial weight in respect of the negligible end still attracts, in the case of Pembury Grange, great weight. But you'll have to weigh up how great that weight is in terms of how great that harm is to the asset, and we say it's negligible. So it's on the negligible end of great weight. The minimum 15-metre buffer has been agreed, and the appeal site is centrally located and designed to minimise impact on the area of outstanding natural beauty, of which it is not within. The implications of not proceeding with the appeal side of that, a critical unmet need for extra care will go unmet for many years to come. And you'll remember what Miss Venables said about this cohort of people. I mean, without being too brutal, many may not be able to benefit for all sorts of reasons from a development that is, that only comes forward in 10 years or even 5 years' time. They can't afford to delay. Conversely, allowing the appeal, the benefits to the NHS, ability to free up family homes, will also not be realised, as well as the jobs and other benefits that are agreed. Allowing the appeal will bring the site into a beneficial use, and significant benefits will flow from the scheme. So we're respectfully asking you, sir, we recognise it's in the green belt. Yes, of course we do. We always have. We recognise it's inappropriate development. Yes, we always have. We recognise that there's less than substantial harm. But so when you look at the context of this critical unmet need, you look at where the sites are or are not sites coming forward, you will see that this is actually a site that there's no question it can deliver relatively speedily. And in terms of harm, if you accept our evidence, there is relatively limited harm, albeit harm that for policy reasons you must give substantial weight to. And we do respectfully ask you to allow this appeal. Thank you very much, sir. I'm grateful for your patience.
Thank you, Mr. Jones. I trust there's no other matters that anybody wishes to bring to my attention.
No, thank you.
Are there any applications for costs?
No, thank you, sir.
Can I get? Can I just get on? I'm not muted.
You're not muted, Mr. Jones, no.
No, I'm not muted.
Don't say anything you don't want us to hear.
No. There was nothing. I'm just going to say no.
Okay.
But there are no further applications, and I don't think I'd be very popular if there were. But at this time, but no, sir.
Okay. Well, thank you very much. I'd just like to thank everyone for their contributions, and I'd like to thank particularly the local residents who've given evidence. I don't know if Mr. Hood is still with us, but thank you particularly to the residents who've gave evidence and contributed to the inquiry, and thank you to everyone else. I did say thank you to the town hall staff last week, and I think it was handled very well at the town hall. So thank you very much to them. And if there is nothing further from any of the advocates, I have now got everything I need. There's nothing outstanding, and I can close the inquiry.
Thank you, sir.
Thank you very much. Thank you very much. Have a good weekend and keep cool.
I will. Thank you.
Thank you very much.
Thank you very much, sir. Thank you.
Bye.